So good morning, everyone. My name is Mahlo. I'm the representative of the Claims Conference in Germany, and I have the honor and the pleasure to lead today's morning panel. I would like to start by thanking Mr. Stauber, thanking Sarah and Adi for the excellent organization of the conference, and as many in the auditorium, yes. Give a good hand. As we have heard from many people in the auditorium, also I have taken out many insights from the last 2 days. I'm really looking forward to learn more today. Yesterday we talked about the implementation of the Luxembourg Agreement and which consequences it had for the Israeli society, and further what the compensation did for the individual claimants, interestingly going into even changing their identity in a certain part. Today we will focus on the struggle for compensation and restitution of Jewish property. And when we talk about the struggle of compensation, we obviously are talking about the perspective of the victims' side on the so-called Wiedergutmachung. If we take a naive look at the theoretical overall picture, we would think to see matching intentions. On the one hand, there's the willingness to pay for damages, and on the other side, there's the willingness to file for compensation and restitution. However, from a victim side's perspective, the filing of compensation and restitution claims has heavily been perceived as a struggle, as many survivors had to fall back on the help of lawyers, for example. And this indicates a disconnect, a gap. And I hope that by lunchtime we will have answers to this question. In this matter, it might be also interesting to analyze whether the word Wiedergutmachung in itself has been made survivors more reluctant or hesitant to file for a claim for compensation. In any case, as we have also heard yesterday by Judge Porat, the word Wiedergutmachung has a repulsant meaning for Holocaust survivors and Jewish organizations, and the Claims Conference does not use this word. This also does not change if the etymology of the word Wiedergutmachung is explained, or if the user of the word attaches a different meaning to it. History has changed borders of countries. History has changed relationship of countries, and yes, history has changed also the connotation of words. And what has been used in the past has been used in the past, and that cannot be changed, but what we can change is obviously the future and the present. And so it is not without any reason that modern societies change words if they deem or feel that they are disrespectful or not inclusive enough for certain minorities. And the examples are obviously and manifolds. Our first lecturer today is Dr. Kim Wünschmann. She has taken a modern approach in her work to the Institute for History of German Jews in Hamburg by using the medium of graphic novels, as Art Spiegelman did very successfully in his comic Maus. A prominent German TV network, the NDR, Norddeutscher Rundfunk, once wrote about her. Dr. Wünschmann and her team are looking for new ways to make polyphonic Judaism audible and visible, whether in comics or digitally. The culture of remembrance must become younger. Ms. Wünschmann obtained her PhD from the University of London and subsequently held position at the Hebrew University of Jerusalem, the Center of German Jewish Studies at University of Sussex, and the LMU in Munich. Her research centers on Holocaust studies, European Jewish history, legal history, and comic studies. And her publication includes Before Auschwitz, Jewish Prisoners in the Pre-War Concentration Camps, published by Harvard University in 2015, and awarded the Yad Vashem International Book Prize for Holocaust Research. And co-written with Stephanie Fischer, The Forthcoming Oberbrechen, A German Village Confronts Its Nazi Past. Your lecture titles today The Luxembourg Agreement as a Comic, A Graphic History of Restitution and Compensation. And I'm very curious and to know, can you start your lecture and to learn about those aspects. Thank you.
Thank you very much for the kind introduction, and thanks to the organizers for inviting me to this conference, for the wonderful organization. It's a great pleasure. It's an honor to be here and contributing to this important gathering. What I will present to you today is a graphic history of restitution and compensation, and this graphic history is a collaborative project funded by the Volkswagen Foundation, conducted by Dr. Stephanie Fischer from the Center for Research on Antisemitism at Technical University Berlin and myself. Together with the Cape Town-based artist Liz Clark, we work on a visual history of the Holocaust and its aftermath, harnessing the potential of comics, the potential of visual storytelling for historical research and for education. We study Jewish, non-Jewish relations in the village of Oberbrechen during the 20th century. And here you can see a map from the comic that gives you a bit of geographical orientation where Oberbrechen is located. And you could also see how we work with historical photographs and incorporate them into our comic. We ask, how did Jews and Christians live together in this small town in Hesse in West Central Germany before 1933? And how did Nazism impact on the social fabric of the place, and how did it change after 1933? Who took part in anti-Jewish persecution? Who profited from expulsion, dispossession, and murder? The project does not stop in 1945. We explore post-Shoah relations between the Christian villagers who remained and the former Jewish neighbors who survived the Shoah in exile. What was at stake for those on either side as they re-established contact after 1945? What does this case study tell us about attempts to restore justice through reparations? Before I will take you deeper into the comic and discuss how microhistory matters when analyzing the processes, the complex processes of restitution and compensation, I would like to make some brief methodological remarks and address questions that some of you might have asked yourself and have in fact asked me since they saw the title of my presentation. And these questions may be similar to the ones posed in a very forceful manner to artist Art Spiegelman, whose two-part long comic Mouse many here in the audience will know. Why comics? Why mice? Why the Holocaust? Spiegelman's choice of medium comics has caused controversy since the work was first published in the 1980s, and it causes controversies until today. Many of you will remember that earlier this year, a school board in the McMinn County in the U.S. state of Tennessee has voted to remove the comic from its 8th grade curriculum because of depictions of violence, nudity, and foul language. Comic about the Holocaust. The debate about Mouse raises fundamental questions of representation, and in particular artistic and visual representations of the Holocaust. How do we deal with aesthetic representations, aesthetic expressions of painful histories? What is an adequate and what is a dignified way to speak about the Holocaust and the ongoing trauma that outlives the actual violent events in the post-war era? Think about the debates about filmic representation of the Holocaust, shuttling perhaps most vividly between the polar opposites of Spielberg's Schindler's List, which portrays so much, arguably too much, violent history, and Claude Lanzmann's Shoah, which strictly abstains from staging any historic images and remains in the present and in the abstract. Charles Friedlander, Hayden White, and others have explored these burning questions of representation already at a 1990 conference and a later volume aptly entitled Probing the Limits of Representation. In the wake of the linguistic turn, historians and other scholars reflect critically about their work and the various modes of historical emplotment. Some, like Richard Evans, have come out in defense of history, try to reconcile the discipline as a science, as an art, as a craft, with the postmodernist challenges. And the bottom line of these debates is that historians should know that they construct narrative and that their narratives can and perhaps should always be debated and disputed. So, why comics? Literary scholar and comics researcher Hilary Shute studied Spiegelman's work extensively. Here you can see the cover of her monograph Disaster Drawn. She also worked with Spiegelman on MetaMouse, that is the making of Mouse. And she compellingly answers this question, why comics, when she says, and I quote, "Mouse developed a unique idiom of representation." She places comics in a longer drawing to tell tradition, according to which experiences of war and violence found powerful expression in images, even if those images are very difficult to look at. Shute quotes Jacques Chalot's 17th century etching Les Grandes Misères de la Guerre and Francisco de Goya's etchings Desastres de la Guerra from the early 19th century as early examples of graphic testimony and this drawing to tell tradition. Nazi atrocities, as you know, were depicted in many images produced in the camps and ghettos, often in secret. As acts of self-assertion, these graphic testimonies were a way of coping with overwhelming experiences. As acts of resistance, they document crimes and they secure evidence. Just think of the 4 photographs from Auschwitz-Birkenau clandestinely produced by the Sonderkommando prisoners and, by the way, also visually quoted by Spiegelman in Mouse. I want to very, very briefly discuss some key features of comics and make you familiar with comic research, which is then helpful to understand how Stephanie Fischer and I construct our graphic history, and in particular, the chapters about Holocaust restitution and compensation. In comics, at first glance, the constructed nature of historical narrative is obvious. Hilary Shute states, and I quote, "Comics are evidently staged, built, made images of history. The hermeneutic act is ingrained in the very form of representation. Here we have a form that is constantly aware of its own mediation, linking documentation and testimony with artistic practices such as visual abstraction and drawn metaphor. At the same time, this is an intensely personal form of representing history. Secondly, we see whole pages at once. The reader can decide where to look first. They control the pace of reading, the direction of reading and viewing. And comics does transgress conventional understandings of chronology, linearity, causality. And this is why they are such a suiting medium for memory and testimony of violent pasts. There would be much more to say and to analyze, but I'll keep it short that we can go to the graphic history, as we chose of our medium to study Holocaust restitution and compensation in new ways, trying to find new approaches to a history so full of, as we've heard in the past days, contradiction, imposition, irritation, re-traumatization, issues of dignity and humanity, power politics, existential questions for the individual survivor, for the Jewish collective, and for the young state of Israel. So how can we draw and represent restitution and compensation? This post-genocidal history that is so heavily based in written sources, legal texts, official documents, memoirs, and at its core, the hundreds of thousands of personal files containing the negotiations of the survivor claimant with the German authorities. Quoting the few photographs of high political milestones, which are stored in our collective visual memory, is a starting point. And just as the organizers of this conference and also the producers of the film Reckonings, we used the famous photograph of the long table in that room in the Luxembourg town hall, on which Foreign Minister Charette, JCC President Nachum Goldmann, Chancellor Adenauer, surrounded by their respective delegations, signed the Luxembourg Agreement in September 1952. The drawing aims to represent an atmosphere that is very tensed. Not a word was spoken, silence surrounding the act of signing. And as you can see, the original black and white of the photograph has been colored, but the coloring remains very pale, perhaps in a sort of vintage style. Gray, black, brown, white are the dominant colors in these images. Even the flowers in the middle of the table look pale. Macro history is presented here in the most condensed and the most concise form, the image and the two text boxes. At the same time, it remains somewhat closed and perhaps even unapproachable. Is this a historic achievement? Is this a successful example of transitional justice? The serious-looking men in their dark suits do not appear to be celebratory. And what does this high political event even mean for the so-called ordinary people? Like other scholars have done before us, we contextualize the state-level decision, the diplomatic and the political history with individual lives. And here, let me take you to the case studies. One Jewish family from the village of Oberbrechen, the Liechtensteins, fled to Argentina in 1937. They settled in the Avigdor colony, established by the Jewish Colonization Association, the ICA, with about 100 families, mostly from Germany. You can see here, and perhaps my cursor works, that we place Siegfried and Flora Liechtenstein, our protagonists, into a heated discussion about how to react to compensation legislation. One thread of the panel number one, is therefore the discussion about the practicalities of restitution and compensation. What is it actually all about? How does it work? What can be done? We know from research that information and experiences were shared in the network of survivors. Recommendations for lawyers were given to friends and acquaintances. And this is what we try to depict in panel number one. The next panel number two, expresses the controversies. The woman says, "I'm not taking any blood money from the Germans, never." The man says, they call this Wiedergutmachung, making good again, as if. Our protagonists, Siegfried and Flora, remain silent in this panel. The sources do not allow us to place them on the spectrum of discussion, and I think we discussed yesterday about really the difficulty to extract from the files the motivation of the claimants. And this is what guided us here in the construction of this panel. We simply do not know what their motivation was. As Flora and Siegfried walk away from the group, they think, they say, they do things that we do know from the sources. And without having read the text, you can see that this bottom part of the page breaks away visually from the uniform grid. Most clearly visible is the way that the panel frames dissolve and the color scheme changes into a black and white scene. And here we link the past to the present and flash back to 1942, when Flora Liechtenstein's sister Irma Hess, who had fled to Belgium, was deported via Mechelen to Auschwitz-Birkenau, where she was murdered. A text box in the lower right-hand corner explains this. The absent, the lost, the pain, the murdered are thus visually present, and they were present, as we know, in the deliberations of the survivors on whether and how to claim compensation. And these claims could be a reason to reconnect to former Christian neighbors. We see Flora Liechtenstein in the lower left-hand corner writing, a letter that has been preserved in her compensation file. She's writing to a former neighbor asking for help and support in filing compensation. This correspondence is remarkable, as it shows how survivors could trust, could rely on former neighbors, and how they communicated about the Shoah at this very early stage. And here the contact with the old town was a positive one. The next page is our attempt to graphically depict what we all know is the most ambiguous dealing with German authorities in the process of restitution and compensation. We see Siegfried Lichtenstein, former cattle dealer from the village of Oberbrechen, in his battle with the authorities in West Germany, and we see him in the West German embassy in Buenos Aires. And we learn about the claim of his daughter, Irene, whose education was interrupted by Nazi persecution. So you can see on first glance, and this is what I meant with seeing comics all at once and deciding where to start reading, you can see that this page is heavily filled with written text, mirroring the text-laden source base. We decided to reproduce some of the documents, some of the sources here on the page, such as the correspondence of the compensation office in Wiesbaden with the mayor of Oberbrechen. And this correspondence shows the other side of involvement of former neighbors and Christian villagers. Asked whether he could confirm the survivors' claims, the mayor reports back, and I quote, "None of the local residents can provide the requested information. In my estimate, the income of S. Lichtenstein cannot have been very high given the circumstances in which he lived." End quote. The Germans at the local level were downplaying the damage of the former Jewish neighbors, forming a coalition of silence, building up resistance against confronting a violent past in which the villagers themselves were, of course, deeply implicated. What is more, with their behavior, they increased the pressure which put the persecuted in the most uncomfortable and impossible situation. We see here how Siegfried Lichtenstein was questioned at the West German embassy in Buenos Aires, and he defended his claims and made clear that the mayor was only a schoolboy when the family had to leave Germany. What could he really know? Another village authority was influential in the daughters, Irene Lichtenstein's claims, and this was the head teacher of the village school. He could testify on the anti-Semitic treatment that Irene had to suffer in school. And the last three panels depict her story. As the authorities doubted Irene's account, the head teacher's statement was vital for the compensation claim, but the fact that he had to be contacted several times, he didn't respond for a long time, also shows his hesitation, if not resistance on his part. And we end the page, you can see, by again intersecting micro and macro history. Irene Lenkiewicz's claim for compensation was approved only days before Mossad agents captured Eichmann in Buenos Aires. And here we link to another form of reckoning and post-genocidal justice. The re-traumatizing effects of filing for compensation are perhaps nowhere as drastic as in the medical reports, and this was also already mentioned during the conference, that those medical reports that the survivors had to submit to the German authorities. We treat this theme at the example of another former villager, Selma Altmann. Selma Altmann filed for compensation for damages to her health and then had to go an examination at a psychiatric hospital in Los Angeles where she lived at the time with her husband and her sister. It is actually, and quite remarkably, only through this source, only through this medical report that we know of the violent history in the village. There are no other sources that document it, showing you how vital it is to have this account, however difficult. Harassment and abuse, which we depict in the chapters on the Nazi period, brought back here in the form of flashbacks to again show that the past experiences of violence lived on and could lead to re-traumatization. We also show the German physician who reviewed his US-American colleagues' report and found, and this is in the thought bubble of this panel, I quote, "In Mrs. A's case, no illness can be found that stands in causal connection to her persecution," end quote. My last example concerns restitution, and here we can learn about the Christian villagers who had acquired possessions of their former Jewish neighbors. In the US-American zone of occupation, as you know, legislation was passed as early as 1947 to restore property forcefully taken from Jews. We see here a couple who had bought the house of the Stern family in Oberbrechen, receiving the official letter from the authorities to report the property. In order to keep the house, they decide to plea with the surviving members of the Stern family. First and foremost, their youngest son Hermann, who had left the village already before World War I and immigrated to the US for economic reasons. The case is interesting in several respects. First, as we can see here, this Christian couple seeks help from the Catholic priest of the village. Another important authority in the village community, apart from the mayor and the head teacher, the Catholic priest agrees to support them. He writes on the letter that is then sent to the authorities and also sent to the Stern family, and this is in the compensation files, in the restitution files as well. So Stern, who had lost two brothers in the Holocaust, decides that property restitution is less important to him than securing the memory of his family members who are buried in the local Jewish cemetery. Remarkably, but this would be a whole another story, as the sources tell us, he strikes a deal with those Christian owners of the house on his own terms, does not claim back the family home, but asks them to take care of the graves at the Jewish cemetery. To conclude, the three case studies of restitution and compensation, the Lichtensteins in Argentina, Selma Altman and Hermann Stern in the US, have shown a variety of individual experiences and agency in dealing with restitution and compensation claims. They visualize attempts at post-war reckonings, and they demonstrate that restitution and compensation was not just a bureaucratic process when narrowing the scale of observation to the micro level. Reparations emerge as an intimate social history in which members of the local communities had to position themselves. The comic genre gives room for discussion of emotions, expressed with the help of a broad set of visual techniques. Drawing flashbacks to a violent past shows that there can be no closure with history. On the contrary, these traumatic experiences live on, and they can trigger anew when confronting German authorities and former neighbors. This, we would claim, is one of our strongest contributions to historiography, to show and to visualize what we think of as the aftermath is in itself a history of violence. Thus, again, and here come back to the features of comics, questioning conventional narratives of causality, chronology, and linearity. As a new form of abuse, compensation and restitution was experienced by the survivors and was experienced as traumatic by the survivors, and for a long time, perhaps until today, ignored by those on the non-Jewish side. As we have seen when discussing Holocaust comics such as Maus, the specific visual grammar of comics allows for this unique form of representation of this very troubled and complicated past. At the same time, we can hope to use comics to make it accessible to a broader audience and to carry this history into the future. Thank you very much.
So, Ms. Wünschmann, thank you very much for your highly interesting lecture that approached us also to the question why the comic has a real value added. different levels. And also one other takeaway that I took was the idea of that the aftermath is also a history of violence. So there is not only the word struggling in the context of a relationship of the survivors toward the German bureaucracy, or a struggle, an internal struggle for the survivor, but also a struggle, let's say, with his path in, as you very well described, in the little town or village he came from, and the social struggle he had in order to get documents, for example. Yeah. So a different form of struggle is that the survivors were trying to get back their property and businesses. And our next presenter is Dr. Ingo Loose. He will concentrate on the aspect on how German restitution organization or institutions were handling cases in which a survivor and an Aryanizers put in a claim for the same property or business. Dr. Loose obtained his PhD in 2005 on German banks in occupied Poland from 1933 to 1945. From 2000 until 2010, he was a lecturer at the Humboldt University, and since 2010, he is a researcher at the Leibniz Institute of Contemporary History. His fields of research are the history of Jews in Poland and Russia, Soviet Union in the 19th and 20th century, Yiddish literature, Nazi occupation policy in East and Central Europe, and the economic history of the Third Reich. He is lecturing today about the equalization of burdens versus restitution, post-war battles between Jewish survivors on the Holocaust and former Aryanizers, some case studies from Lower Silesia, 1936 to 1978. I would like to Mr. Loose, Dr. Loose, to come up to the floor and give his presentation.
Yeah, good morning, everybody. First of all, thank you for the kind introduction, and thank you to a warm thank you to the organizers and the entire staff of the conference for the kind invitation to Tel Aviv and to Israel, and for the excellent organization of everything about this illuminating conference. The following thoughts I would like to share with you are very much a work in progress, since it is sort of a byproduct of a bigger project on the history of Jewish entrepreneurs in Breslau and Lower Silesia from the 1920s to the Holocaust. And this focuses mainly on economic counter-strategies of these businessmen and women against increasing political pressure after 1933. But in the end, all of them fell victim either to bankruptcy and liquidation or to Aryanizations. And in using the term Aryanization, I hope you will always hear the quotation marks I've here in my manuscript. Many of these Silesian Jews did not succeed in leaving the Reich and were finally deported and murdered in the Holocaust. But this also includes the topic what had been left of the significant economic share in property of the Jewish community in Breslau after the Shoah and the Second World War. And this brings me directly to some questions closely linked to this conference, namely to the Equalization of Burdens law in German LAG of August 1952 that we have discussed already yesterday evening. And yesterday, Ambassador Avital spoke of a patchwork of totally different forms of compensations. And if you recall the diagram of numerous different programs of compensations Kim Wambach displayed in his presentation, the LIG is only one tiny chapter in this entire structure from 1952 until now. On the issue as such, Iris Nahum is undoubtedly the much better expert than I am, and for that reason I'm extremely grateful for her paper yesterday and the clarifications of the complicated legal structures. As you will see, this is pretty much a grassroots history, but nevertheless an integral part of the entire compensation process, which includes not only big politics, but also the lower levels of administration, which had to put political decisions and laws into practice in the first place. In recent years, the German debates on the Holocaust, as well as on the Third Reich and its aftermath, have been increasingly often linked with and expressed in terms of economic origin. In the last, say, 15 to 20 years, we have seen a large number of publications about Aryanizations and Aryanizers in several cities of the Reich, who in the second half of the 30s unlawfully took over Jewish property, businesses of Jewish owners, etc. However, little attention has been paid in this context to Aryanizers who, after 1945, or rather 1952, claimed lost property in the former East German, now Polish or Czech territories. In fact, a lot more countries were involved wherever a German and a German Jewish minority had lived before the Second World War, but for now let's keep things simple. In Germany, the political debates of the last few decades dealing with the expulsion of several millions of ethnic Germans from Central Eastern Europe in the years following the end of the Second World War almost entirely omitted the fact that after Berlin and Frankfurt on Main, namely Breslau was the hometown for the third biggest Jewish community with more than 20,000 members in the German Reich in 1933. In 1937, still almost 17,000 members of the community still lived in the city, which means that in the years before, the emigration rate of Breslau had remained far below the average throughout the German Reich. In May 1937, local NSDAP party sources spoke of about 2,000 Jewish shops and businesses in Breslau alone, which seems to be a more or less realistic figure. Nevertheless, by the end of 1938, the vast majority of these businesses had been already shut down in one or another way. So shortly after the November pogroms, and I tend to use the plural, not the singular, November pogroms, Jewish economic life in Breslau vanished almost entirely. I mention these figures here for one purpose, because in a moment I will have a look on the dimensions of the equalization of burden procedures and of the decisions made in favor of Jews on the basis of the LAG. So for Jewish survivors from the Reich, from Breslau in this case, the starting point was that they were often, to a minor degree, interested in any form of compensation as far as it was perceived as a merely humiliating German goodwill payment. We had that since the very first day of our conference. All the more promising was the opportunity of the equalization of burden since 1952 to claim what had been robbed during the Aryanizations. With all justification, Jews from the former German territories in Central Eastern Europe felt themselves as the first expellees from these territories, in a certain sense even as double expellees from these lands that is fully entitled to take part in this form of restitution. Since the LAG was designed to integrate German expellees into the West German population and therefore to provide them with sort of a seed capital, it took 4 more years until the end of 1956 when the 11th Ordinance on compensation payments under the Equalization of Burdens law was passed and Jewish claimants as so-called fictional expellees were entitled to claim their lost property within the framework of the LAG law. Nota bene provided they could prove first that they were victims of Aryanization, which often turned out to be quite difficult, and second, they could prove their cultural and linguistic connections to German culture, or at least, as it was done later on, at least German citizenship. In the case of the lost territories in the East, one may assume that many of the Aryanizers successfully settled their claim because West German administration dealing with the execution of the Equalization of Burdens law was hardly able to conduct thorough research about the circumstances of individual ethnic German expellees, since most of the documentation had been destroyed in the war or become inaccessible beyond the Iron Curtain. But what happened if there were Jewish survivors, or close relatives, rightful heirs, etc., who were the legitimate owners of the Aryanized businesses or real estate and now too became claimants to the same companies or businesses? Those who had benefited from the persecution of the Jews in the late 30s were obviously aware that conflicts between Aryanizers and Jewish survivors would arise as soon as the political talks between the State of Israel, the Jewish Claims Conference, and the FRG had begun that finally led to the Luxembourg Agreement. For example, after 1952, an association of so-called loyal buyers of Jewish property was formed in Berlin, whose exact activities can no longer be constructed in detail, but they obviously pursued the goal of securing the possessions of Aryanizers against potential Jewish competitors who, in fact, from 1956 on, began to participate in the equalization of burdens. What happened in these cases of conflict? Which compensation office processed the applications initially depended on the applicant's place of residence, with those who lived abroad being taken on by special compensation offices. And as soon as the authorities noticed that there were two applications for one and the same property or business, the case of the applicant living in Germany, which means normally the Aryanizer, was normally handed over to the office that processed the case of the Jewish survivor. However, cases in which it turned out that several people had submitted applications for the same object could also show that the Jewish owners had several heirs, distant relatives, distant family branches, etc. So it did not always have to be the Aryanizer who made a burden equalization procedure lengthy and complicated. Naturally, the question of verification of economical and historical details in the former German territories of expulsion turned out to be particularly difficult, because in many cases the documents that could have proven the loss and damage simply no longer existed. And this was even more true for Holocaust survivors living, for instance, in Australia and being forced to provide documents from the archives. A major problem for the Equalization Office was the question on which basis the information could be verified, because there were no historians in the offices, and research on the persecution of the Jews, Aryanizations, and the Holocaust was still in its infancy. With regard to individual cases from Breslau, I must now admit that I have changed a bit my mind. First, I planned to present some examples of quite different Jewish companies from Breslau, which became the subject of conflict between Jewish owners and Aryanizers. But instead of that, and with regard to the limited time at my disposal, I will rather try to give sort of a typology of the cases I found. What did they have in common? Of course, the question arises as to whether the ethnic Germans who were expelled from the homeland were given preference over the Jewish claimants. Because of the length of the procedure and the constant need to send new documents, many Jews got the strong impression that an attempt was being made to delay their applications. And indeed, the proceedings were not a place for special empathy, sympathy, sorrow, or at least understanding for the fate of the survivors. If you disregard the bone-dry official language of the correspondences, then I cannot claim for the files I've gone through that the concerns of the Jewish owners and their heirs were not taken seriously, or that they were even deliberately delayed or complicated. On the contrary, in the majority of cases, these applications from Jewish claimants immediately led to the assumption of a history of persecution, even if the survivors were unable, for the time being or even later on, to produce any supporting documents. And this can also be learned from the angry letters from the former Aryanizers, who were already sure of their compensation payments and whose cases had now been stopped for the time being or even turned down completely. But of course, this very much depended on the personnel involved, and there were also highly outrageous cases in which Jewish lawyers had to intervene when even the dumbest lies of an Aryanizer remained unnoticed or allegedly unnoticed. What repeatedly caused considerable difficulties for Jewish applicants was the fact that Aryanizations showed a very wide range, and that the rule of thumb that sales under pressure had only occurred in 1938 and later on had many exceptions. Some of the cases already involved forced sales already in 1935. Or in 1936, which nevertheless were also regarded as Aryanizations by the equalization offices, if the purchaser had not paid, for instance, sort of a goodwill. And this was also the case, for example, when Jewish trading companies had only supplied state customers and authorities and were now on the brink of ruin very quickly after 1933. Of crucial importance was always the question whether the Jewish owner received the money from the sale in the late 30s, from the sale of his businesses at his free disposal and not in a blocked account, etc. In the case of previously constructed tax debits, a very well-known strategy from Nazi authorities, to push forward the process of Aryanizations, or if the money had been paid in full as Reich flight tax, it was generally assumed that free disposal was out of question. Problems of proving the circumstances, postal communication across the globe took months. Receiving certificates of inheritances took years. And the authorities stood between, in a certain sense, between hammer and anvil, that is, in the middle of the battle of correspondence between Jewish claimants and the Aryanizers. The results of all this was a catastrophically long duration until payment finally was made. On average, this was not a question of some years, of several years, but in many cases of several decades. An interesting by-aspect of this totally inadequate duration was that the sum finally paid to the Jewish claimants consisted, as a rule, of a smaller part for the mere loss of robbed property and a bigger part of accumulated interest due to the length of the procedure. At the very start of my research, I would have guessed that the equalization offices tended to decide mainly in favor of the ethnic German claimants and against the Jewish former owners. But are there any hints in the LAG files to assume that the Aryanizers were trusted more often than the Jewish survivors? On the basis of my files from Breslau, I would say that this point was at least not significant enough to be visible. But this does not mean that there was no distrust, just that the forms do not provide reliable information about this. And therefore, what should be more intensively taken into account in scholarship is a problem which I would call the credibility of victims. For trials against perpetrators of the Holocaust before West German courts, Katharina Stengel has recently published depressing results on exactly this constantly questions credibility of Jewish, especially Eastern European witnesses and survivors. And I wonder whether comparable issues shouldn't also be examined more closely for the LAG and, of course, mutatis mutandis also for the VG procedures. And if you allow me a short digression at this point, I remind you that after 2002, thousands of applications for ghetto pensions were rejected by the German pension insurance with largely completely absurd and historically incorrect reasons. The same thing then happened again on the lower level of the social courts, and it took many years before the Federal Social Court in Kassel made two fundamental decisions, and later the Bundestag put an end to this with an amendment. I worked for a number of years as an expert witness for ghetto pension proceedings, and a rejection rate for over 90%. can hardly be explained other than by administrative behavior affected by anti-Semitism. So if you think that there was sort of a learning process, if you might call it, in between the 50s and the years following 2002, I'm quite a pessimist, I must say. Coming back to the LAG cases, all these typologies are inevitably linked to the question about how representative these data can be. And of course, there is no final certainty about this. But since we are dealing with the third largest Jewish community in Germany before the Holocaust, these are somewhat more than just isolated cases. One of the biggest questions still open is about the amount of profiteers, about the peculiar situation in West Germany during the 50s, and of the opportunities the LAG offered to former Aryanizers. Of course, we can add as many case studies as only possible, but it would be more interesting, as far as I can see, to know to what extent the LAG was misused by Aryanizers, and to what extent Jewish Holocaust survivors were excluded from payments because they did not fit into the narrow scheme of what the law defined as being of German descent, that is Germanness, or in Germany, Volkszugehörigkeit. This is, of course, an important point Iris Nahum already made yesterday evening. For instance, I'm, for the time being, unable to say how many Jewish businessmen in Silesia who survived the Holocaust were later excluded from the LAG procedures because they had been Polish, not German citizens, which in the German East was quite common. And I remind you that even in the second half of the 30s, more than 40,000 Jews with Polish citizenship still lived in the German Reich. Since I can omit some aspects after the presentations yesterday evening, please follow me for a while, so to speak, to the basement or the workshop of such research. If we try to draw a reliable picture of the dimension of this sort of bitter competition between Jewish survivors and the Aryanizers, we cannot avoid doing scholarship in Bayreuth, namely in the branch of the Federal Archives of Germany, where the entire material of these 3 million LAG files are kept in the Lastenausgleichsarchiv. These holdings, although a treasure trove by itself, are a good example that in contemporary history our main problem is often not a lack of material, but on the contrary, that there are kilometers on the shelves without a clue where to start. There were, and for scholars still are, 3 substantial problems. First, how to identify a business being formerly Jewish property. Aryanization most often meant renaming the business. Just to give one example, after the forced sale of the pharmacy of Samuel Pincus in Breslau, it rebranded at once at Gutenberg Pharmacy. In many cases, the reference German, as in German Women's Coat Factory, for instance, or German Hardware Factory, or something like that, can already be a first indication of possible Aryanizations. What is needed now is a more or less complete database of Jewish enterprises in order to identify what was looted and taken over by the Nazis during the 30s. Then you have to go through the entire commercial register in the years following 1938 in order to collect further data of the already Aryanized businesses. Second, the main and crucial question was whether there were any Jewish survivors or family members who had emigrated or fled earlier and who now were able and entitled to claim what had been robbed and stolen from them. Indeed, there were few cases that only Jewish claimants filed their claim, while there was no corresponding application by the Aryanizer. Maybe because he perished in the war or for other reasons. Whether in individual cases, perhaps also out of bad conscience, we will never know. In most of these cases, with only a Jewish claimant, the business in question had been totally destroyed in the November pogroms and never sold but only shut down. The third crucial problem is the aforementioned fact that all these claims were linked to a territory that was no longer part of Germany, but now found itself within the borders of communist Poland, or the Czechoslovakia, and so on. This harshly limited the options to obtain reliable information from the land register or commercial registers. In my database on Jewish-owned businesses in the broadest sense of the word, I could identify slightly more than 2,000 entries in Breslau alone for the years following 1933, and statistics of the Breslau Trade Chamber mentioned for the entire year of 1938 only 77 applications for Aryanization, in contrast to round about 700 applications for new openings and additional 600 applications for purchase of non-Jewish owned companies. Altogether, in November 1938, there were still 288 Jewish businesses in Breslau, of whom 280 were liquidated, and only 8 were Aryanized until the end of the year. Now, looking into the files of the Federal Archives in Bayreuth, I was able to identify at least 40 to 50 cases and applications in which former Jewish entrepreneurs collided with German claimants in the context of the LAG procedures. If we take the aforementioned 85 cases, which were mentioned by official sources for 1937 and 1938, 40 to 50 applicants after 1952 who, to put it bluntly, tried to cheat the German authorities about allegedly not having profiteered from the Aryanizations, give an enormous percentage. A percentage which might be even higher with regard to a possible dark figure of cases which I simply did not find for the aforementioned reasons in the archive. In contrast to that, I should add and emphasize that I've come across not a single case in which a Jewish applicant deliberately provided false information about his claim. To conclude with, looking at these cases of Jewish and non-Jewish opponents struggling for the same piece of property, we nevertheless should not forget that the LAG was primarily designed to integrate the expellees from the East into West German society. So there is no wonder that this law was maybe not the best instrument for Jewish claimants who normally, but not in all cases, lived abroad. For them too, compensation payments were urgently needed to build up a new life abroad, namely here in Israel, the UK, in the USA or Australia, which comprises the majority of my cases. However, the question is how an alternative could have looked like that would have been able, in an even better way, to help the Jews to their rights and to justice. The entire topic seems to be a long-gone story, something for the historians, if you might say, but the entire process of Wiedergutmachung without any doubt had groundbreaking long-term effects, notwithstanding all the shortcomings of the compensation for Holocaust survivors and of the BEG and LAG procedures in particular. How explosive the question of compensation can be for bilateral relations can currently be observed in Poland after the government made demands of 1.3 trillion euros on Germany. This is, of course, a topic on its own, but I wanted to present you only a small facet on the micro level in order to underline that big politics are one thing, but the results are inevitably dependent on the cooperation and day-to-day actions of administration at the micro level. For the historians, this means that there must be more quantitative research into the Mars files, because otherwise numerous interesting questions would remain unanswered, be it about compensations or about social history of the Federal Republic of Germany, of the State of Israel, and for the entire group of Holocaust survivors. Thank you for your attention.
Dr. Loose, thank you very much for your very insightful typology. Also striving the points of procedures regarding the length of the process and the economic outcome, that the interest of what has been paid was always much higher than the value of the business itself. And also thank you very much for also pointing out the, let's say, ideas of the credibility of victims, the point of credibility of victims, and the burden of proof, as well as the fact that the research is pretty difficult. And you mentioned the renaming of the businesses, for example, that really makes the burden much harder to go into more and more accurate research. In the next lecture, we'll focus more on the macro level. Rachel Blumenthal will compare how Germany and Austria dealt with their past. Rachel Blumenthal is a fellow of the Institute of Contemporary Jewry in the Hebrew University. She researches the cataclysmic consequences of the Second World War. She was awarded a PhD degree by the Hebrew University for her thesis on the Claims Conference, the State of Israel and the Diaspora from 1951 to 1964, and holds an LLM from Tel Aviv University. In August 2021, Lexington Books published her book Right to Reparations, the Claims Conference and the Holocaust Survivors from 1951 to 1964. The Leo Baeck Institute in New York awarded her the Westheimer Fellowship in 2022, and she is now researching on Austrian model of restorative justice. Relating to your provocative title, All the Austrians Went Away with Murder, I look forward to the different levels your lecture will touch, and please come up to the stage.
Okay, so thank you very much to Professor Stauber for organizing the conference and to the committee for inviting me to talk. Thank you very much to Adi and Sarah for organizing everything. And thank you to the sponsors, of course, especially the Claims Conference. Okay. I wanted to say at the beginning something about this building, because this building is now called the Museum of the Jewish People, but it was originally the Museum of the Jewish Diaspora. It was envisaged by Nachum Goldman. Nachum Goldman thought it was very important to teach Israelis about the diaspora, and the Claims Conference funded the building, and so it's very appropriate that we have this conference in this building. And now to my subject about Austria. So, annexed Austria and Austrians played the same role as Germany and Germans in the robbery and murder of Jews in the Second World War. Pictures like this, I don't think you have anything similar in Germany. The violence in Austria was far greater than in Germany. Okay. So Vienna was the, Austrians were 10% of the entire population of Greater Germany, but they filled almost 10%, almost half the senior positions in the Holocaust command structure. And there were lawyers. It's important for those of us who are lawyers to remember that lawyers do terrible things. So there was Seitz Inquart and Otto Wächter, who were lawyers and took a very active part in the Holocaust. Austria, Vienna, before the Second World War, there were 200,000 Jews, mainly in Vienna. Vienna was one of the first cities that was declared Judenrein. Adolf Eichmann set up his central office for Jewish emigration on August the 26th, 1938. And within a year, 126,445 Jews had emigrated after being stripped of their citizenship and all their property. In the years 1941 to 1944, 65,000 Jews were deported to the east, very few returned, and only 6,000 members of the original community remained in Austria during the war. This is 3%. The Jewish demands for restitution did not distinguish between Jews from Austria or Jews from Germany. The basis was the persecution, not the country of origin. So in one of the first demands, which was, I'm sure we all know, drafted by Shalom Adler-Rudel, who was the director of the Central British Fund for German Jews, which is now the World Jewish Relief. He talked about the basis of the claim being property that had been stolen from Jews both in Germany and in Austria. But in practice, there was a huge difference. And in this talk, I want to explain why I think this difference occurred, and I want to put forward 5 separate explanations. So the first explanation was the German refusal to pay compensation to Austrian victims. Protocol 1 to the Luxembourg Agreement laid down the ground rules on compensation for Hitler's victims. Its provisions were the basis for the federal law on compensation of victims of National Socialist persecution, the BEG. Under the BEG, survivors who belong, we've heard about this, who belong to the German field of culture, language and culture, were eligible to benefits under the law. But this did not apply to Austrian Jews. Austrian Jews did speak German. Many of them were part of this Schiller and Goethe, but they were excluded from the law. The Claims Conference went back to the Germans and said, this is not acceptable. And the Germans said, the Austrian Jews should go to their own government. We're not going to pay anything to Austrian Jews. So this is one explanation. The second explanation is the question of who were the true victims. So in Germany, you have a transition from the Weimar Republic to the National Socialist regime, which was very quick and complete. The Weimar Republic existed for 15 years. On January the 30th, 1933, President Hindenburg appointed Hitler as Chancellor, and then in March, Hitler passes the Ermächtigungsgesetz, the enablement law, and that's the end of democracy and the beginning of the Third Reich. So the result is that victims are people persecuted by the National Socialists. This is clear to everyone. When you're talking about victims, you know that there are people who were persecuted by the National Socialists. And it's true that for a long time, many groups were excluded from the BEG, from any form of compensation. But still, there is this understanding that victims are victims of National Socialism. In Austria, things were much more complicated. So in Austria, there was a sort of very gradual transition from democracy to National Socialism. You have, at the beginning, the rump state, which emerged from the First World War and the Treaty of Saint-Germain, with the constitution by Hans Kelsen. And in 1933, you have Chancellor Engelbert Dollfuss, who comes to power, and Dollfuss is not a Democrat. He dissolves the parliament, and he replaces it with a fascist regime. This is Austro-fascism, and he chases after the communists, but he doesn't want to annex Austria to Germany because he needs loans in order to finance the Austrian state. And so in the following year, you have National Socialists who assassinate Dollfuss, and he's replaced by Schuschnigg, and Schuschnigg executes some of the National Socialists who he executes who had assassinated Dollfuss, and then you have, in 1938, of course, you have the Anschluss. So at the end of the war, you have three separate groups claiming that they were the true victims. You have the communists who were persecuted by Dollfuss. You have the National Socialists who were persecuted by Schuschnigg, and then you have the Jews who are persecuted by everyone. So this is reflected in the Austrian social security laws. So Austria passes laws very quickly at the end of the war. You have the Victims' Welfare Act, which is called the Opferfürsorgegesetz, which was enacted in July 1945, and it provided food, clothing, pensions, and assistance in finding work to victims of fascism. But this category was limited to resistance fighters and individuals who had been persecuted on political grounds. Of course, this excluded Jews because they were deemed to be persecuted on racial grounds. In 1947, the Victims' Welfare Act was revised, and now it was extended to victims of racial and religious persecution. In theory, Jews should have been now entitled to victim indemnification papers, financial assistance with a small annual tax credit, but not to a pension. But in practice, this didn't work. Why didn't it work? Because a prerequisite was that you had to have Austrian citizenship, and all the Jews lost their citizenship before the war, and it was not restored after the war. So the result was that only a tiny minority of Jews who chose to remain or resettle in Austria were entitled to social benefits. In the words of Elizabeth Anthony, who has written a recent book about the return of Jews to Vienna after the war, Austrian Jews could be victims as Austrians, but not as Jews. And so now I move on to the third explanation, and this is about restitution. According to Gestapo records, the value of Aryanized property in Austria was $1.2 billion, and this estimation was certainly too low. Restitution took a very different path in West Germany and in Austria. And the reason for this, I'm going to put forward 3 points. One, the different legal definition of the status of West Germany or Germany and Austria. Two, the activities of the Jewish organizations in the two different countries. And three, the location of Jewish assets in Austria and in Germany. So at the beginning, you have the definition of Austria as liberated, not occupied. And this was a serious obstacle to Jewish attempts to obtain redress for Jewish losses. The basis, of course, we all know, was the Moscow Declaration from 1943, which mistakenly stated that Austria was the first free country to fall victim to Hitlerite aggression. And as a result, the Soviet occupying power allowed Karl Renner, a social democrat, to set up a provisional state government in Vienna on April the 27th, 1945. So this is before the end of the war. And subsequently, he was appointed by the State Council to be the president, and you have elections. And so Austria has this legitimacy in the eyes of the Allied and a large degree of autonomy. And the result was that Austria laid down the ground rules on restitution. And of course, this contrasts with Germany, where the occupying forces, they were the ones who laid down the rules, because Germany was occupied, it wasn't liberated. Jewish organizations such as the Joint and the World Jewish Congress were very active in Germany, in occupied Germany at the end of the war. They lobbied the occupiers for restitution, and as a result, the US military government, and someone has mentioned this already, passed the Law 59 on November the 10th, 1947, and the purpose was to effect, to the largest extent possible, the speedy restitution of identifiable property to persons wrongly deprived of it in the years 1933 to 1945. And moreover, this law established the concept of a successor organization. Again, this was thanks to the Jewish lobbying. And the idea was that if you have property that had been Aryanized and the owners had been murdered and there were no heirs, the successor organization would step into the shoes of the original owners and they would claim and receive the property. And what they then did was that they sold it and divided it up between the Joint and Israel. In Austria, the Jewish organizations were much less active, and the result was there was no parallel Law 59, and there was no recognition in Austria of a successor organization. And a third important impediment to restitution was the Soviet control of Vienna. So most Jewish property in Austria was located in Vienna. And of course, the Russians, the Soviets, were not very keen on restoring property to private owners. According to Robert Knight, for the communists, the seizure and nationalization of Reich German capital was of more importance than the restoration of Jewish property. In other zones of Austria, which were controlled by the Western powers, there was very little Jewish property. It wasn't like in Germany where the property was spread, the communities were spread all over Germany and the assets were spread all over Germany. So the result was that if you have all the property in one place and that one place is under Soviet control, it's very difficult to obtain restitution. And now to my next point about the parties to the negotiation. So we all know that the Luxembourg Treaty was negotiated by three parties. You have Israel, you have the Claims Conference, and you have West Germany. But in Austria, the question of who represents the Jews was very problematic. Israel did not take part in the negotiations. At the top, there's a newspaper clipping, which there was no actual decision of the former Israeli Foreign Ministry, we are not going to take part, but Israel decided that they were not going to have any claims against Austria. And this clearly weakened the Jewish claim. The result was that instead of a state, you have only an organization. You have the Claims Conference, which is now renamed itself to call itself the Committee of Jewish Claims on Austria in New York, together with the Federation of Jewish Communities in Austria, and they established the Joint Executive Board for Jewish Claims on Austria. They like these very long names, and they presented themselves as the spokesman at the talks, but the Austrians didn't recognize them. So at the beginning, you have Dr. Klein of the Finance Ministry, who said that he was willing to hear the Jewish delegation, but he was not willing to negotiate with them as an equal partner. And so this refusal reflects the way that Austrians dealt, the problematic way that they dealt with their past. And another important difference is the attitude of the politicians. So Adenauer believed strongly in the need for reaching a settlement. And he initiated, after he was prompted by Goldman and by Israel, he initiated the negotiations, and when the negotiations broke down and Goldman went to Rundhoff and persuaded him to resume the negotiations, Adenauer overruled his financial people, Schäfer and Abs, and he persuaded them, he insisted that they reach an agreement. And in Austria, the leaders continued to make openly anti-Semitic statements after the war. So Karl Renner set the tone when in a cabinet meeting held on May the 10th, this is 2 days after the end of the war, 1945, on what they call Aryanizing inverted commas in the original, he said that a law would be passed on restitution, but added compensation of every little Jewish merchant or peddler for his loss was inconceivable. In August, Renner informed the cabinet that we were punished enough, we bear no responsibility. And later, Minister of Finance, Dr. Reinhard Keimetz, member of the SPÖ, the Socialist Party, explained that payment of any kind of restitution was out of the question because Austria did not cause any damage and therefore was not obliged to pay any kind of reparation. So you have this very legalistic, formal argument. There's no Austria, so Austria is not obliged to pay any compensation. Leopold Fiegel, who replaced Renner as Chancellor, argued that only a small number of Austrian Jews were murdered. In his words, the biggest Juden massacre only began in 1942, and by then our Jews were gone. Miraculously, usually with some luggage, a ship's ticket and 200 Reichsmark. So this is very important to notice the difference between the politicians' attitude in Germany and Austria. And now to my last point, which is about the tactics. So my argument is that there were the Austrian procrastination, and Austria argued that it was too poor to pay compensation, and these were important factors in the outcome. So negotiations started. In Germany, you have negotiations which start in March and end in September. This is 6 months, and you reach a more or less some sort of settlement. In Austria, negotiations start in the following year, in July 1953, and they continually break down, they start again, they break down, and as I said, the Austrians didn't really want to talk to the Jews, and in the end, it's the Allies behind the scenes who put pressure on the Austrians to provide some sort of solution. And so in 1956, the Austrians reached a partial settlement, and in 1961 they reached another settlement. So negotiations lasted from 1953 to 1961. This is 8 years, and as a lawyer, you know that the longer the negotiations, usually the worse the outcome, and this was definitely the case in the case of Austria. And at the outset, Julius Raab, who was the chancellor at the time, talked about the difficult financial and political situation of Austria. Austria, not the Jews, was to be pitied. And now to the outcome. So a memo of the Council of Jews from Austria and Israel dated August 1961 stated, "Keiner von uns ist mit dem Erreichten zufrieden." None of us are happy with the results. On January 1956, you have it, this is in Hebrew and German. So in January 1956, the Austrians set up one fund. It was 550 million shillings, which was approximately $22 million. It was a help fund. It wasn't reparations, and a small percentage of the victims, mainly people over the age of 60, received sums of between $800 to $1,000, $1,200. This is one-time payments. That's all they received. And then Austria set up a second fund with this very long, complicated name. This time they had $6 million. They set aside $6 million. So the total sum was $28 million. And I mean, this is incomparable to the sums that Germany paid. On restitution, Austria settled claims for 4,000 properties for a sum of 83 million shillings, 80% to Glaubensjuden. But most of the properties that were returned were in a very dilapidated condition. And what the few people who managed to get their properties back, what they did, and there are books about this, Frussi and Rothschild, they sold them for pennies. And you have these beautiful buildings now in Vienna, which a lot of them have been restored, but they had belonged to the Jews, and the government acquired them for pennies. And as to other assets, almost nothing was returned. I was in Vienna in the summer, and I walked past. There's a pharmacy, an apotheker. My grandmother was a pharmacist, and it says she has this description where she talks about the fact that her pharmacy was Aryanizers and then was restored. So it's still very much alive in Austria. On the other hand, you have this picture from the Klimt. There's a frieze, and in 2015, the Austrians, it had belonged to Jews. It was plundered. It was acquired by the Austrians in the 1950s, and then the Jewish owners applied to have it restored, and the government said they didn't think it was appropriate. So now to my conclusion. So a Jew from Vienna and a Jew from Berlin who underwent the same nightmare during the Third Reich: expropriation of property, loss of citizenship, incarceration, starvation, and forced labor, were entitled to very different remedies. And the Austrian model of justice compared unfavorably to the tripartite Luxembourg agreement. And the title of my talk is not something I invented. I took it from Maurice Buchstein, who was the legal counsel to the Claims Conference, and he talked about the Austrians getting away with murder, which I like because it has a double meaning. And so a comparison between Germany and Austria highlights very different treatment. In West Germany, restitution was the rule. In Austria, the exception, and the government refused to recognize the rights of Jewish organizations to heirless property. In Austria, compensation was presented as charity. Professor Goschler's talked about charity. It was always charity in Austria, not justice, and only the neediest received very small sums from the help funds. Research, and so Austria was not the only country that behaved in this way. I mean, there were lots of countries who profited from the Nazi regime and the Nazi era. And for instance, Holland, people who plundered property in Holland, again, remained the owners at the expense of the original Jewish owners. And so that is why I think it's very important to analyze each country, each place separately. Like the Holocaust didn't happen, it wasn't one single event, it was lots and lots of separate events. The restitution and compensation, again, was lots and lots of different cases, and it's very important to research them. So thank you very much.
So Dr. Blumenthal, you really made a compulsive case for continuing research about it. It is something that is obviously shocking when we hear this. You talked about the Klimt. The Klimt will be also part of our, let's say, will be part of our next lecture. The next lecture will be touched, not really in a sense, but it will be touched the aspect of looted art, but not in Austria, more in Israel. And as it is largely known, the topic of looted art is an open topic still. It's a current topic. It's a pressuring topic, not only in Germany, but also in many other European countries and the US. It is one of the areas in which Nazi injustice perpetuates still today. And the presentation that we will hear in a moment from Dr. Kochavi will focus on Israel's perspective on Nazi looted art. Dr. Kochavi received her PhD from the University of Leeds and holds an MA in History and Business of Art and Collection from the Institut d'études supérieures des arts in Paris, and a second MA in Law and Studies from Bar-Ilan University in Israel. Her professional experience includes curatorial positions at the Magnus Collection of Jewish Art and Life at UC Berkeley, where she has been involved in the curation of exhibitions and research of Jewish artifacts in the Contemporary Jewish Museum in San Francisco. Prior to her curatorial work, Dr. Kochavi filled positions at the Contemporary Art and Antique Galleries in Israel and the UK, as well as at Christie's Auction House. And between 2010 and 2014, she worked as a provenance researcher at the Company for Location and Restitution of Holocaust Victim Assets in Israel. The title of her lecture is The Art Restitution and National Responsibility, Israel's Shifting Policy Towards Nazi Looted Art. Dr. Kochavi, please take the floor.
Allow me to begin, like my fellow speakers, by thanking the conference organizers, Professor Stauber, the Claims Conference. I'm delighted to be here and honored to speak to this distinguished guest list. And since our time is short, I'll jump straight into it. In 1998, members of the Israeli delegation to the Washington Conference on Nazi Confiscated Art opened their statement by making it clear that the State of Israel, the Jewish state, sees itself as the central representative of the survivors and their offspring, and is dedicated to achieving justice on their behalf and to the remembrance of the Holocaust. Thus stressing that Israel remains consistent with the post-war attitude as the main country in place that stands for Holocaust victims and survivors and Holocaust remembrers. In late 1930s, when news of the Nazi regime's organized destruction of European Jewry began arriving into Palestine, several key members of the Yishuv identified it as a crucial moment to save Jewish life and culture. In this presentation, I will try to briefly focus on the moral issues and legislation surrounding the restitution of Jewish cultural objects after the founding of the State of Israel. Many of the items shipped to Israel were titled heirless, indicating that their pre-war owners were unidentified, unknown, or haven't been found yet. These images that you see here are all, as you see on the bottom, from the data bank of the central collecting point in Munich. What was in Munich? Since the time is limited, I only chose a few key examples to represent the transition taking place in Israeli society from the moment the state identified itself as the rightful heir to Holocaust victims' assets to the reinterpretation of the concept of restitution and addressing the need for individual restitution to the rightful heirs of the victims. By the end of World War II, as the Allied forces continuously discovered caches of confiscated cultural property, a need to make urgent decisions about the property's future led to the founding of a successor organization, the Jewish Restitution Successor Organization, which you see on the top here. The organization was later joined by a second organization set up in order to handle Jewish cultural objects, the Jewish Cultural Reconstruction. The two organizations signed an agreement in August 1947 in which the JCR, the Jewish Cultural Reconstruction, agreed to act as the agent of the Jewish Restitution Successor Organization in tracing, restituting, and allocating Jewish books, Jewish ceremonial objects, and other Jewish cultural property found primarily in the United States occupied zone in Germany. An important part of the decision-making was made with the help of various experts who were called by these organizations to join the monuments, fine art, and archives men and women, which some of you probably heard of, in the process of identification of the properties discovered and determining their future. Of these experts who arrived from Israel are, for example, philosopher and historian Gershom Scholem, who was sent on behalf of the National Library of Israel, and Mordechai Narkis, head of the National B'Tzalel Museum in Jerusalem, the predecessor of the Israel Museum. Narkis ended up being responsible for the shipping of Jewish ritual objects and works of art that later made their way to synagogues, memorial sites, and museums, primarily B'Tzalel, in Israel. In many of his letters, Narkis described the conditions in which he was working at the central collecting points and the intense feelings he experienced when coming across the various types of objects. And here I put a short quote in English and Hebrew. I'll just read the English part. "My heart is bleeding and I am working. Everything that has been collected here at the Wiesbaden Museum is only a fragment of what the despicable took from Hungary, as I see it. And everything is counted in thousands and shows the state of our culture. The few objects removed from Germany were shuttered with hammers, and those were the most beautiful and ancient of the pieces." Narkis also mentioned the moral obligation he felt compelled to fulfill, as many others did at the time, while seeing Israel as the main heir to the unclaimed or heirless property of Holocaust victims. The devastating situation in Europe at the end of the war also brought other museum representatives from Israel to visit main European cities. These visits were mostly aimed at trying to collect and bring back with them to Israel remnants of pre-war Jewish life and testimonies of the destruction of European Jewry. Thus, for example, Chaim Gamzo, director of the Tel Aviv Museum of Art at the time, Chaim Atal, director of the Ein Harod Museum of Art, and Narkis all found themselves scrambling for funds to purchase various artworks that were put on sale on Paris auction houses whose pre-war owners were unknown. Miriam Novich, one of the founders of the Ghetto Fighters House Museum and Archive, also made efforts to connect with artists who survived the Holocaust for donations of their works to the museum, for example. In 1957, Narkis passed away unexpectedly, and less than a decade later, in 1965, the Israel Museum opened its doors. At the time, the entire collection from the B'Tzalel Museum was making its way to become part of the new national institution. By 1965, a few of the heirless works of art were restituted to heirs who made efforts to contact the German Restitution Office, the Jewish Restitution Successor Organization, and the Jewish Cultural Reconstruction offices in Frankfurt and New York. Jewish cultural reconstruction personnel had a difficult time trying to identify the items requested. However, the process, even for the few works that were restituted, was slow, unorganized, and eventually led to very, very little success and mostly frustration. Despite several international efforts that took place from the 1950s on the protection of property during war, it was only during the 1990s, after the end of the Cold War, the publication of research on Nazi-looted art, and the class lawsuits that took place in American courts against Swiss banks and European insurance companies that international conferences began discussing the issue of restitution of Nazi-looted art. In 1998, more than 40 governments, as well as cultural institutions, sent representatives to the Washington Conference on Holocaust-era assets that concluded with publishing a list of 11 principles. Here they are. The principles offer a process that aims at identifying the heirs and reaching a fair and just solution. They include, for example, stages in which research and resources are necessary, as well as a database and the publication of research information. Like other treaties and conference resolution, the Washington Principles are non-binding concepts, which were agreed upon by the conference participants and signatories. As such, only a few countries have proven to actively implement them into their national legal processes. Several following conferences expressed support of the Washington Principles. The Vilnius Forum Declaration of 2000, which opens by requesting governments to undertake every reasonable effort to achieve the restitution of cultural assets looted during the Holocaust era to the original owners or their heirs. In 2003, the European Parliament stressed this even further, and in 2009, the Terezin Conference Declaration reiterated the Washington Principles and specifically governments' responsibility to reach fair and just solutions. And of course, it goes on. In 2018, the conference titled 20 Years to the Washington Principles took place in Berlin. Afterwards, a joint declaration by the federal German government and the United States government was issued, reinforcing the country's commitment to follow the Washington Principles. And at the same year, a conference took place in Jerusalem that issued another declaration that called museums to identify Nazi-looted art in the collections and for countries and museums to make a firm commitment to take the appropriate legal steps to return the works of art to their rightful owners when claims of restitution are filed. The statement also addresses commemoration and education. We believe that this approach can help in education about and commemoration of the Holocaust, and tell the story of the destruction of the cultural life of the Jewish people perpetrated by the Nazis. 5 countries implemented the Washington Principles by establishing national commissions to research works of art in public and national collections and provide a mechanism to facilitate restitution: Austria, Germany, France, the Netherlands, and the United Kingdom. And I'm not going to expand on them because I have no time. Back in Israel, the Israel Museum is the only national art museum in Israel. The museum was opened in May 1965 to the public, and at the time inherited the B'Tselem Museum collection that included, as I said, several hundreds of heirless works of art that arrived in Israel in the early 1950s, originally from central collecting points. The Jewish Cultural Reconstruction Policy called for the redistribution of Jewish cultural items as following: 40% went to Israel, 40% went to the United States, and the remaining 20% was divided between Jewish communities in the Western Hemisphere. The majority of objects arrived in Israel were essentially put in storage, while a few were sold or even exchanged locally. In 1965, upon the museum's grand opening, there was actually no formal legislation that focused on art institutions and museums in Israel. To give an example, the Museums Law, which defines museums, collections, and describes their responsibilities and functions, was only legislated in 1983. The law has no descriptive reference to research, display, or collecting due diligence. It does state, as I quoted here, the museum management is obligated to conserve artifacts, care for them, and display them to the public appropriately, register, describe, and photograph every item in the collection, provide the public with information about the items in the museum, publish catalogs and other publication. The museum, the Israel Museum that is, made a significant shift towards the display and publication of information about what became known as the YRSO, or JRSO, Jewish Restitution Success Organization collection, when in 2007, its website was first shared with the public. The following year, in 2000, and this is the example of what the website looks like today, and it's a searchable website. I invite you all to log in and do a search for yourselves. The following year, in 2008, the Israel Museum in Jerusalem opened 2 exhibitions: orphaned art, looted art from the Holocaust in the Israel Museum, and looking for owners, custody, research, and restitution of art stolen in France during World War II. A collaboration with the French government, which made a significant turning point in the public discussion on the topic and on Israel's responsibility towards the heirs and the expected role it plays in Nazi-looted art restitution. The exhibition's opening was accompanied by a two-day conference called Justice Matters. As a condition to the loan, France demanded certain securities to prevent objects from potentially being seized in Israel. In response to France's demand, Israel passed in 2007 the Loan of Cultural Properties Jurisdiction Restriction Law, which enables the loan of cultural objects of public interest without causing damage to the rights of the Jewish people to objects confiscated during the Holocaust. This essentially means that Israeli courts have no authority in such cases, and any claim will be processed in the country that gave the items on loan, thus making sure the objects would be returned to their country of origin once the exhibition concluded. This legislation was not created in a void. It was a direct result of the restitution case regarding the Egon Schiele painting, Portrait of Wally, that took place in New York in the early 2000s after the work was given on loan by the Leopold Museum in Vienna to the MoMA in 1997, and another interesting case that I will not expand on. Although this legislation caused much criticism in Israeli society, by passing this law, Israel did join other countries, like, for example, the United Kingdom, who the same year passed a similar law in order to enable an exhibition of French paintings from Russian collections to the Royal Academy. Since then, the Israel Museum has been the main cultural organization in Israel that has been known to conduct provenance research, and it publishes information about restituted works of art from the collection. I will only note that among the items that entered the museum collection in the 1950s are also Jewish ritual items, some of which are still being contested today by heirs and re-established Jewish community. The decade of the 2000s can be described as a period of transition in terms of Israel's own responsibility towards restitution of Nazi-looted art and other properties. In 2000, a parliamentary legislative committee led by Knesset member Colette Vital, who was here and hopefully might still be here, was established. In 2004, the committee published its findings in a report that led in 2006 to the legislation of the Assets Law, or in its full name, the Holocaust Victims Assets Law, Restitution to Heirs and Dedication for Assistance and Commemoration. The law designated an external organization, the Company for Location and Restitution of Holocaust Victims' Assets, to be set up for the purpose of locating properties in Israel belonging to Holocaust victims, identifying their heirs, and performing restitution. Properties whose owners remained unidentified were transferred to provide assistance to living Holocaust survivors in Israel, and the remainder was donated for educational and commemorative purposes. As part of its responsibilities, the company was to independently initiate and conduct research on various types of property, initially on immovable property such as bank accounts, plots of lands, etc., and it also developed into research on art and cultural properties. As part of this effort, and in order to raise awareness to the topic, the company organized 2 conferences focused on cultural property located in Israel in 2014 and in 2015. Following the company's work and with its support, in 2014, the Israel office of ICOM is the International Council of Museums, conducted a roundtable meeting that published its conclusions online. Unfortunately, since then, very little has been done, and very little follow-up has been done by the Israeli ICOM leadership. I will just remind us that ICOM is an organization which encourages museums to join and participate in the promotion of partnerships, knowledge, and engage in a dialogue. It, however, can't legally enforce its decisions. In 1986, ICOM published this first code of ethics, which was updated in 2006. And these are just a couple of quotes that address provenance research. One of the highlights of the 2015 conference organized by the Company of Location and Restitution of Holocaust Victims' Assets was the identification of a Nazi-looted artwork in the collection of the Ein Chorod Museum of Art. The Beggar, which you see here, by Polish-Jewish artist Eugene Zak, was discovered to have been looted from a Jewish family in Paris. Following this case, 3 works of art, a painting, and 2 17th century tapestries have also been identified in the Tel Aviv Museum of Art and restituted to the heirs of Rudolf Moser. a prominent Jewish publisher from Berlin who amassed a comprehensive personal collection. And similar to the Ein-Harod Museum case, this research was also, and the discovery was also done by an external researcher and an external organization to the cultural institution in which the works of art exist, or existed at the time. In 2021, the Israeli Ministry of Justice, along with the Ministry of Culture and Sport and the Office of Social Justice, led an online conference on Nazi-looted art provenance research in Israel. At the conference, several participants called for the urgent need for Israel to take responsibility, as it often expects of other countries, and to act on the matter promptly, thus ensuring that Nazi-looted cultural items located in Israel will be identified, researched, and restituted. A year later, an update on the work of the working group was shared with the conference participants and explained a few setbacks that were taking place in the process. Despite that, several cultural institutions are expressing interest in conducting provenance research on items in their collections, but there is yet a lot to be done. So to conclude, since the 2000s, there's been a shift in opinion. From a moral perspective, identifying Israel as the rightful heir towards supporting the rights of individual heirs. A legal framework, however, supporting these rights at the moment is virtually not existent in Israel. In practice, cultural institutions are yet to have dedicated funded provenance research position. Thus, those who are conducting such research often do it voluntarily. Public-facing databases, which are few, aren't being regularly updated, thus making it impossible for researchers and potential claimants to have updated information available. There is no central database and no indication in terms of either the relevant archival where the relevant archival materials are available for researchers, at museums or any other cultural institutions, and of any collections that actually need to be investigated. In addition, there is an ongoing public debate on the question whether Israel should remain the so-called rightful heir to the heirless object or not, a view that relies on circumstances taking place over 70 years ago and hardly represents the situation today, as several heirs have been successful in restituting objects that belonged to their ancestors before the war worldwide. We must maybe ask ourselves at this moment in time, what will happen in the near future and what can be done? Where does Israel stand in terms of restitution? What policies could assist in creating a formal restitution process, since the informal one has had very limited success so far? Should the government be involved, and to what capacity? The Company for Location and Restitution of Holocaust Victims' Assets has been closed since 2017, and the responsibility over the remaining assets was taken over by the custodian of absentee properties under the Ministry of Justice. Is Israel prepared to set up a national spoliation committee, as in the Netherlands, the United Kingdom, Austria, Germany, and France? How would it be funded? Who would be sitting on such a committee, and how could they enforce their decisions? These are all questions that should be addressed promptly by cultural and government leaders, as the generation of Holocaust survivors departs this world, and we remain responsible to correct the injustices of the past and to return the heirs their family heirlooms, giving them the opportunity to fulfill and conclude their ancestors' last wills. Thank you.
Thank you, Dr. Kochavi. It was really an excellent historical background that you gave on this topic. You very well described the beginnings in which Israel was seen as a saver of Jewish heritage and culture, and so that everything had to be brought into the state of Israel. Even my work today, if it's not although it's not concerning looted art, but it's concerning, for example, properties, they have in Germany, the Jewish communities have written in their books a claim, let's say that if there will be no Jewish life in Germany, the property will fall to one of the restitution organizations, for example. And so that was also, I think, the idea in the beginning, and then you really describes the shift happening over the Washington Principle, the informal processes, and now the question in formalizing a process with a law, for example, which really reminds me of many other countries in which the same path happened with an informal process, and now the question about a more formal framework. So with that, I think we will pass to the question and answer. Please, if you could come up to the stage and have a seat, and let's collect some questions. I think we'll have a microphone ready here.
Thank you so much for these very interesting presentations. My question goes out to Rachel. I would be interested, is there any kind of the slightest difference when it comes to the different parties in Austria? So, I mean, you know the situation in Germany. The Social Democrats supported the compensation talks. They even saved it in the end, if you look at the ratification process to a certain extent, and nobody should underestimate the role of Jakob Altmaier. But in this case, if you look at the Austrians, if we look at Figl, if we look at Raab, but also at the Social Democrats, not only the Christian Democrats, not only the Volkspartei or the Christian Social Party, there have been clear anti-Semitic strains, I would say, within the parties. On the one hand, and on the other hand, those people dealing with it, like Raab and Figl, they have been either in the concentration camps or fiercely being persecuted and opposed to the Nazi regime. So what role does that actually play? Is that, I mean, if he's saying we have suffered enough, one would dispute that and would push that away. But I mean, this is, there's, let's say, a little grain, I wouldn't say of truth in it, but of course, out of his personal perspective, and this is the perspective we would have to see, this is not totally to be pushed away. So I would like to ask you, is this like notion, that the fact that they have been under heavy persecution and that they have been like, I mean, if you look at Figl, I think it was 5 years in either Flossenburg, Dachau, and in the end in Mauthausen. So I think this is an example where I would love you to elaborate a little bit more on this, let's say, personal, emotional, whatever side you might call. And the other question goes a little bit to you. Drawing a line between the two presentations, could you elaborate a little bit also on, let's say, the reluctance for a long time on the side of Austria to deal with these restitutions? And also, I think, I don't know if you can describe this to be a special case, Austria, but maybe you can elaborate on this a little bit more.
Very good. I think you're over there.
Thank you. Thank you for a really fascinating panel. And I have a question for three of you. First of all, Kim, really congratulate you on this project. I hope it's going to be a bestseller and you'll be able to afford buy a flat in Hamburg because of that. But I also ask myself, would you regard that as history? Because one of the things, and I think we kind of discussed that also over the 3 days, is, you know, history writing is also about maintaining and sustaining the complexity, the ambiguous. And I had the feeling that this type of representation very much, you know, it evaporates. It's not there. It's not there in the same form, just because of the way it's been represented. And you also ended your presentation with a very, very strong statement about kind of echoing very much Christian Prus' kind of concept of the kleine Krieg gegen die Opfer, which is, again, very problematic also for, I assume, for a lot of people who sit here, who actually all the time we now, in many ways, kind of emphasize the ambiguity and the complexity of this process of restitution. And, you know, this type of question also have implication to other process of restitution, reparation, was nothing to do with the Holocaust, yeah? And which also, for instance, bring me to the question as to whether the applicants for the equalization law, would you kind of include them in this kind of type of exercising of violence? which brings me to the second presentation by Ingo Loose, really kind of fascinating. And I would like to ask you about actually the name, because we talked a lot about Wiedergutmachung. So actually, why did they have, was there any discussion about how to call this type of legislation, and why Wiedergutmachung was not applied to this type of compensation? Yeah. And my understanding also of this legislation, that it's a type of a solidarity legislation. So and I know just very little about this history of this legislation, but if I remember correctly, Jewish organization all the time protested against this legislation because it involved paying taxes to fund this type of, to create the fund to compensate these people. And one of the ways to tax these people was to, put extra tax on property that Jews actually were, were able to reclaim, and now they were actually asked to pay tax to kind of fund other types of compensation. And last but not least, to your presentation, I think it's very much you invited this question because you talked very much about a very certain type of looted kind of cultural assets. And of course, being in Israel, you have to ask yourself, what about the looted kind of other assets of, the context of the Palestinian looted cultural assets? How all that kind of relate to this conflict?
Nothing behind. I think let's go.
Okay, because this is a conference that is focused on the Luxembourg agreements, I just want to make two short comments in regard to Dr. Kohavi's presentation. The first is that the date in which Israel started to change its views really was the Vilnius International Forum on Holocaust-era cultural assets. In the year 2000, the Israelis were represented by a delegation led by Colette Avital, which insisted that all heirless, unclaimed property should come to Israel. This was something which Stuart Eisenstadt, on behalf of the United States and the French representatives, would not stand. And the discussion went until 2 or 3 in the morning. And eventually what emerged was a statement in the Vilnius Declaration that recognizing that, yes, this is the property of the Jewish people, but how it should be handled is a matter which needs to be taken up separately in each case. The second thing is in regard to 2007, I believe it is, when there was this exhibition from France on à qui appartiennent ces peintures, to whom do these paintings belong. The claims conference was consulted on that legislation. And my recall of this is that what we said very specifically was that the Ministry of Foreign Affairs, or another part of the government, needs to certify that indeed the process in the sending country is indeed sufficient for this purpose. In France at the time, you could get compensation, but you could not get restitution. I do not know whether that was actually ever carried out by the Ministry of Foreign Affairs or others, I think not. And it was therefore just a sort of perfunctory thing, saying that, well, we have good relations with France and therefore it's fine. But these are two sort of political aspects of what you're discussing.
I have a comment and a question for Ingo Loose. In your fascinating paper, you raised the question of whether ethnic Germans were given preference to Jewish claimants under the LAG, under the Equalization of Burdens law, and by studying cases from Breslau, you reached the conclusion that no, ethnic Germans were not given preference to Jewish claimants. I studied the cases from Sudetenland. I reached a different conclusion, namely that ethnic Germans claimants were given preference simply because of the fact that they met the clerks at the compensation offices directly and could convince them of their story. But this is not my point here. My point is that in order to get a full picture of compensation under the Equalization of Burdens law, you just need collaboration between historians. You need good database from the archives. And I'm happy to say that the current head of the Equalization of Burdens archive, the Lastenausgleichsarchiv in Bayreuth, Mr. Kühnel, is very supportive of this kind of research, and he tries to push forward creations of new databases. Now, regarding my question, and here I'm asking you as an expert of Aryanization and persecution in Breslau and in Silesia in general, by studying the files from the Equalization of Burdens law, did you find new knowledge in these files? Do these files provide new information on Aryanization and on the persecution? Do these files add to your knowledge on the years before 1945?
Okay, I have two questions. One is echoing Gideon's first question is for Kim. It's more basic than this. Could you clarify a little bit what kind of book this is? Because is this a mouse and meta-mouse together in a sense of the Luxembourg Agreement or not? Like just to have this a sense of the book really and what is coming. And then for Rachel, you mentioned of course the very important decision of Israel to not be involved, and I couldn't help but think about this 13-volume edition of documents on Israeli-Austrian relations and in general by Steininger. I wanted to ask you more about that aspect of your research. So to what extent will you cover that as well? Thank you.
Hi. I have a few questions. The first one for Kim is, what age group, who is the audience for the book? And is there some kind of teacher's guide, or if it's meant for schools, how does that work? The question that I have for Rachel is, afterwards, the way many Austrian Jews now get a pension is through the Social Security, which is a total legal fiction because it presumes that they paid in for Social Security and they're getting out, which they kind of paid in because they were little children and didn't work. So who made that legal fiction to be able to give, and what was sort of the background to that? And my last question is for Shira. The Austrian Jewish community, when it thought it would not exist anymore, gave all its community archives to the 1700s to the State of Israel. Then when the community was vibrant, it wanted them back, and the Israeli Supreme Court said, go take a running leap, you're never getting it back. How does that fit into the whole concept of Israel thinks, it's a repository of anything, and when someone wants it back, it does or doesn't give it?
Thanks. I have just two quick background information I wanted to share with everybody. I agree what you said, that in Austria, those measures are rather considered charity than justice. The fact that we, the claims currents, mainly negotiate and speak to the Ministry of Social Affairs in Austria clearly proves that. But we are in a process of also addressing the Ministry of Finance to make that point clear, that from our point of view, we do not fully agree to that fact. One remark you made, I cannot fully subscribe to. You said that the negotiations commenced in 1953 and ended in 1961. I can assure you and everybody here that from our point of view, those negotiations have not ended yet. They are still in progress. And what my colleague already mentioned, to me as an Austrian citizen also it struck me always very much the fact that the politician, the second Chancellor Fiegel, a person who has spent years and years in concentration camps alongside Jewish victims, can have made such a comment is more than absurd. So that's really that absolutely illustrates the thinking, the political thinking of that time. And you would probably mention it anyway, but even the coalition partners back then, Social Democratic parties, we know from transcripts of parliamentary discussions that there was a common sense that they wanted to drag on those discussions, drag on things. That was a common understanding between political parties back then. And a short question at the end, because in the beginning you clearly rightly mentioned that from an Allied point of view, Austria was the first victim. You referred to the Moscow Declaration. Everybody will be aware there was also a second part of that declaration that reminded Austria of its responsibility and of its own participation, which Austria could not await. That was the quote. And he also said that another reason why restitution was handled differently is that most former Jewish assets were located in Soviet-controlled western part of Austria, as you said. It's true on the one hand, but Vienna, like Berlin, of course, was divided into 4 zones. Nevertheless, the majority of Jewish population lived in areas that were controlled by Soviet forces. But what was the real effect of that fact that in the 2nd and 20th district in Vienna, most Jewish assets were located, controlled by Soviets? What real effect did that have on those procedures in the end?
Question?
Thank you. I would just like to, my name is Eleanor. I act as an external advisor to an intergovernmental team on provenance research, Holocaust-era provenance research legislation of the Israeli government. And I just want to add the last slide in Shir's presentation. We are at the very, very final stages of a draft of a law that will provide governmental funding for Holocaust-era provenance research in Israeli museums. I hope that we will have a Knesset and then we can move forward our draft as soon as possible, but we're in the complete final stages after having long conversations with the different countries and the different entities and thinking what would suit Israel best, because it's not a simple situation here. First of all, morally, Israel is not a perpetrator. It didn't exist during the war, and also the main issue or the main problem that we have in Israel is that museums are private entities. They're not national museums. They're not owned by the state, and so we have a different type of law that we have to administer. Sorry. Is not owned by the state. No, it's owned by a foundation. It's partly funded by the state, very, very partially funded by the state. It's owned by a foundation. And so that's a very big issue because it's a complete different set of laws that we can administer on provenance research. But we are happy to announce that it's going to happen very, very soon, and the museums are aware of this and are happy with this. So is, of course, the Ministry of Culture, who is part of the process. So I really hope that Israel can be a good example of provenance research and that we can bring this chapter to a nice ending.
Final question?
Well, as an Israeli citizen and taxpayer, sometimes you have to believe in wonders to be a realist. Don't know if you can be a model in Israel. It took 70 years, so I don't know if this is model-wise. But still, coming back to the panel and the question, it was a great panel. Great to hear after Karen's really important question about teaching material, Kim, with the book by himself. Did you compare, I mean, the market now sees more and more, like the one about Anne Frank, which I bought just recently, about the one We Survived, also which came out in Germany and some others. Is there any larger movement of taking those books? I'm reading comics since I'm 4, even today, and I know how they work on children or don't work on children. So is there a bigger movement between you and the others maybe, or within the Institut für Geschichte der Deutschen Juden in Hamburg am Schlump, to develop an approach that those books will be readable for kids in school or wherever they are in the age of TikTok and others? My question to Rachel. Rachel, thank you for the presentation, which I think is important. But right now, there's in Austria a big controversy about Simon Wiesenthal's famous statements, which, by the way, I'm adhere to it, that there were more Austrian procentual participating in the murder than the procentual within the Deutsche Reich. Are you aware of this? And how come you still come to the conclusion, no, there's now a controversy? There were two studies coming out, one in Graz by a guy Bauer and also Perz and Radkolb, who are not so friendly to Jews, what I believe, who also support the same claim against Simon Wiesenthal. Are you aware of this, and which material you maybe have found to show that it's different? And to the panel about Breslau and Schlesien, are you also aware that there are materials like, for example, the semi-complete library of the Theologischen Seminar in Breslau, which does not belong to industry, but it's a very important cultural matter, which is sort of rotting in the cellars of the Jewish community of Basel and Zurich, not because they're bad guys, because the communities, the IGB and the ICZ, simply have no funds to really take care about it. And the other part who went to Mexico, who is lost, nobody knows where it is. Are you aware of more examples like this coming out of the region you were researching? Thank you very much.
I think we go one by one. Regarding the question, who wants to start? Kim, Moshir?
Yeah, I can start. Thank you very much for these very, very important questions. Starting with Gideon. Whether we succeed to bring out complexity and ambiguity, I think is first of all for the reviewers to say. I can assure you that Stephanie Fischer and I try very much. And our decision to use comics as the medium is very much driven by our conviction that it is suitable to bring out complexity and ambiguity. Comics is, and this answers also some of the other questions, is not about simplification. It's not about simplifying history. It's not about, we shouldn't step into the trap of thinking, here we have a medium, it's very accessible, we can attract young readers and achieve that this is easy to consume. It is in itself a medium that requires a lot of pre-knowledge, reading texts and images at the same time. So one of the things that we do, and this answers also Avi's question, is we're very much engaged in a group of historians from memorial sites, but also from research, who reflect on how can we use comics in education. I talk to teachers. I teach history at the university, so my students will be future history teachers in schools. And I always tell them that you have to know what you want to do with comics. Don't just use it because you think it's easy and it saves you time. Once you make the decision for the medium, pay attention to what the potential is, but also what it demands of the readers, and go into that. So yeah, I think we'll see how it will be received. The question about the book itself is very important because it comes out in a series which is called Graphic Histories by OUP. And this is a series that is tailored first and foremost to US American college students. And the idea behind it is to teach history students how we use primary sources and how we construct narrative from primary sources. So it's a four-part book. We have about 80 pages of comics. We then have a second part, which is historical context. This is your classic academic text with footnotes and everything, where we put what you see in the comic in a larger perspective and also reflect about the potential of microhistory and what it can tell us about history on a macro level. The third part is the primary sources themselves. So there will be reproductions for students to read. In this chapter, excerpts from compensation and restitution files, because we want to create transparency and we want to make visible how we use the primary sources for the comics. And the fourth part is the meta level. So there's a making of, which we conduct as an interview with Jay Geller, our colleague, and
Deborah Pomerantz, who was our research assistant. So to bring in a conversation of 4 questions about what motivated us to do this, what is the intersection also of the personal and the scholarly, to make transparent the challenges, the difficulties, and to practice reflexive approaches to history. So very important, I think, is for scholars to constantly reflect what they're doing and how do they make their choices and how do they choose their sources and their topics and their approaches. So this is all part of the making of. So it's a 4-part book by the press, tailored in the first instance to US American college students, but hopefully arriving at a larger audience. Yeah, I think that's from my side.
Okay, so to the question about the different Austrian parties, Karl Renner was a socialist. So there were degrees of anti-Semitism. There weren't Philo-Semitism in any of the parties. No one's mentioned yet Kreisky, but Kreisky was not only socialist, he was Jewish, and it didn't make any difference. Spiegel is very strange because you're right, he went through concentration camps and it made no difference to the way he saw Jews. He made there are lots of anti-Semitic statements that he made. It made no difference. And to Lorena about Israel and Austrian relations, the Luxembourg Agreement was the exception, the only case where Israel actually got involved in claiming reparations. And the rule was that Israel didn't get involved. Israel had its own foreign policy, which was dictated by the state, the needs of the state, and not by the past. There's no explanation of why Israel took this position, which is very strange in my opinion. But this was sort of the general approach. So, in that sense, it makes But I don't. Even if you look, there are no documents which explain it. And everyone knew that it was a fiction, that Austria not really liberated. Everyone knew it was a fiction. And yet it's very strange, the complete differentiation that people make between Austria and Germany. Nachum Goldman was very opposed to Jewish DPs staying in Germany after the war. But this didn't apply to Austria. The Austrians made sure the DPs didn't. But Nachum Goldman went on holidays in Austria after the war, so it's not clear to me. Karen, I don't know when it started. I don't think it's really part of compensation. Germany also had this pension system where you could buy into the system and then get a German pension. I don't really think it was part of Holocaust compensation. But you're right, I have to find out when it started. I know that there was a situation like that. And Marcus, about Vienna. You're right, of course, Vienna was divided into 4. The Soviets, though, were by far the most powerful influence. The Americans and the English were very worried about Austria joining the Soviet bloc, and so they didn't want to rock the boat. Maybe if the Americans had got to Vienna first, it would have been easier to restore property. But because the Soviets were there, and the only thing that the Americans and English were worried about was that they shouldn't join the Soviet bloc, the Jews lost out. And did I miss someone? No? Avi? Yeah. You said about the discussion. All the, I don't know. Stephen Bella, all the authorities say that the Austrians killed much more than their relative share in the German population in very high-ranking positions in the Holocaust administration. And I have no reason to doubt that.
Thank you.
Yeah, thank you for the question, which were shorter than my answer should be, at least. Starting with the equalizations in the framework of Wiedergutmachung, as far as I think in the first place, we should see the equalization of burdens law not in terms of Wiedergutmachung we are discussing here in the last years, but mainly or primarily as a means of integration of post-war German population in the first years of the Federal Republic of Germany. Introducing this law in August 1952 was not primarily designed with Jewish survivors or former Jewish owners of property in mind, but nevertheless as a means of integrating different groups of post-war population in Western Germany. So this is, of course, maybe the main point. And as Iris mentioned yesterday, Jewish institutions were not involved in introducing and passing the Equalization of Burdens law. Of course, the restitution of property was an integral part of the agreement in September 1952. But how to do that, how to bring this into life and practice, of course, was up to the Germans. So. And this is why there was sort of retardation until 1956, when really Jewish claimants were able to take part. But this, of course, you're totally right. This came at a cost. In the literal sense of the word. That looking at the files and looking at this tremendous duration of the whole proceedings, paying taxes at the very end of the procedure was not the biggest problem. So it's, of course, it's illogical, it's a pity, it's a scandal, no doubt. But for the claimants, and very often after 25, 35 years even, it was normally the children, the heirs in general, who held up the procedures. Paying taxes for the final sum was, at least on the basis of the files I've gone through, the minor problem. That there are different pictures about how the equalization offices dealt with the claimants. This is, of course, very important, and this, of course, cries for demands for comparing approaches to the anti-stuff. The problem is, of course, that the equalization offices were located normally and most often in the more or less normal city administration and so on. So there is hardly any possibility to grasp sort of a complete or coherent picture of the German personnel involved. Of course, there were certain continuations, as in your case with the Sudetengau, but in my case, I didn't get the similar impression. That comparison, of course, means to take into account especially these differences, and it would be highly interesting to encompass additional, of course, say Jewish communities, for instance, where Königsberg was mentioned yesterday. Maybe minor or very small Jewish communities in the countryside, for instance, just in order to look whether big cities with big and significant Jewish communities were handled differently from very small communities, something like that. So this should be done, but of course, there must be funds for financing that. This is, of course, extremely time-consuming if we are dealing with these masses of files. You are right, the Lastenausgleichsarchiv now in Bayreuth is very supportive, and they started this year a new project in better digitizing the entire materials, and of course provide a better approach to the files. But this has not always been the case. I remember when I first got to Bayreuth, or some 20 years ago, say, I was told in Berlin, even by colleagues in the Federal Archives itself, under no circumstances don't mention what you are definitely and precisely working on. It was something about entrepreneurs and something about shops in Silesia, and that's it. Yeah. So very much has changed in the meantime. So that is important to underline. New picture of Aryanizations. Yes, for sure. And I admit that this was the starting point while working on Jewish businessmen and women in the 30s. This was the starting point to turn towards these files in Bayreuth, because this was not automatically taken into account that these files, could be helpful. So it was just I wouldn't say by coincidence, but something in this direction. So there were the files, and they provided all these descriptions of Verfolgungsgeschichte. How persecution, how the forced selling of property went on and was organized by the Aryanizations, by the Nazi authorities in the 30s. And so all these descriptions were very helpful in rewriting history, how this anti-process in the second half of the 30s precisely went on. So from that point of view, strong yes on in that respect. And finally, more example. Jewish institutions, as for instance, Jüdisch Theologische Seminar in Breslau, for instance, and something like that, are not part in this sort of legislation. As far as I remember, the very vivid Jewish community now in Wrocław is striving for getting back several parts of former property of the former German Jewish community, but I've no common knowledge on the precise stage they are in the framework of these discussions. I may remind that as far as libraries, for instance, of course, there are still a part of Jewish libraries in Polish state libraries. For parts of the Berlin Jewish library is now located in the university library in Poznan, for instance, something like that. So if you are looking for a Jewish newspaper, something like that, and so on, you should go not to Berlin but to Poznan in order to look through the entire holdings they have there. So this is, of course, a multilateral discussion, but not an integral part of the LRG legislation. Thank you.
I'll be brief. I'll be very brief. So I'll begin from the end. Thank you, Elinor, for sharing these great news. And I just want to acknowledge you because I think I can say that I know how hard you personally have been working on this kind of legislation, and I know how important it is to you. So I very much appreciate it, and I appreciate you sharing that with us. And I think it's one of the wonderful things about these kinds of conferences that brings a group of experts together and the kind of exchange that can only take place in these kinds of platforms. So thank you again. Wesley, thank you for your comments. Your knowledge always, you always have so much to add, and I appreciate it. I almost feel as if I should have shared a few of the slides in advance and asked you a few questions before. So thank you, because it added so much. And Karen, I'm familiar with what you're talking about. The case of the Jewish community, the Vienna Jewish Community archives. The archives are divided between 3 places in the world at the moment, between Russia, Israel, and Vienna. And I'm sorry. So that's right. I forgot. Before in Warsaw, and in Israel, there have been efforts to reach all kinds of agreements and resolutions, including digitization. Unfortunately, I don't know the end of that. I know the process. And I'm very short on time, but we can talk about the process in a minute if you want to. Symbolic thing of how Israel approaches it. So I think I think with the transition to what Elinor just said, I think there is an effort to change the way that it was perceived and the behavior that existed in the time. And I think now we're moving in a very different direction. And I tried to also mention that in my presentation. I'm hoping that we'll be able to see more of that, but I will continue following that the same as you. Gideon, I'm going to end with your comment because I have probably too much to say about that. So, Michael, thank you for your comment. Again, there's a lot to say. One of the issues that I'll just mention about spoliation committees, like the one in Austria, is that it's limiting because it focuses on national museums and national collections, and a lot of the collections and a lot of the art objects exist in private hands. So spoliation committees have a very significant list of limitations in their capacity and also in how they can achieve restitution and assist in that. They can only assist in the process. In Austria, I would say that although if you look at the research and the history, the restitution laws have been there since 1950s, but they haven't been able to really assist Jews, as we've seen in various aspects. And only recently it developed into the existing spoliation committee, and I think we have to continue seeing how it develops further because it's fairly recent. And I'm sure it will be also inspired by what the Netherlands, for example, is doing. And Gideon, and then everybody can go and have lunch after we speak about the Palestinian-Israeli conflict, because that is what we are here for. Thank you. It's a very important comment, and we shouldn't ignore it. I agree. From I don't have experience, obviously, working on materials that were confiscated from Palestinian communities in Palestine or in Israel. From my knowledge and my personal experience working with different artifacts and objects, I would say that I might even go broader and look into the work that's been done more recently that have to do with the repatriation and nationalization of lands and materials of even the tribes of Northern America. And there's been a lot of work that is now being done to restitute and to return a lot of objects to the tribe, to the natives. And there's been something that I appreciate since I've been living in that area of the world for a long time. It's called the land acknowledgement that's been taking place and it's basically how a lot of conversations begin and a lot of events begin now in places, and I appreciate it very much. I think it's also fascinating historically. A land acknowledgement is basically when you sit in a specific place, you acknowledge the history of the land, who it belonged to and how it basically changed hands. And I think it creates a very, very deep understanding of where you are located in that moment. And also, of course, there's the issue of all the changes around property that have been taking place, and all the research has been done only in the last few years around the 19th century and colonialism. And I think that might be even something to be explored, maybe within that context, how that develops. So, thank you.
So with that, I will thank the whole panel. Thank you very much.
Thank you. Welcome back after a wonderful lunch. And on top of all the thanks that we've given the organizers for this conference, both Tel Aviv University, Professor Stauber, and the Claims Conference, I want to thank them on behalf of all those who've eaten for the wonderful meals that they fed us with as well, and add to that also. A lot of comments have been made about, the session after lunch, but I'm hoping this is our last day and our last two sessions so that we can go through them very successfully. A lot of thought and talk sometimes is given to something being out of the box. And in some ways, the session that we are going to today is kind of out of the box for what we've heard before, and even in some ways the theme of the conference. 70 years of Holocaust compensation and restitution, dealing with the Luxembourg Agreement, has been focused very heavily on the Claims Conference, appropriately so. The origins of the Claims Conference, the origins of the agreement, the impact on restitution in countries, Germany, Austria, and so on. We've heard many of these talks so far. This session is going to focus on the WJRO, the World Jewish Restitution Organization. So let me take just 2 minutes to give a brief background to it, as well as perhaps give a context, that overall context to our session. Our speakers may or may not address that context, but I think it's something that has been hinted at or touched on earlier in many of the earlier presentations, but I want to bring it out and speak very openly about it. So first of all, again, my name is Mark Weitzman from the World Jewish Restitution Organization. The WJRO is in many ways a sister of the Claims Conference. It was founded following the collapse of the Eastern European communist regimes, including the Baltics and the Balkans in the mid-1990s, and it's a consortium based on 14 different Jewish organizations whose role is, and Israeli, Nachon, thank you, Colette. Colette knows more than certainly than I do, so I mean, no, I'm serious, I appreciate that. You're right. You're right. They're actually, I should say, international Jewish organizations as well. Appropriately so. And its aim is to recover property and to set up frameworks for restitution in about 18 countries outside of Germany and Austria. So the countries range alphabetically, for example, from Bosnia and Herzegovina and Bulgaria, all the way through to Slovakia, Slovenia, and Ukraine. And I will not give you the whole list of all 18, but you can imagine, and some of the countries will be the focus of presentations later on today. What I do want to say, and in terms of context, an overall context, and this was alluded to by some of the speakers of the opening event, the opening session, as well as Rachel Blumenthal in our presentation earlier, that conditions were very different, obviously, as we all know, in Eastern Europe than they were certainly in Western Europe, certainly in Germany and Austria. Many challenges existed to beginning a process of restitution after 45 years or 50 years of communist domination and rule. And these challenges included political, social, economic issues. But the one that I wanted to highlight is really the question on the challenge of dealing with restitution in the face of Holocaust distortion. Distortion, which distinct from Holocaust denial, and most of you probably are well aware of this already, does not dispute that the Holocaust happened, but it generally strives to either shift responsibility away from local collaborators or to minimize the impact of what happened, to play with the numbers, excuse what happened. It kind of shades away the reality into a different kind of political narrative, political historical narrative that is both based on some of the communist historiography of the period that lingered, as well as tapping into traditional nationalist and anti-Semitic tropes and motifs. And these efforts are particularly strong and have been in some of the countries where our work is focused and where the majority of the victims of the Nazis were found, countries like Poland and Ukraine, Lithuania, and obviously they complicate matters and make the work of restitution much more difficult. It is really hard to proceed in establishing a basis for restitution when the question of basically who did what and to who were the victims, what happened to them, what happened to their possessions, when all those facts are still in dispute. It makes it's like trying to build a building on shifting sands that you can't build on. And that is the context of dealing with many of these countries and the political structures in, I'll say, Eastern Balkans of Europe, and that is makes our work in some ways significantly different from what has happened with the claims in dealing with Germany and Austria. And I think that different perspective is one that we should keep in mind. By the way, Holocaust distortion is not limited to those countries. I'm speaking coming from the United States, where we have seen Holocaust distortion from street protests all the way up to the White House in different times. So and in the Western world, we have many examples of it as well. But nonetheless, our session here is going to focus on the conditions and the successes, the challenges, perhaps even some of the failures of dealing with restitution in Eastern Europe. in light of some of the conditions that I just mentioned. And I'm looking forward to the presentations that you're all going to hear very shortly. To begin with, our first presentation is Dr. Avi Weber, who is a guest lecturer at the Philipp Marburg University in Germany and at Reichman University, and has involved the joint German-Israeli legal academic research project, Post-Holocaust Development of Legal Remedies as a Learning Process. He specializes in German European law, constitutional law, and compensation law, and since 2008, he's been the external consultant to the Ministry for Social Equality, chartered by the Israeli government to negotiate with foreign governments for restitution of property and Jewish rights. As of August 2020, he's a member of the board of EVZ, a German federal fund entrusted with compensation of slave laborers and Holocaust remembrance and education. That's the formal biography. I've asked each of our speakers to come up and begin their presentation by adding something that is not in the formal biography, so we get to know them a little bit better. Avi, the floor is yours.
Thank you very much. Just 1 second. In the meanwhile, I'll try to follow Mark's advice or request. So the most significant thing that I remember of doing was about 22 years ago when we were lobbying and pushing in the parliament for a change of the law. Is that good enough? Oh, okay. Thank you. A change of the law that we're going to discuss also in today's presentation. I was just a student then, and 22 years later, I'm still a student and still involved in issues relating to Holocaust survivors. So that's either depressing or joyful. That's how it is. So my talk today is, to put it in the context of what Mark just said before, these are the legal developments in principle and their effects on recognizing rights of survivors. The parallel to be drawn also to restitution of property is, of course, the changing of the regimes in Central Europe. And what I'm going to speak about today is more of the individual compensation rights of the survivors. But of course, when we'll have the panel at the end, we can draw the conclusions that are the same, actually the same terms that brought to the changes for the individual compensation that could be drawn also for the property rights. So I'd like to start first from a personal dimension. The story that we're going to talk about today is the recognition of survivors from Eastern Europe and the changes of the understanding of the term Holocaust survivor. So I chose to take the personal story of my grandfather, who started long before the war as a citizen of Romania in the city of Czernowitz, which is today Ukraine's. And basically his story was that he was living there for a very long while until about the war, and then they moved to a very international city called Timișoara in Romania. It was a city that one could hide very well in because it was a multinational city where people spoke German, Hungarian, Romanian, and other languages. And there are Jews that were predominantly of German backgrounds could live well, and they thought far enough or far away from the Germans. As we all know, that paradigm didn't really materialize, and towards the end of the war, even that territory was surrounded, or German forces were at the midst of entering the area. So what I would try to do today is give a context of the topic that we're having the conference about. So the Luxembourg Agreement that we've heard a lot about during the last few days was the first international agreement actually allocating personal compensation to people. It was a breakthrough in the entire concept of international law. It was an agreement between states and the NGO, the Claims Conference, and it created for the first time basically an understanding that individuals are also subjects, in a way, of international law. So for the persecution and for deprivation of civil rights of the survivors, an agreement would be reached in order to create for them a mechanism that will reflect the moral obligation of then federal government Germany, what we know as the West Germany, that was based upon the crimes of the Nazis. The legislation, of course, is based on an American U.S. Marshal legislation that was enacted before the founding of the Federal Republic of Germany. But the BEGISH was in principle, the Bundesentschädigungsgesetz was in principle the first format of actually rendering rights for individual victims, starting from their personal situation and their properties and their monetary issues and so on and so forth. The legislation itself was limited to the territory under which people were persecuted. So the first wording of the legislation, or the first versions of the legislation, was addressing only areas that were directly under the influence of Germany, which meant the historical paradigms and understanding of the Germans in the 50s as per their responsibility towards the Holocaust. And that, of course, changed en route as the legislation was developed for recognition of their moral responsibility, not only for territories directly under the German occupation and German hands, but also territories that were influenced by Nazi Germany, and so to speak, in the satellite cities and countries such as Bulgaria, Romania, and others. Surprisingly enough, although this topic was already addressed in the 60s, in modern waves of legislation, when we've met with the so-called the ghetto pension law and the follow-up directive, the first version of the legislation once again went to the original paradigms of the territorial scope of definition of survivors, meaning that the first versions of the legislation covered territories that were directly under the German occupation. In Germany, compensation law that started or were kicked off with the Luxembourg Agreement started off with what we call administrative law compensation. This was state-managed programs that were dealing directly with survivors, and these programs would run until the 70s. The German legislation had also international effects. In Israel, a copy law or follow-up law named the Law for the Invalids of Nazi Persecution, what we call here in Israel Chok Nechei Redifot HaNazim, was also legislated in Knesset. And that legislation had a special clause referring to German jurisprudence as per the definition of survivors. There were many obstacles relating to framing and allowing people from East Europe to receive their pension, as there was, with the fall of the Iron Curtain, some sort of a historical complex of actually understanding and scoping out to the amount and the way people were persecuted then. The fall of the Soviet Union and the expansion of the European Union and NATO opened archives and enabled further research and further addressing of the situation in these territories. Another very important issue, the historical ban on compensation to East Bloc was lifted, and with that, individuals had, for the first time, the right to come up with their legal claims against the federal government as per the right to be compensated as Holocaust survivors. The very clear, under Soviet Union, anti-fascist definitions that basically neglected or told a different story of the Holocaust were also eradicated, and thus the combination of a changing of the historical research with the establishment of new frameworks allowing the recognition of rights of survivors, spearheaded by the Article 2 of the Claims Conference, that was actually a part of the reunification contract in Germany. It's allowed survivors of East Europe origins to come up with their claims. I spoke before about this legislation that I started my work with. The contract or the treaty, the Luxembourg Agreement, spoke of a cutoff date, the very specific date, October 1st, 1953, that basically spoke about the different limitations of the different groups of people to be handled by different laws. This was a clause allowing the Germans and the Israelis to discuss about the cut-off date, and after that date, basically, the responsibility remained with the federal government of Germany, and up until that date, the Israeli side had to take care of basically all those who came to Israel until that age or date. The cut-off date also played a very important role in clarifying legal definitions of Holocaust survivors, whereas the Israeli legislation has remained almost from its first day open to claims. The federal government had its legislation and its cut-off dates in the form of the German BEG Schlossgesetz that basically in end of 1969 blocked or basically had set up a date for the claims. So whereas the German legislation as of the 70s remained frozen in a way because no new claims could be brought before the administrative system, the Israeli system remained open and so was affected by the ongoing legal order in Israel and the new legal definitions in Israel that were made by the Supreme Court. The main issue about East European survivors is those who came to Israel came after this date. And thus, whether they were left in their origin countries and were excluded because they were in Soviet territories, whether they were already technically in Israel in the 70s and the 80s, they could not make their claims because they were bound by technicalities. The collapse of Soviet Union, just to bring us to up-to-date situation, has brought many claims to be resolved. None of them, by the way, are relating only to Jewish Holocaust survivors. Most of us usually think about this context about the Jewish survivors, but here we see the wave that has brought to the EVZ, which is the slave labor fund, was supposed to cover the slave laborers, and then the creations of new lists and new understandings according to the research, allowing allocation of funds to survivors coming from the East Bloc. The ghetto pension law that I mentioned before, again, was dealing with the territorial scope of the German influence, which was moved later and changed to Eastern territories until the legislation itself was fully changed and adopted. So we're basically standing with the question, with the change of the legislation and with the abilities of new claims to be submitted, key terms that were already thought to be covered in the 60s under the existing legislation framework were rediscussed. So basically we saw the change from the old classical understanding of ghettos, such as Ghetto Lodz, what we remember from Schindler's List, to the situation of open ghettos that we know today. We've seen the change in recognitions of survivors that were only under direct Nazi persecutions to survivors that came also from the satellite countries, as I said before, Romania and Bulgaria. We see the recognition of other groups that are less relevant for this topic, but still interesting, of the North Africans. By the way, it's a very tragic case that those from those countries who actually made their way to Europe and actually suffered in camps such as Bergen-Belsen and so on were always excluded of the right to receive personal compensations because they were of wrong nationalities. So just for example, the case of people from North Africa that came to Bergen-Belsen were excluded because they were British nationals. And again, of course, parallel to the legal development, this research and the studies of what has happened in Eastern and Central Europe was always instrumental to claims that were brought before courts in Germany as per the rights of the survivors. The main changes that took place are, of course, was the enlargement east. We had a democratization process of Central and Eastern European countries, which allowed a new type of discussion with governments and their understanding of their responsibility towards what has happened. We've seen a wave also of states making their own historical committees and their own soul searching on what has happened in the Holocaust. So we know the famous Romanian case where Elie Wiesel was heading the historical committee. But we do see at the same time legislation that is ongoing, just showing us how this issue is still relevant, as we've just seen in Belarus before the fights or war started with Ukraine, where nations still pass laws relating to definitions of Nazi wrongdoing in order to make some sort of a political claim. The big change was the move from the paradigms of the 50s, as I said before, the understanding that the classical understanding of persecution and the scope of the Holocaust and the types of the Holocaust was readdressed. And we saw a wave of positivistic approach towards the research of Nazi persecution, which allowed to make the claim to enlarge the definition of survivors. We've seen also a wave of recognition of local governments outside of the territories of Germany in rights of survivors. So we've seen legislation in countries such as Poland, Romania, and others creating frameworks either for social support of Holocaust survivors or actually compensation program. In Israel, we've seen a change also in the understanding of the role of the State of Israel and its responsibility towards Holocaust survivor, a question that is, in my eyes at least, could be a topic for an entire seminar or a discussion day as per the scope of the obligation or the need of the Israeli government to take care of survivors living in Israel. But the Supreme Court has made a 180% change in its paradigms, leaving the 70s where it would only follow and copy German decisions to having its own independent Israeli free jurisprudence as per the definition of survivors. We've seen also a wave of changes of legislation also here. We had the first big decision about jumping out of this classical cutoff date of the 1st of October 1953 in Israel already in 2007, when we had the first Holocaust survivors benefit laws. Those of you who lived in Israel remember the demonstrations then led by survivors and having the Prime Minister Olmert sitting with his staff and not understanding how come there are suddenly thousands of survivors in the street blockading the Prime Minister's office. Sadly, it didn't happen as fast as we all hoped, but I think we were all very happy to see that under the government, where I think Yair Lapid was then the finance minister, that there was a change made in order to create some sort of a system that created same benefits to all survivors under Israeli law. As I said, the ongoing discussion and the ongoing changes within the historical understanding of the scope of the Holocaust and its different forms allowed survivors to push for enlarging the scope of the so-called ghetto list. Those are the places in which, under German legislation, people are to receive their payments. And there again, the Article 2 agreement of the Jewish Claims Conference played an important role in setting up rights of survivors worldwide. So I would try to come now to conclusions. So surprisingly enough, and I remember we have with us Coletta Vital that had many meetings or many discussions in her capacity as a head of a committee in the Knesset, and years after, the term Holocaust survivor is still not defined by until today. So I think we've covered most of them. We're coming to the point that we have actually worked out the legal definitions, but it is a very dynamic process that started in 1951 with the assumption of responsibility by Konrad Adenauer, and is actually ongoing until today. And we have these yearly meetings between the Claims Conference and the federal government as per pushing and recognizing new groups of survivors on a yearly basis. The dynamics of the historical research and the widening of the territorial scope also changed the understanding of the definition of survivors and allowed more countries and more groups to be included. Again, in my eyes, one of the most important things is that the sanctions towards payments to East Europe and opening up the abilities of Jews living in Central and Eastern European countries to physically or technically press their claims against the federal government allowed this ongoing discussion that once again made it clear and apparent that more groups should be done. I started off actually my talk today about the fact that I'm 22 years involved in this. So recently, just to show you how things come back over again and the history seems to repeat itself, this year we've also seen a small issue regarding sanctions. Because of the sanctioning of Russian banks, those survivors living in Russia were actually left with no money. So then again, the Jewish Claims Conference found itself maybe 70 years after the first agreement, negotiating with German government and others of means of getting food for first, support, but also money to territories that were under the embargo and the sanctions of world banks. So everything that we speak about kind of repeats itself. We're always in a way of a loop. But when we look 70 years back, I think that we've had over the years a very interesting process of the redefinition and the re-understanding of the scope of Holocaust survivors. Thank you very much.
Thank you, Avi, for really covering an immense amount of ground in a very tight schedule and a tight time. I think that we really appreciate how much you were able to pack into here, because I think that when we think about the way the Luxembourg Agreement had to be applied in different ways and different contexts than it originally was conceived, and you were able to give us a sense of covering the change in definitions that were required, covering the further extent of the scope of persecution, and how all that was built on the original and worked off the original conception, the original agreement. I think I thank you for that picture that you were able to give us. And I guess my personal note I'll add was that seeing Raoul Hilberg's name, they reminded me that when I first began, I took a seminar with Hilberg, and it's interesting today to see how little he is referred to in so many ways. Danny Michman has just written about that a little bit. But the person who once really created the field in many ways has really been superseded by more recent interpretations and contexts. Our next speaker is Professor Stefan Christian Ionesco, who is currently the Theodore Zev and Alice R. Weiss Holocaust Education Foundation Visiting Associate Professor in Holocaust Studies at Northwestern University. He's the author of several book chapters and articles in such journals as Holocaust and Genocide Studies, Nationalities Papers, the Journal of Ethnicity and Nationalism, Journal of Genocide Research, Holocaust Studies, a Journal of History and Culture, and Yad Vashem Studies. Professor Ionesco's book entitled Jewish Resistance to Romanization, 1940-1944, was published by Palgrave Macmillan in 2015, and currently he's finishing a book manuscript entitled Restitution of Jewish Property in Postwar Romania, 1944-1950. Stefan, the floor is yours.
Hello, everyone. Thank you very much, Mark, for this generous introduction, and I would like to thank the organizers, Professor Stauber, and all your colleagues and Claims Conference for putting together this wonderful conference. And for me, it's especially meaningful to be here, to participate in this conference, where Claims Conference has such an important role. Part of my current research, which my paper belongs to, was started when I was a fellow. I had a fellowship from Claims Conference entitled Saul Kagan Fellowship for Advanced Shoah Studies. And the other one. Okay. I will use this one. So thank you very much for that. Before I start, I have to comply to Mark's request to say something maybe interesting about me. Nothing shocking, but as you noted, my last name is Ionescu, right? And perhaps if you met other Romanians, you've noted that many Romanian last names end up in Escu. It's like something contagious, a plague, perhaps. Some years ago, when I started my first job in California, part of my contract, I had to deliver a lecture, like annual lecture. And I was very proud. I prepared a lot for the lecture, and the university advertised it, the huge billboards in the campus. I was very proud. Very late, I've noticed that they misspelled my name, my last name. So instead of Ionescu, they wrote Antonescu, which is a wartime dictator of Romania. So I had to start my lecture with a disclaimer that I'm not related to our terrible dictator. Having said that, I will perhaps prepare to start my presentation today, just to say that this is part of a broader book project entitled Restitution of Jewish Property in Post-Holocaust Romania, that hopefully will be published.
I'll just make it full screen.
So, yes, okay, thank you. And without further ado, I will start. Just to show you here, it's actually a flyer that was distributed during the Holocaust in Romania by this Romanization agency, Centrul Național de Romanizare. It says for rent. This was put on houses that were basically confiscated, expropriated from Jews to advertise for potential Gentile tenants who could find fancy on specific houses. Cities were full of this type of notes. So my paper today is entitled Courts Reversing Robbery, Implementing the Reversal of Romanization of Jewish Property, 1944-1950. After the putsch that toppled Marshal Ion Antonescu's anti-Semitic and genocidal dictatorship in August 1944, Romania changed sides. It abandoned the Axis and joined the Allies. Before it became a full-fledged, this is our wartime dictator, that is not my relative. Before it became a full-fledged communist dictatorship in December 1947, post-Antonescu Romania was ruled by several transitional governments. The first three were coalitions made of four political parties that removed Antonescu: National Peasants, Liberals, Social Democrats, and Communists, only to be replaced in March 1945 by the pro-communist Popular Front-style coalition headed by Petru Groza. This is a map of Romania, and this is Petru Groza, the pro-communist prime minister. As you see, he doesn't look like a typical proletarian guy. Actually, he was very wealthy, boyar. Tensions continues in Romania at political level between these two groups, the pro-communist coalition and the traditional historical parties, the National Peasant, the National Liberal parties. In terms of Jewish survivors expected the abolishment of previous anti-Semitic policies, the criminal indictment of perpetrators, and the restoration of their rights, especially the restitution of property that had been confiscated during the years of Romanianization, 1940-1944. What was this Romanianization that I keep talking about? This was the local equivalent of Nazi Aryanization in a broad sense, and mainly entailed the transfer of economic assets, real estate, companies, and jobs from Jews to ethnic Romanians through expropriation by the state, redistribution to deserving Romanians, and purchases of assets by Gentile profiteers. In this paper, I will only focus on individual private property, housing and companies. Ethnic Romanian refugees, civil servants, skilled workers, various agencies and NGOs, war widows, invalids and veterans were the main beneficiaries of Romanianization. In order to implement this policy, Antonescu established several agencies. You've already seen one, Centrul Național de Romanizare, National Romanization Center, and adopted a series of laws, such as Decree Law for the Expropriation of Jewish Urban Real Estate from March 1941. One of Antonescu's major projects, Romanization aimed to promote economic nationalism and create a strong ethnic Romanian bourgeoisie. While the Romanization agencies failed to confiscate and redistribute the majority of Jewish real estate or companies to ethnic Romanians during the Antonescu regime, for the most part due to Romania's involvement in the anti-Soviet war, the detrimental evolution of the war for the Axis, and Jewish legal resistance through litigation and camouflage, tens of thousands of Jews lost their houses in favor of Gentile beneficiaries. My research uncovers the extraordinary untapped story of the Jews mostly successful petitioning to courts and the retrieving of their Romanized assets in the post-war era, even though only temporarily for most of them. By summer 1941, the post-Antonescu transitional government adopted the laws reversing the racial legislation, including Romanization provisions, and also adopted the main restitution laws. These are two main restitution laws in my interpretation. So Law 641 from 19 December 1944. Please note the date is very early, right? Earlier, several speakers mentioned the pro-American restitution law in Germany, adopted in 1947. This is rather early law, although not early enough for Romanian survivors. If you read the petitions, people are very frustrated that for several months the government didn't seem to be moving in this direction. This was entitled The Law for the Abolishment of Anti-Jewish Legislation, but included a lot of restitution stipulations. And the second one was Law 607 from August 1945 for the annulment and revocation of some acts that transfer property in exceptional circumstances. Again, very long title, but it refers to those property that had been sold, allegedly, by Jews to Gentiles. These laws have been drafted mainly due to foreign policy considerations, such as the government pledge stipulated in the Armistice Agreement to repeal previous discriminatory measures based on political and racial criteria. Its concerns about the Jewish lobby, the peace conference, and its goal to obtain better terms concerning Romania's border and co-belligerent status. Although the new regime on paper abolished the Romanization provisions, in practice it allowed restitution only partially and in the short term. The restitution was undermined by major problems in events such as the devastation of war, insufficient personnel at Romanization agencies, and contradictory court decisions. Although many properties were successfully returned during the first post-war Antonescu years, restitution was a disorganized and incomplete process. It stopped a few years later when the communist regime seized complete power, obtained control of the Jewish community, and implemented new expropriations targeting political enemies and bourgeoisie, such as nationalization of companies in 1948 and nationalization of housing in 1950. In practice, most local Jews used traditional patterns of petitioning developed across history in order to obtain the reversal of Antonescu's dispossessions, especially by petitioning to courts. Even though restitution laws were adopted relatively quickly, as I mentioned, de facto restitution took longer. Typically, to reclaim expropriated real estate, anti-racial legislation required Jews to file a request in court to evict their Romanization profiteers who still live in those houses. Despite formal restitution, some Jewish owners could not move into their houses right away because restitution laws prolonged the leases of several categories of Romanization beneficiaries, such as retired civil servants, invalids, orphans, widows, welfare organizations, state institutions of public interest. They prolonged them several times until April 1948, except in the cases of houses owned by the Jewish working class, war invalids, widows, and of low income. In order to obtain the right to return to their pre-Antonescu houses, Jewish owners and tenants had to prove that they inhabited the houses before the expropriation laws. Thus, the burden of proof fell on the Jewish owners and tenants. Not always the Jewish plaintiffs won their property back. The court system issues sometimes contradictory decisions, especially in the cases of transactions where the Gentiles claim to have acquired the property through legitimate methods, like purchasing them. Having a skilled lawyer when suing for restitution was crucial for former Jewish owners, especially when they faced some potential hostile judges. For example, the lawyer Miron Butariu, a Gentile lawyer, recollected in his memoirs how he represented a Jewish plaintiff in a court in the city of Arad, who requested the restitution of his house confiscated in 1941. Facing a hostile judge who was a sympathizer of the fascist movement, Butariu questioned the magistrate's objectivity based on his fascist past, and as a result, the judge had to recuse himself. The crucial question is, what was the extent of court restitution? And is it, possible to have a grasp of the extent of this court restitution during the first post-war years? Overall, because we lack access to full court archives, it is not entirely clear how effective the restitution laws that I mentioned, 641 and 607, and what was the proportion of Romanian Jews who managed to recuperate through post-war litigation the properties they lost, expropriated or sold, allegedly, to Gentiles during the Antonescu regime. However, I tried to do something. I found about 147 court decisions, and this court decision showed that Jewish plaintiffs won about 68% of the cases that reached the Supreme Court. If we take into account the court decisions at all levels of jurisdiction, all this 147, the Supreme Court, Appeals Court, Tribunal, Judecătorie, local court, the Jewish plaintiffs won about 68% of cases, while few of them ended up in neutral decisions. While this is not a representative sample for the entire restitution litigation, it is a significant exploratory finding until the court archive will become available. It shows that most of the Jewish plaintiffs eventually won their cases, but also that restitution sometimes requires several years of litigation at different jurisdictional levels until a final decision could be reached. The examination of these court documents also showed that most of the Supreme Court decisions were issued in 1945 and 1946, based on law 641 for the expropriated assets, and those prolonging into 1947, 1948, 1949 were overwhelmingly cases based on law 607, in which former Jewish owners tried to cancel the sale of the assets made under duress. The Supreme Court decision proved that the Jewish plaintiffs were very successful in the litigation based on law 641, about 69.6%, and largely successful in litigation based on law 607, that referred to restitution of properties sold under duress, 62.5%. So fewer cases seem to be won by Jewish plaintiffs and among those that were sold. Jewish plaintiffs were very successful at appeals court, about 75%, successful at tribunal level, 65%, extremely successful at local court, Judecătorie, about 80%, but it's a smaller sample here. This suggests that Jewish plaintiffs were more successful at a lower level of courts, the judiciary, compared to the litigation at Supreme Court. The court decision that also showed that, for example, if we look from a gender perspective, that Jewish women also actively participated in litigation to recuperate their property. Women were plaintiffs in about 28.6% of all cases, of which women participated alone as plaintiffs in about 23.8%, while they stood together with their husbands in about 4.7%, almost 5%. Discussing the cases of various European countries, the New York-based American Institute of International Information was particularly concerned in 1946 report about what he saw as the reluctance of the Romanian authorities to honestly address the restitution of Jewish property and the complications of relying mainly on courts to implement restitution. The Institute's representative believed that the Romanian government adopted restitution legislation only formally, but did not really intend to return the Romanized properties to Jewish owners, because it aimed to protect ethnic Romanian profiteers, and only a minority of former Jewish owners managed to successfully navigate the complicated restitution formalities and recuperate their houses. I'll just read a direct quotation from this report released in 1946. Romania is an example of the futility of legislation under conditions of bad faith and a hostile administration. The legal provisions show an eagerness to protect those who acquired Jewish property at the expense of Jewish owners, and the practices of special exemptions, which resulted in making the laws almost meaningless. Out of the 17,000 confiscated houses, only 5,000 are again in Jewish hands by 1946. As to sales concluded under duress, only those properties which are now in the hands of proven fascists, former government officials, or active members of fascist organizations are annulled. In other cases, the Jewish owner must prove that he suffered a loss of at least 40% of the value of the house before his claim would be considered at all. Even if his claim is accepted, not only must he repay the original price, but also indemnify the present possessor for all improvements and expenses. The new owner, however, is permitted to keep all the income he might have derived from the property during this 4 years of Antonescu regime. End of quotation. One of the most relevant parts of the Institute report is the estimation, probably based on data supplied by Romanian Jewish leaders, that out of the 17,000 houses expropriated by Antonescu regime, from which the Jewish owners had been evicted, only 5,000 had been returned to them by 1946. Because even though the laws acknowledged restitution on paper, they stipulated various exceptions and delays, and sometimes the implementation by the judiciary had been hostile. During the next years, the restitution seemed to be increasing significantly, because by April 1948, the exemptions in favor of specific categories of privileged Romanization tenants ended, and the courts continued to rule in favor of the former Jewish owners and tenants. But it didn't go for long. For example, the last court decision I found is from spring 1949. From that moment, I didn't find anything. So it's maybe there are somewhere, but I could not find them. The Institute correctly argued that the restitution of the property sold under duress was less successful than the restitution of expropriated real estate, because of the conditions required by Law 607 regarding the status of buyer, the proportion of financial loss suffered by Jewish owner, and so on and so on. The Institute also had rightly noted that a crucial part of the restitution process took place in courts, in local courts, whose procedures were slow and complex, and sometimes the judges were hostile to Jewish claimants, at least during the first post-Antonescu years, which were plagued by uncertainty about the country's political future. Gradually, the court system went through major changes, and this probably influenced the litigation, including the one related to Jewish property, because some of the pro-Nazi judges were purged. Well, not all, the majority stay, I think, from what I've seen. And the remaining ones adapted to the communist regime and its anti-fascist and anti-racist discourse and policies. Restitution of Romanized Jewish property by courts was sometimes suspended by the authorities' use of the requisition law. Such cases took place when some high officials, including Prime Minister Petru Groza himself, advocated for the requisition of Jewish-owned buildings, including some of those that were recently restituted by courts. While a few government officials understood the difficult situation of Jewish survivors in relation to their property rights, most of them, including Prime Minister Petru Groza, were unsympathetic, to say the least, or hostile to the Jews, and they believe in a myth depicting local Jews as wealthy, quote, parasites and profiteers at the expense of ethnic Romanians, the economy and society. A particularly false and unfair accusation blamed the Jews for the existing anti-Semitism and chauvinism in Romanian society, and for undermining the new people's democracy, the communist regime, which is very bizarre. The Prime Minister's hostility against the Jews and their alleged privileges might have been caused by the fact that Groza himself was one of the profiteers of Antonescu's Romanization of Jewish businesses. I found some documents, including from secret police, that he bought a Jewish factory, like alcohol factory, and during the war. After Groza party came to power in March 1945, he profited again from Jewish property when he moved in a luxurious villa confiscated from the Jewish industrialist Max Auschnitt, who fled Romania. This villa is located in a beautiful part of Bucharest. A court decision did not always guarantee that Gentile profiteers would abandon the Jewish houses. They often ignored the Jewish owners, who then had to hire a judicial executor to enforce the decision. Some tenants were very influential and refused to obey both the court and the executor. Jews whose houses were occupied, for example, by public institutions such as police or secret intelligence service faced particular difficulties and were not really able to move in. To conclude, Even though the post-Antonescu transitional governments formally abolished the Romanization legislation and adopted the laws for the restitution of property rather quickly, by summer 1945, in practice restitution did not proceed smoothly. Romanization beneficiaries and anti-Semitic groups opposed the countermand policies and agitated against restitution of Jewish property, and the authorities did not seem fully committed to address the injustices done to the Jews. While some Gentiles supported the restitution of property to Jewish survivors, numerous others, I would say the majority, especially the anti-Semites, beneficiaries of Romanization, opposed the countermand policies and displayed their hostility in public and private settings. Most of the politicians from both political camps struggling for power, the pro-communist and the traditional historical parties, agreed to reverse Romanization measures because they saw it as an imperative requirement imposed by the victorious allies through the Armistice Agreement. Here, this anti-Semitic myth of world Jewish conspiracy worked very well. They thought that both American, British, and the Soviets were puppets, and the Jews were puppeteers. Although many properties were successfully returned during the first post-Antonescu years, overall a fair, complete, rapid, and permanent restitution of property did not take place. The court restitution process ended by 1949-1950 due to a variety of international and domestic events, such as the consolidation of the communist regime, its growing confidence due to Soviet support, the signing of the peace treaty in February 1947, and it entered in full force in fall of 1947, the new nationalizations, and the establishment of Israel. The situation plummeted, especially after December 1947, when the communist regime forced King Michael to abdicate, abolish the monarchy, and seize complete power. The communist massive nationalization policies of companies in 1948 and houses in 1950, targeting mainly political enemies and the bourgeoisie. However, I would argue that many Jewish survivors faced a second expropriation of their assets within a single decade. Even though the communist nationalization worsened the lives of many entrepreneurs, property owners, liberal professionals, and artisans, regardless of their ethnicity or religious background, the Jews who were disproportionately represented in those social categories were particularly affected. My examination of restitution process between 1944 and 1950 shows a significant agency of Jewish survivors, whether notables or ordinary members of the community, who, in spite of the numerous obstacles encountered during the post-Antonescu transitional years, worked tirelessly for restitution and often managed to recover the property, only for a short time. Thank you.
Thank you very much, Stefan, for that extremely informative look at a really, I guess, a case study in the sense of one of the early and little known, I think, efforts at restitution, the halting process in which it took place with sort of stops and starts, the reality of what set in when communist nationalization began. And I think you left a lot of space for further research, further questions to be pursued, including what you mentioned at the end, the role of anti-Semitism as a motivating factor in restitution agreements, I think, which would be something very interesting to pursue as well. Thank you very much for that. Our third and last speaker on the panel is Dr. Anna Chirich-Pavlovich, who is a recipient of the Claims Conference Saul Kagan Doctoral and Postdoctoral Fellowship for researching the restitution of Jewish property in Bosnia and Herzegovina, and a PhD candidate in disciplinary history at LT University in Hungary. She holds the MA degrees in Jewish history from Central European University in Hungary and international law and human rights from the European Institute in Spain. Previously, she completed BA Studies in International Relations at the Faculty of Political Science, University of Belgrade in Serbia. She was a Maria Sklodowska-Curie Fellow for researching anti-Semitism in East Central Europe and explores Sephardi revival in Bosnia, as well as the intertwinement to some crucial socio-political phenomena, such as civil society, popular culture, nationalism, and World War II memory in the Balkans. She is currently engaged in developing an online repository dedicated to digital preservation and revitalization of Jewish heritage in Southeast Europe. Anna, the floor is yours.
Well, I would like, of course, to thank to the organizers and to the Claims Conference and to all of the participants who presented before me, because I feel that I and all of us have learned a lot so far. I thought, I was also, by the way, I was also declared Anna Pavelic instead of Anna Pavlovich. Yes, yes. They actually printed the booklet, yes, for me presenting about Ustaširizm with the Pavelic last name. Yes, it happened to me too. Yes, it was printed, so it was very, very embarrassing for me personally, but it happens as well. Something interesting about me, I didn't know what information to provide, but I can tell you that after I finished my bachelor degrees in political science, I promised myself never to deal with the Balkan politics and history. So I thought I will never be engaged in this. And indeed, my first academic work was about European Union, about the session, about the legal requirements. So I was very, very neutral, and I stick to the plan. However, at one point when I got familiar with the Sephardi Jewish culture in Bosnia, I was completely in love with it. And here I am speaking about the restitution of Jewish property in Bosnia. So I broke my promise, definitely. So this is the overview of my presentation. I will speak, of course, about the Jewish community background and some general facts about the annihilation in the Shoah, about war damage estimations and communist-era expropriation, about post-war Bosnia, which is very particular case and complex political system, about restitution efforts so far, and I will consider some obstacles for the righteous law on restitution. Bosnia is, I think, one of the worst, if not the worst example of the restitution of Jewish property. So one of the most complicated cases. And I especially thank to the organizers for including this topic in the conference curriculum, because I will get to voice the situation of Bosnian Jewish community. So a little bit about their history, because I'm well aware that it is not part of the common knowledge in Jewish studies as well. So first, the historical records of Jewish presence in Bosnia date from the mid-16th century, when Sephardi refugees settled across the Ottoman Empire, and of course in Bosnia, which was included in the Ottoman Empire until the late 19th century, when it was occupied by the Austro-Hungarian Empire. What has changed during the Austro-Hungarian reign, that also Ashkenazi Jewish community began to settle in Bosnia, most of them in Sarajevo. So most of the Jewish communities before the Holocaust and after the Holocaust lived in Sarajevo. So most of my talk will consider Sarajevo. So before the Shoah, there was about 40,000 Jews in Bosnia, and most of them, 12,000, lived in Sarajevo, which was about 1/5 of the city population. But what is also good to know is the ethnic composition of Bosnia before the Second World War. The last census was conducted in 1931. So according to that census, the most of the population in Bosnia was Orthodox Serbian, then Muslim, then Croat Catholic, and there were 1.07 others, including 0.5 Jews. The war in Kingdom of Yugoslavia began Bosnia after the Austro-Hungarian period, and after the Great War, Bosnia was included in Kingdom of Yugoslavia until the Second World War. So when the war consumed the country in April 1941, Bosnia was occupied by the Nazi puppet state, independent state of Croatia, and of course local Croat population was privileged in that system, but also local Muslim population, or today Bosniak population, were declared as honorary Croatians. So there were spontaneous and organized property robbery and mass executions of the regime enemies, and not only Jews, but Serbians, Roma, and political opponents. When it comes to the robbery of Jewish shops and organizations, they were firstly assigned to the most loyal members of the Ustaša regime, so-called trustees or povjerenici. And they were later sold to domestic Aryans, which usually meant domestic Muslim or Croat populations. The new Ustaša regime, they issues a series of laws which allowed them to expropriate local Jewish communities, but also similar laws were enacted also on the local Sarajevo level, which even more endangered the situation of. Is everything all right? Okay, it's all right. Okay. So there was a systematic private property plunder that was legalized with many state and local level laws, which were usually copy-paste law by the Nazi regime. So they were not particularly original when it comes to the anti-Jewish legal measurements. But following those laws, government's trustees were assigned to the Jewish and the Serbian shops, but this order was also effective for the Jewish cultural, sports, humanitarian, other voluntary organizations as well. So many of these associations, such were La Benevolencia, Ezrat Yetomim, La Humanidad, Actus, Bikur Cholim, Visitar Dolientes, and so forth. These organizations operated as small enterprises, since they had their own movable and immovable property, their financial means generated through frequent fundraising or via passive incomes, like renting properties or similar. So also both Sephardi and Ashkenazi religious organizations had their trustees assigned it to them. So they were managing the Jewish property before it was sold to local Aryans, as I've mentioned. So more than 80% of Bosnian Jews were murdered in the Holocaust, and about, according to the estimation, about 2,000 survivors returned to Bosnia. But for our considerations, I've found in the archives some first, probably the most accurate estimations about the Jewish material losses in the Holocaust. And according to this estimations, the value of the looted property is as this. As you can see, the most valuable item on the list were looted shops, manufacturers, and industry. And the value was 1,770 million Yugoslav dinars. But the overall value, which is probably more important for our talk today, is so the overall value is 2.5 or almost 2.6 billion dinars, Yugoslav pre-war dinars. But at the time it was more than 47 million US dollars, and today it would be, when we calculate today value, it would be a little less than $1 billion. So it was the estimated value of the looted property in 1945, but if you count all the losses during the communist regime, it adds to more than $1 billion American dollars. At the beginning of Bosnia was, of course, incorporated in the socialist Yugoslavia after the Second World War. And in the beginning, it seemed that novel socialist government was willing to return all the looted property which was plundered by the Ustasha regime. However, they quickly, in less than a year, they changed their mind and decided to take this property for themselves. So in the following 2 decades, until the late 1960s, more than 40 laws were nationalizing private property in socialist Yugoslavia. So those were, for instance, law on agrarian reform and colonization, law on property confiscation and execution, law on nationalization of private commercial enterprises, and so forth. Of course, this affected Jewish communities a lot, because if they managed to regain at the beginning of socialist Yugoslavia any property, everything was taken for them. In addition, there were 6 collective aliyot from Yugoslavia to Israel in the late 1940s and beginning of the 1950s, and they all had to renounce their Yugoslav citizenship and permanently donate their property to the state. And some of them returned to Yugoslavia, but they never regained their property back. And out of this number, 9,074 were from Bosnia. But coming to the complexity of Bosnia, Bosnia is not only a post-socialist country, but it is a post-conflict country. So in the beginning of the 1990s, Bosnia was consumed by the interethnic war. So after the interethnic bloodshed, Bosnia had to endure both the post-socialist, I would say, and post-conflict transition, which was incredibly painful in terms of politics, economy, and so far. But what is also important for our talk today is the Dayton Agreement, which functions as a constitution of the Bosnian Republic today. The primary concern of this agreement was to halt the war and to establish a peace between the main belligerent parties, or as they call them, constitutive people, and those were Serbian, Bosniaks, and Croats. But the trouble with the Dayton Agreement is that it is systematically discriminating minorities such as Jews, Roma, and others, so they cannot run from some of the state positions. But they say that Bosnian political system is one of the most complicated in the world, because it is a federal republic composed of 2 autonomous entities, and every entity has its own legislative body and presidents, but they also have a 3-party presidency consisted of 1 Croat, 1 Bosniak, and 1 Serb. And I think it makes it all the harder for any negotiations about the restitution of Jewish property, because they had to negotiate with 3 people which usually do not agree with each other and do not want to sit in the same room. So you have to be engaged in a trilateral kind of negotiation. But it's also a differentia specifica of the Bosnian political system, and that is why Bosnia can hardly be called typical sovereign state. It is a significant international involvement, and that is to say the Office of High Representative has essential veto powers and can cancel law or enact law, or can basically change any state official. Also, within the Constitutional Court, there are three foreigners who are appointed by the President of the European Court of Human Rights. But to be more precise, so restitution efforts thus far in Bosnia. So Bosnia still doesn't have a law on restitution, any law on restitution, which could be the legal basis for the local Jewish community to claim their assets. But the early 2000s were seeming like a momentum for restitution, and there were some significant social efforts, and I would say optimism, restitution optimism. There was 2003 law on religious freedom and legal position of churches and religious communities, which did not help much to local Jewish community because there was no law on restitution. But Bosnian Jewish communities also conducted a survey in 2005, but the survey was only about their communal property, not about the private property or hireless property, which is, I think, the most important issue, especially in post-socialist countries and the countries where the Jewish communities were largely annihilated. So the hireless property is the most important part of the restitution efforts. Also in 2006, Economic Institute published restitution feasibility studies. For them, it was feasible to restitute and to restitute actual properties to Jewish and other communities that were, but they were mainly refer to the restitution of property that was seized by the during the communist era. But there were also efforts in 2008 and 2009 to enact a law on denationalization, as they call them, although the commissions that were established in order to enact this law were called the Commissions for Restitution, but somehow the law turned out to be on denationalization. And indeed, it considered the period after 1945, so only the communist era for the restitution, which was not, of course, beneficial for the Jewish community because then the property could be restituted to the people that actually looted the property during the Second World War. But also what is important is that Bosnia signed the Terezin Declaration on Holocaust-era assets and the related issue. So, on my opinion, briefly, I've listed the 3 points. So what hinders the restitution of Jewish property in Bosnia? It is, in first place, unstable political system plagued with nationalism of so-called constituent people. It is the lack of social recognition. The Holocaust is detached from its local context. So no one is denying Holocaust. However, it is hotly debated what exactly happened during the Holocaust, so who was the victim and who was the perpetrator. So it is one of the main issues, as Mr. Wünschmann mentioned, so it is very difficult to navigate within all those different narratives. But what is also very important, and we can find the examples in all post-socialist countries, it is the rehabilitation of Nazi collaborators, which I believe significantly hinders the restitution efforts because Nazi-era collaborators were portrayed as national heroes. So in Bosnian case, important example is definitely Roman Catholic Church, which is holding regular masses for Ustaša leaders, but also rehabilitation of domestic Muslim collaborators such as Hussein Jozo. And I have to mention that I have found publication by Routledge, I think it was from 2017, which portrays Hussein Jozo as a prominent Balkan scholar and Muslim reformist, while he was an SS Sturmbannführer and who remained an outspoken anti-Semite until his death in 1982. And during the Second World War, Jozo joined 13th Waffen Mountain Division of the SS Handjar and was imam of 28 regiments. However, there were significant efforts to rehabilitate his name, and a street in Sarajevo was named according to him, and also a primary school in Gorazde, because the name Nikola Tesla was unsuitable, obviously, for them. So those were some of the examples, but of course there are many. What can be done? I think we should continue researching and overcoming memory gaps, because memory gaps, what I forgot to mention, are the third important dimension of the destruction of Jewish communities. So when it comes to Bosnia and many other communities, the destruction was not only material and physical in terms of killing and taking their property, but it was also a cultural destruction. So a cultural dimension of genocide is, I believe, largely underexplored, and the creator of the notion of genocide, Raphael Lemkin, wrote a lot about it. And actually, he contemplated about a case in Bosnia when it comes to the cultural genocide and what was Ustaša regime doing to local Jews and Serbians. So also we need to raise public awareness about the domestic Holocaust and what really happened, but also advocating for restitution law that considers looting of Jewish property starting from the war or set in Yugoslavia, which was April 1941 and not from 1945. So in the end, if I may, just one more minute, I wanted to show just a couple of pictures of buildings that were formerly owned by Jews and that are disputed. So this was a building of their main association, La Benevolencia, and now the Cantonal Ministry of Interior. This is Jacques Salom's mansion. From the beginning of 19th century. Jacques Salom was one of the renowned member of the Bosnian Jewish communities who survived the Holocaust, but never regained his property back. And this is Bratzo Poljokan mansions, who died in the Holocaust, but villa was never returned to his family or to the Jewish communities, and it remained a government-owned building. I will have to stop here, but please, I believe that I have probably forgot to mention something important, and if there were something missing from my speech, please do ask me to explain. And I would like to take just a minute to thank Mr. Ivica Čerčer, former president of Bosnian Jewish communities, for coming here. And please, if you feel that there should be said, there's something else should be said, please feel free to add. Okay.
Thank you, and I'm going to invite our other speakers to come up and take a seat here. But I want to thank you, Anna, for really giving a panoramic survey of an area that's too often kind of ignored or fallen by the side, as well as also illustrating the intense complexity of, and maybe the most difficult political situation that we have to work with. So I really thank you for bringing all that to our attention. I will just take a second to note that WJRO, if you're further interested in this topic, has on its website, we did a update to the Just Act report that the U.S. Senate had mandated the State Department to deliver. We did it for the Terrorism Conference a week ago. So on that, you will find the link to every country, all 47 countries that took part in the original Terrorism Conference. And I thank Wesley Fisher for his the active authorship of that update. But you'll find links to every country and what they've done or not done in the past 2 years. Some of the countries that we just discussed, others that we haven't had a chance to mention. And also second thanks to Ivica, wherever he is right now, back there. So the routine is the same routine as for previous Q&As. You will, basically the mic will be passed around. A chance to ask your questions. We'll get all the questions out of the way, and then the participants will have an opportunity to answer them as directed. So, are there questions? Karen.
Hi, this is a question for Avi. During most of your speech, you focused on a sort of a
the definition of, we talked about Holocaust survivors. Yet when you talk about from Eastern Europe, most of the Holocaust survivors were flight cases. And those flight cases basically were not able to be compensated at all, but they were first compensated in 1980, which is obviously 10 years earlier than when you talked about 1990. And when they came out of Eastern Europe. So my question goes a little bit towards the definition, the changing definition of Holocaust survivors, because I think now, both in the State of Israel and in Germany and in the Claims Conference, it really, one of the biggest changes has been to include flight cases in the definition of Nazi victim, and they weren't sort of touched on your talk at all. So perhaps if you want to respond to that.
A naive question, but may I ask Dr. Pavlovich whether in fact, given the fact that the Serbian aspects are trying to leave, or they may try to split from Bosnia, whether that would be a good thing or a bad thing, so far as this is concerned, so far as this specific matter is concerned, so far as the property is concerned in regard to Jewish property that was taken. And the second thing is, I'd like to ask both you and Dr. Ionesco whether there is actually anything in the trials or otherwise that is actually about movable property, or whether everything is about real estate, really.
I also have a quick question for Anna, if you allow me. You have listed 3 specific items that, in your view, hinder property restitution in Bosnia. And my question is, do you think that one should also add the specific delicate reality of a tiny Jewish community in a predominantly Muslim country nowadays, and the sensitivities and the political sensitivities about that?
Thank you. I have a question to Stefan. You mentioned the property of single Jews or families. Could you say something about the property of Jewish organizations? Because Anna had this as part of her speech, and maybe you can add things to that, also including the Jewish communities for sure. Thank you.
2 things. One, to thank Anna really for the good work which she did to squeeze everything what she wanted in only 8-9 minutes. Then one small remark. All of you who are familiar with the history of Jews of Balkans will stumble upon the statement that the Ottoman Sultan Baz II, from the depth and the goodness of his heart, received refugees from Spain and settled the Balkans with Jews, the Sephardi Jews. The truth is definitely completely different. Sultan was pragmatic, and he needed those Jews for their knowledge of the languages, commercial connections through all Europe, for their ability to do medical work, for his expanding army, and one thing which no one mentions, for their knowledge of extracting gold and silver from raw ore, and because the biggest mines were in his territory in Kosovo. And the second, somebody mentioned this question of 3 constitutional nations and different approach to the restitution. It's more than that. It's so difficult. I'll tell you. First, Croatian constitutional part deny any part in looting or in the destruction of Jewish community. Serbian part accepts everything because they want to join Jewish suffering with the Serbian suffering, but in the same time they told me and others of us representatives to various meetings, they will not accept anything about restitution if date of restitution, if terms of restitution will not include the property of the Serbian church in Bosnia and Herzegovina, because without that they don't accept anything. And the Muslim part is says very simple: we are not accepting 1945, we are not accepting 1941. We want to start our request for restitution from 1872, when Austria occupied Bosnia. Thank you.
Thank you, Avicii, for adding more difficulty to our already torturous process.
Right. So first of all, thank you very much for the very good question about flight cases. I think it kind of touches the point I was trying to make. I was actually focusing more in my presentation about the ghetto list and the changes within the definition of the ghettos. But we have the same similar concept touching also on flight cases. So first I'll quickly answer legally, and then I'll answer, I think, politically, and then from there I hope that I've addressed your point. So legally speaking, although officially both in Israel and in Germany and worldwide one speaks about different categories of survivors. So in Israel, it's very well known in the public political jargon that we have two circles, the first circle and the second circle. And in the second circle, we mainly relate to these flight cases. This is legally totally wrong and pointless, because in 1973 already, the Supreme Court of Israel, in the case of Stein against the Authority for the Rights of Survivors, deferred itself for the first time for the Supreme Court decision in Germany regarding flight cases, which made it clear that a person would be defined as a Holocaust survivor under the BEG if he crossed a demarcation line. So the old German jurisprudence regarding flight cases was as follows: if a person fled from a Nazi-occupied territory to a third country, crossing an international demarcation line, he is to be seen as a Holocaust survivor under Article 1 BEG from the 50s. The Schlussgesetz that I've mentioned in my presentation basically made it an empty, what we call in Hebrew, an empty law. Because when the decision was given in the late 60s in Germany, there were no new applications possible. So that kind of led, I think, to the solution of 1980, the hardship fund, which supplemented the Article 5 of the Schlussgesetz, which was the special fund for those who escaped or came from Soviet territories or were not able to submit under the original BG. But to make a long story short, basically the difference as per the recognition of the flight cases depends on the jurisprudence. So whereas the German decision of the late 60s speaks about the need to cross a demarcation line, and thus irrelevant for those who come from the former Soviet bloc in many cases, in Israel, they are to be seen as survivor. But, and here's the small but, because they're to be seen as survivors only under the Israeli Nazi invalid law, it's again an empty group, because none of these people were able to come to Israel until the 1st of October 1953. And thus, they're excluded from the Israeli system and that Israeli court decision from 1973 to receive their pension. So, theoretically, under Israeli law, they are to be seen as survivors as all other survivors. Their only issue is that that's the definition of the Israeli Nazi invalid law, which is bound by this cutoff date of 1953. So basically, this belongs to the group of stories to be told or to continue to discuss, address, and find solution. How do we address actually that group after so many years? I think that in the last few years there has been a progress or a certain understanding of the need to address this issue from all relevant sides, and I hope that in your other hat, not as a viewer or listener, as negotiator, I do hope that you will have a lot of success in continuing the fight that is a well fought war.
Okay, thank you, Mr. Churches, for your remarks and for explaining further and complicating further the issue. But yes, I forgot to mention that 3 different positions and 3 different narratives about what should be the beginning of the first year of the restitution. But I don't know if it would be a good thing or a bad thing if the Serbian part would split from Bosnia for the Jewish restitution, because I personally don't believe that the Serbian part is the main issue in the restitution talk, or they would like to join Jews in the suffering during the Second World War, and they had right because they were victims and their property was confiscated as well. So many times among the Jewish documents you can find also documents of looted Serbian property as well. So sometimes they were usually located at different parts in the Ustaša regime, but sometimes those documents can be found together. And also to answer the question about the political sensitivity of Muslim-Jewish relations, yes, thank you. I forgot to mention it is a very important issue, because I believe as scholars and as human beings, we need to respect all the victims of the violent 20th century in Bosnia. But I believe that local Muslims do not want to assume the role of perpetrators in the Second World War, while in the archives it is rather clear that they were, along with local Croatian population, they were the one who appropriated Jewish property during the Second World War. It is very clear because the property was, after confiscation, was formally sold to the people. So you can actually see the names of the people who bought those Jewish shops and the other properties. So, and in Bosnia, it is very clear to distinguish according to the name, because each community is sticking to their names and last names. So according to name and last name, especially in I think in the Muslim case, you can distinguish the ethnicity of the people based on their names and surnames. But yes, it is a sensitive political question, because to begin, the righteous restitution of Jewish property in Bosnia, you will have the domestic population will have to face the high level of complicity with the Ustaša regime, that they are descendants of those people, so that their forefathers did. So I think it would be the most it would be the hardest part, that the first social recognition and then eventually the legal recognition maybe they will eventually agree to some kind of restitution law, but the part about social recognition of what happened, and that you cannot blame Nazis for everything. Well, Bosnia was formally independent state of Croatia was formally condominium of the Nazi Germany, the northern part and the southern part by the fascist Italy. However, the extermination camps, most of the, if not all, the extermination camps and in situ mass executions were carried out by domestic regime, not by the Nazis, when it comes to Bosnia. So you cannot blame the Nazis for what happened to they participated, they looted some of the Jewish movable property, especially, I would say. But when it comes to the immovable property, we should look inside the Bosnian realm, not find not find the perpetrators outside. So it would be the most difficult part to admit how much they participated in the Holocaust, I would say.
Thank you very much for the questions. I will start with question, Professor Fisher, about is there anything in the trials about movable property? In the civil cases, in civil trials, I looked, no. But let me say that I did not find all materials of these trials, only the core decisions. So in those, I'm only specifically referring to this real estate or stores. Or I started to look in criminal cases trials, so in war crime trials that took place. It seemed to be that there are more details there about the movable properties, including because there are more detailed, for example, testimonies from Jewish survivors or Gentile eyewitnesses who mention about some of these robberies of, including, Judaica or other movable property. And I think, if I remember correctly, there are also a lot of details about movable robbery, mass dispossession of movable property in the documents collected by the Romanian branch of the World Jewish Congress. They conducted a massive investigation in the country in 1945, collected tens of thousands of individual fish, a lot of data, including handwritten short or a bit longer narratives by survivors in their names, but also in the name of the families about the losses they suffered, including, of course, deportation, torture, killing, but also about property. So some of them refer to movable property too. That would be a good, I think, I just crossed my mind, that would be a good place to look for details about that. The second question about what happened with Jewish communal property or property belonging to Jewish organizations. So Antonescu regime expropriated that type of property as well. Not completely, but for sure. I mean, we know they expropriated sometimes Jewish schools, hospitals, even cemeteries. Even in Bucharest, it's a very famous case. Sevastopol cemetery in central downtown Bucharest was basically destroyed, somehow resembling, the fate of the Sephardic cemetery in Thessaloniki, Salonika. And after collapse of Antonescu regime, several, it's not clear how many, but many of these communal properties were returned, but gradually, only it took several years. How do I know about that? I mean, I read in some of the EGO documents, for example, the chief rabbi of Romania talks about that. But also, the problem is that the Jewish community and Jewish organization, they lose these properties again because of the communists, some through naturalizations, others basically in late 40s, early 50s, the community leaders, by now, the traditional Jewish leaders had been expelled away from the country. So the chief rabbi, Alexander Shafran, had to leave and flee the country. In 47, he is expelled. Wilhelm Filderman, the traditional leader, he also went into hiding and flees, maybe 47, 48. So there are new Jewish leaders of the communist regime, especially from the what might call local Yevsektia, the Jewish Democratic Committee. So basically they donate them to the state because the argument is that now that the Jews enjoyed equality under communist regime, they don't need this special institution, they don't need special schools or social institutions or hospitals because they benefit from all the public institutions. So actually Chief Rabbi Shafran mentioned that in his memoir that they also pressure him to donate them, but he refused. He said, no, these have been built throughout centuries. The community cannot just give away these institutions, social institutions. But basically they're lost by early 1950s. Most of them are gone, except synagogues, a few cemeteries.
I want to thank all our participants, all our panelists for giving really detailed, formative, really illustrating the scope of what we're working on today is sort of the child of the Luxembourg Agreement and how it has been providing a framework for opportunities and action that we're really in the process of maintaining and going on an ongoing basis. WJRO is doing a research project in Bosnia-Herzegovina as we speak, looking at studying property, both communal and individual property. We hope to make this area continued priority and focus for us, but it is one of the things that is, as you've heard, very difficult, very complex, and a very different set of circumstances, which is why I described as out of the box that we've been talking about earlier. So I thank all our panelists for illustrating that, for helping us understand it better, and helping shine a light on what is a current issue, not just an historical issue as well. I also want to acknowledge the presence of my colleague Nachliel Disson here, who runs our office in Jerusalem. And if you're anyone from Israel is interested in further work on this or further connection, Nachliel is always around, and is an essential part of our work on this as well. And not to say that it's the most important thing, but perhaps I'll extend our collective thanks to all the panelists and participants for keeping us on schedule. As a matter of fact, for letting us out for the coffee break even a few minutes early, considering we started a little late. That is not the least of the debt that we owe you all. Thank you.
Afternoon. We are sinking into the sixth session. I hope that you have comfortable seats. One of the challenges I had when I was still teaching, that was a lecture in a big hall, Thursday afternoon between 2 and 4, and with comfortable seats. So the students, I had to keep them awake. Anyhow, we are here in for the seventh session, not the sixth session, sorry, on subsequent developments of the Luxembourg agreement and recent campaigns. We have 4 speakers. You have their bios in the files you have, but there are people who are watching it via Zoom, so or later via YouTube, so I'll read also the short or longer bios of the people who will present. The first one is Wesley Fischer, with whom we are in touch already for many, many years. Dr. Fischer is the director of research for the Conference on Jewish Material Claims Against Germany, which in short is Claims Conference, and for the World Jewish Restitution Organization, the WJRO. He heads the Claims Conference WJRO Looted Art and Cultural Property Initiative, which works with governments, museums, libraries, archives, and other repositories of artworks in Judaica in cooperation with Jewish communities worldwide to encourage provenance research and claims processes worldwide. It's created projects to make the records of the Einsatzstab Reichsleiter Rosenberg, the ERR, the largest of the Nazi agencies confiscating Jewish cultural property, accessible and searchable, including the database of art objects and at the Jeu de Paume, which in expanded form is the basis for the Jewish Digital Cultural Recovery Project, and research on libraries plundered by the ERR. Is at present the founding member of the executive board of the Jewish Digital Cultural Recovery Project Foundation. He is also responsible for various archival projects, including the archives of the Claims Conference and the Victim List project of the Swiss bank settlement that supported the uploading to the internet and expansion of Yad Vashem's central database of Shoah victims' names. He's a member of the Scientific Advisory Board of the European Holocaust Research Infrastructure, which is usually known as ERI. And he will talk, and it's a long title, from the Jewish Restitution Successor Organization to the 2008 Jerusalem Declaration, the handling of looted cultural property by the Claims Conference. Wesley?
Well, while we're uploading, I like the tradition started in the last panel in which we're all supposed to say something odd about ourselves. I would say that in my case, it's mostly the fact that at least those of you who know British and American culture, you know that the name Wesley is rather unusual for a Jewish boy. The reason, however, I'm Wesley is because my parents named me in memory of a man named Velvel, and so it's spelt in the German way, W-E-W. So that's how that came about. Anyhow. So the first thing I want to say is that this presentation has 2 really sort of major aspects to it. One is that it was done by myself, but also with Dr. Ruth Weinberger, who is here, and anything that's good about this presentation goes to her. Anything that's bad, you should criticize me. In effect, the next thing is that I'm going to try to help you with sort of main points in all this, because many of the presentations so far have actually covered some of the things that are on the slides and that I had in the talk. So this may be a way of getting through the rest of the afternoon more quickly, but I can't guarantee that. Couple of main points. The theft in the Holocaust is generally much underplayed in Holocaust studies in comparison to the murder. That's for obvious reasons, but it's a problem in this field. The second thing is that not only was the Holocaust the greatest theft the world has seen, it was also an enormous attempt at what is called cultural genocide in Raphael Lemkin's terms that was discussed before. A third thing. The Claims Conference is generally viewed as historically having been focused on survivors and not really paying attention to anything else until the 1990s and the like. We've gone through the archives of the Claims Conference, and it isn't true, which is one of the interesting things in this, I think. Basically, if we go further on, there are 5 basic questions that ever since National Socialism came to power in Germany almost 90 years ago in 1933, and certainly after the decrees and events of 1938, these are basic or operational questions concerning cultural property that was plundered in the Holocaust that have faced Jews worldwide. The first is, what should be considered Jewish cultural property? The words looted art, just to be clear, generally refer not only to paintings and sculptures and the like, but they also refer to libraries, to Judaica, and so on. Secondly, how should the size of the plunder of Jewish cultural property by the Nazis, their allies, and collaborators be measured? The usual statistics that are used are 600,000 paintings, and there's 100,000 are missing. These were estimates at the Washington Conference in 1998, and they are guesses. The fact is that it's clearly in the millions. We know it's in the millions because the Monument Men alone gave back into Germany millions of objects. So it's much larger than that, but we don't really have a notion of the actual size. How to handle restitution of cultural property belonging to individual families and heirs. That's a fairly straightforward question, but it's an issue in various countries still. How to handle restitution of cultural property belonging to Jewish communities. Now, that is something which there's some debate about, and there's a certain amount of tension between the giving back of, or the restituting of, cultural objects to individuals and individual families, and the question of doing so to Jewish communities, whether those communities are defined as, for example, the State of Israel, or whether they're defined in other ways. Lastly, what to do with the unclaimed, quote, heirless cultural property. There really isn't anything that's heirless in that sense. Everything ultimately belonged to somebody, but it's a way of saying that the heirs can't be found. At least right now, they can't be found. So over time, the questions have remained the same pretty much, but the answers to them and policies in this area have changed. If we look at Jewish attempts in intergovernmental conferences, what we see is, of course, the hero of that aspect of this, namely Nehemiah or Nehemiah Robinson. Ronald Zweig dealt earlier with this and talked about this a great deal, so I can skip this. But basically, it was Nehemiah Robinson who tried to get the governments to listen. And after the conclusion of the Paris conference, after the war, Jewish leaders and organizations started concentrating their efforts on the restitution of property more specifically. In the immediate post-war period, the decision was taken that rather than continue to try to convince the governments, Jewish attention turned to convincing the US military. And it's in November 1947, as already mentioned here, that the US Military Law 59 was passed. The US military recognized what came to be known as the Jewish Restitution Successor Organization, or the JRSO, which we'll talk about in a minute. I'd like to note the following, which comes from Leora Bilski, who is one of the chair people yesterday. Leora Bilski of Tel Aviv University has argued that there were major changes in international law that resulted from the early Jewish attempts at restitution after World War II. And they are, in her words, quote, from individual restitution of private property to collective restitution to the victim group. That had not existed before. From a backward-looking return to the status quo ante to a forward-looking restitution as a means for cultural rehabilitation and reconstruction. In other words, not just looking backwards and giving something back to where it came from initially and the like, but also looking to where it might be used in the future. And this is, of course, a major issue given the tremendous demographic shifts in where Jews and in where Jewish scholars were. Lastly, from a conception of, quote, property that's focused on the economic value of the cultural objects to a more holistic understanding of cultural objects as aspects of a Jewish culture that was to be reconstructed and rehabilitated. So, the Jewish Restitution Successor Organization. This is important because you've got some people here who then led the claims conference. Benjamin Ferencz, the gentleman in the middle, I guess this doesn't show you on that, all right, anyhow. The gentleman in the front. Ben Ferencz was the Jewish Restitution Successor Organization's, JRSO's, first Director General. He later became a key negotiator for the claims conference and remained with the claims conference for some decades. At his side was Saul Kagan, whom we'll see photographs of in a moment, who served as the JRSO's secretary, and he later became the Claims Conference's longtime executive vice president. Ferencz and Kagan first met in 1946 and soon started to develop and administer an efficient system for the collection and distribution of assets on a worldwide basis. Mr. Kagan had an intricate knowledge of the German banking system and essentially of all the things that had gone into how the Germans had taken property from the Jews. And for the purposes of the Jewish Restitution Successor Organization, he had a temporary leave from the US Army, which he was working for. And through his efforts, he effectively mapped the landscape of Nazi looting and property crime in a way that paralleled the chronicle of capital crimes documented in the Nuremberg trials, which is what Ferencz was primarily interested in. The JRSO, in turn, grew out of the Commission on European Jewish Cultural Reconstruction, which had been established as a central research body in 1945. The most important publication, you may know, was the, quote, tentative list of Jewish cultural treasures in Axis-occupied countries, which listed the various treasures known to have existed before the Nazi occupation. And this was, we'll get to that in a moment, but the JRSO founding was not without opposition. The British allies feared that a Jewish organization would use any recovered assets to fund immigration into Palestine. And the Soviet Union simply said that the heirless assets belonged to the state. On the American side, it was General Lucius Clay, the American military governor, who promulgated in November 1947 Military Government Law 59, and essentially that was entitled Restitution of Identifiable Property. And although that was limited to the American zone, by December 31st of 1948, property worth some $250 million in then the price of the cash value, was restored to former owners living in some 60 countries worldwide. In Saul Kagan and report on the GRSO's activities covering 1947-1972, he noted that scarcely a major Jewish community in the world failed to benefit from the redistribution of these treasures. A substantial share went to Jewish communities in Western Europe and aided in their struggle for cultural and spiritual reconstruction. This is beginning to be interesting because as we'll see, with the Jewish cultural reconstruction, which was involved with JRSO, there came to be the idea that they were giving everything, or pretty much everything, to Israel, the United States, 40% to Israel, 40% to the United States, 20% to the United Kingdom and other countries, and basically not dealing with the question of the reconstruction of Jewish communities that had been
killed off, or had been terribly damaged by the Holocaust. It's not quite true. In any event, with the JRSO, at a certain point, the JRSO also distributed art objects. And these were secular art objects. They had come from Jewish museums, Jewish private homes that the Nazis had seized. And most of these objects were stored by the Americans in the Munich Central Collecting Point. In February 1949, the Munich Central Collecting Point transferred 11 crates containing nearly 700 art objects to the JRSO. These paintings were then shipped to New York in November 1949 and transferred to the storage rooms of the Jewish Museum in New York for further examination and appraisal by experts and art dealers. 35 of the paintings were shipped to the Bezalel Museum, now the Israel Museum, after they had undergone some necessary restoration. The remaining objects, among them 100 paintings, 150 drawings and prints, 200 miniatures, a number of carved angels in wood, and the like, they all essentially were put on auction, which is an interesting thing. So far as I can tell, this is the first auction by Jewish organizations that was ever held. And it comes before the Claims Conference, and it's at an earlier time. The definition of Jewish cultural property. There was controversy surrounding that auction, in particular since Mordecai Narkis of the Bezalel Museum would have wanted more objects, and he loudly voiced his displeasure. But the auction has also caused disagreements within the JRSO. In addition, it seems that the definition of Jewish art promoted by Stephen Kaiser, who was then director of the Jewish Museum in New York, prevailed. He defined Jewish art as a thematic category and, for example, did not consider paintings by Max Lieberman with non-Jewish themes as Jewish art. This definition influenced which artworks were auctioned off, both in this auction and then to some extent later on. Any definition of Jewish cultural property would need to draw a distinction between Jewish art and Jewish-owned art. But given that difference, there are and historically were diverging opinions how heirless Jewish-owned art should be treated and used, from auctioning off the cultural properties to displaying the objects in museums. It took until the 2009 Terezin Declaration for there to be a kind of definition that clearly included the question of Jewish cultural property, including sacred scrolls, synagogue and ceremonial objects, as well as libraries, manuscripts, archives, and records of Jewish communities, and the like. Jewish Cultural Reconstruction, or the JCR, was originally a research entity led by Salo Baron, by Hannah Arendt and others. It became the agent for the JRSO in 1947, but legally everything had to be signed off by the JRSO. And in effect, its policies were forward-looking, as I previously mentioned. It was forward-looking in the sense that it was following where Jews and Jewish scholars were likely to go. So that's the 40% to Israel and the 40% to the United States and 20% to the UK and others. As Jewish life in Europe has revived, there's growing resentment of those JCR policies. And that is actually part of what is seen as the assumption that everything that was being done, including being done ultimately by the Claims Conference, was following the same notions. But we'll see, it was actually not. So next, the Claims Conference is founded in 1951, and we've been discussing the Luxembourg Agreement, of course. The discussion up until now has been essentially all on Protocol 1, on the individual compensation to Nazi victims. This is a discussion about Protocol 2, the allocations program. So, in effect, you have for Protocol 2, the Claims Conference receiving the sum of 450 million Deutsche Marks, or about $110 million at the time, for relief, rehabilitation, and resettlement for the Claims Conference. And the Claims Conference Institutional Allocations Program was thus born. Now, I have a couple of things. We'll come back to this in a moment. But first of all, notice that the leadership of the Claims Conference had essentially had a lot of experience coming from the JRSO and the previous matters. So it's not, and of course Goldman also from the World Jewish Congress had that, but Nehemiah Robinson, Benjamin Ferencz, and Saul Kagan, clearly at least, they all had major leadership roles before the Claims Conference was founded, and that had a huge impact on the Claims Conference for the years to come. And I mean, Nehemiah Robinson passed away in '64, but Saul Kagan became executive director at the Claims Conference's founding in 1951, and he remained involved for the next 6 decades until his death in 2013. So it's quite a bit of influence. Now, on the 13th of March, 1952, the Claims Conference affirmed its position vis-a-vis unclaimed heirless property by noting that the organization was formed on the premise, quote, to guarantee that Jewish assets confiscated during the Nazi regime, for which there are neither heirs nor claimants, not remain with those who participated in or profited from the pillage, but be made available to representative Jewish organizations for the relief, rehabilitation, and resettlement of hundreds of thousands of needy survivors of Nazi persecution. The Claims Conference stance was therefore very much in line with that of the JRSO, which was its political and logistical predecessor. The Claims Conference is not a legal successor to the JRSO, but obviously there's a tie. In a 1964 report that was issued by Nahum Goldman and the Claims Conference, he recapped the organization's first dozen years by noting that in 1952, the main responsibilities were attaining 2 major objectives. 1, to obtain funds for the relief, rehabilitation, and resettlement of Jewish victims of Nazi persecution, and to aid in rebuilding Jewish communities and institutions which Nazi persecution had devastated, and 2, to gain indemnification for injuries inflicted upon individual victims. In other words, if you look at the idea of what it meant at the time for there to be relief, rehabilitation, and resettlement of the Jewish victims of Nazi persecution, you realize that a large part of this has to also be educational and cultural, and that's part of what I think I'm trying to drive at. The influx of money following the Luxembourg Agreement allowed the Claims Conference's allocation department to address the topic of cultural and education reconstruction, mainly by dedicating in its first couple of years around 15% of its cultural budget. The allocation grants focused above all on the revitalization of Jewish education and learning centers, as well as on the research and documentation of the, quote, Jewish catastrophe, word Holocaust was not yet used, carried out by institutions such as the Wiener Library in London, the Centre de Documentation Juive in Paris, the YIVO Institute for Jewish Research in New York. And essentially, there was funding to older institutions, indeed to countries, to about 10 countries around in Europe as such. And this was done in addition to the question of newer institutions and the like. The organization's 20th year anniversary issue noted that the transformation in Jewish life that took place in West and Central Europe in the course of the years 1954 to 64 is all but incredible. Of course, this is self-praise, but even so. In 1953, the Jewish community on the European continent, the bearers of historical traditions centuries old, were on the verge of destitute in many instances. Sacked and plundered at Nazi hands, their communal leaders, rabbis, teachers, and other officials, mostly murdered or driven off to overseas lands, their surviving members impoverished, their possessions accumulated in the course of centuries looted, their communal institutions razed or reduced to ruin. The prospect that they would ever flourish again within our own lifetimes seemed all but visionary. Of the $110 million in allocations granted by the Claims Conference between 54 and 64, 76% went for the relief, rehabilitation, and resettlement of Nazi victims, 20% for cultural and education reconstructions, and the rest went for administration and to cover the costs of the Israel purchasing mission. More than 90% of the allocation money granted to educational and cultural reconstruction was made to communities on the European continent. In all this, we have the salvage of Jewish cultural treasures, and essentially, after the Claims Conference was formed, they reached out to members of the JCR, in particular to Sela Baron, to include them in the organization's advisory committee on cultural applications. The JCR's participation, however, did not last very long. After disagreements, Baron gave up his position in the advisory committee. This may have been part due to the fact that the Claims Conference rejected the idea that they should support a project submitted by the JCR in 1953, which had asked for $71,000 and was aimed at identifying and microfilming approximately 1 million pages of Jewish material in European libraries. This was rejected not because it was a bad idea, but because this was already something that the Claims Conference was supporting through a variety of different institutions, I mean, including Yad Vashem, which we'll get to in a moment, but it was through a series of different types of organizations, and that indeed allocations were made to institutions and organizations in 10 countries: Belgium, Denmark, France, Holland, Hungary, Italy, Switzerland, United Kingdom, Yugoslavia, and the United States. Over 96% of the allocations were granted between 54 and 58, when the needs were most pressing, and the remainder between 1959 and 1963. Consequently, in 1958 and early 1959, the Claims Conference concluded that it had become the greatest single source of funds going all over the world. But in fact, it's sort of true. A substantial portion of these funds, as previously noted, went to the YIVO Institute and the Centre de Documentation Juive and the Wiener Library. And a lot of this went to microfilming and such. And in particular, also, there was a project to microfilm the archives in Amsterdam and in Budapest. And in addition, there was an idea that there should be a central catalog of looted Judaica and Hebraica in European libraries. This was brought about in part by the director of the Jewish section of the Royal Danish Library, who had proposed that all the heirless Jewish books should come to Copenhagen and be kept there. At the time that proposal was met with resistance from Jewish organizations saying that Jewish culture was dynamic and heirless Jewish cultural objects, foremost books and ritual objects, were to be used and not exhibited in museums. And Copenhagen was not a major center for this purpose. However, 10 years after the fact, the idea was refined somewhat, but it was taken up again. However, ultimately, the Claims Conference never published that catalog. Instead, the funds were used to replace books that were lost in Jewish institutional collections in France, Italy, and other countries. Overall, it can be said that in the 11-year span between 54 and 64, the Claims Conference allocations played a vital role in the reconstruction of the Jewish communities in Western and Central Europe, which had fallen under Nazi occupation, and in the expansion of other Jewish communities where Nazi victims formed a majority or a very substantial part of the Jewish population. Indeed, one of the main things is the founding of a new Jewish institution in a new land. And it was not, this was up and beyond the question of what was being done to help the reconstruction of these communities in Europe. So between 1954 and 1964, there was enough money to do this. Yad Vashem was established in August 1953 by the Knesset, and it benefited, however, from the money that was provided by Germany. On 6th of October 1954, the Claims Conference and Yad Vashem signed an agreement that defined their mutual relationship. The agreement stipulated that the Claims Conference would provide up to 1/2 of the total annual expenditures for the activities agreed upon by both partners. The government of Israel and the Jewish Agency were to provide the other half. Consequently, a joint committee was established by the Claims Conference and Yad Vashem that was authorized to review the construction plans of the archives building and of all programs to be undertaken in the future. On a content level, the Claims Conference placed special emphasis on Yad Vashem's Pinkas HaKehilot project, which was of particular importance to the Claims Conference, that it ensured its support would extend beyond the period of the organization's own existence through the Memorial Foundation for Jewish Culture. And in general, the assistance given in this was quite great. It included payments for the gathering of the archives of Vienna's Documentation Center, the Slovakian Jewish Department of Documentation, the Jewish Historical Committee in Munich, and the underground ghetto records of Warsaw and Bialystok, as well as files of the Reichskanzlerei and the Einsatzgruppen. This was followed by the microfilming of the International Tracing Service. Those of you who are from Yad Vashem may recall that there are these earlier microfilms. A collection of 21 million cards and documents, which was defined as casting a light on the fate of Jewish concentration camp prisoners and slave laborers, numbering some 3 million. The anticipated end of the Claims Conference. Don't say Kaddish yet. From the early 1970s until the mid-1990s, the interest in Holocaust-related matters was seen to subside. The 1979 Claims Conference report noted that the conference objectives in the field of relief and rehabilitation of Jewish victims of Nazi persecution have essentially been achieved. And in effect, there was this expectation that the Claims Conference would close its doors. The last payments from all of this in the Protocol 2 came forth in the 1960s, and therefore there was a question as to whether or not the Claims Conference would continue. There was establishment of the Memorial Foundation for Jewish Culture in 1965 by the Claims Conference with its last allocation money. The Memorial Foundation was envisioned to serve as a living memorial to the 6 million Jews and to reconstruct Jewish cultural life around the world. But it kind of didn't happen this way. I don't mean the Memorial Foundation, it's just the more general matter. You have the end of the JRSO during this period as well. The JRSO took over JCR in 1951, as we've discussed. In 1952, the JRSO uncovered a collection of 400 paintings in Berlin that were important. But by 1975, the JRSO gradually handed over its responsibilities to the Claims Conference. In 1984, there was a Judaica auction at Sotheby's that suddenly meant that the JRSO was brought back to life for a short period of time. These were books that had been taken from the rabbinical seminary in Berlin, the Hochschule für die Wissenschaft des Judentums, and they were, surprise, surprise, the books had all been taken to New York and were in the possession of Dr. Alexander Gutman, later a professor emeritus at Hebrew Union College, who had smuggled the books out of Germany and into the United States. Basically, the discussions about this with the JRSO, he wanted to put the books on auction, but what happened in the courts was that the JRSO recommended that the disputed Judaica should be handed over to a newly established foundation, the Judaica Conservancy Foundation, consisting of the Jewish Theological Seminary of America, the Yeshiva University in New York, the Hebrew Union College in Cincinnati, the Hebrew University in Jerusalem, the Leo Baeck Institute in New York, as well as the Leo Baeck Institute in London. I don't know why the Leo Baeck Institute in Jerusalem is not included, but anyhow, in terms of things that started happening during this period, remember the expectation is that the Claims Conference is going to close its doors. One of the things that was clearly most major was the reunification of Germany. The Claims Conference did make attempts throughout the 1970s and 80s for there to be some contribution to this, to all of this by the GDR. However, that really didn't go forward. But finally, in 1990, Chancellor Kohl assured the Claims Conference that a unified Germany would uphold its commitment to restitutions. And eventually, Germany made the 30th of June 1993 the filing date deadline for movable property, including cultural and religious objects. And the Claims Conference was named the successor organization. There wasn't any real need for the JRSO at that point. It's time, yes, I understand. Okay, I knew this was going to happen. All right, you're going to have speed, we're going to have speed reading. It's not going to be reading even. All right, so there was in East Germany, there was created a successor organization. There were artworks that were claimed and so forth. Interesting, this particular picture is of a weather vane that was in a synagogue in a small town near Berlin that the community no longer existed, the synagogue no longer existed. Nobody claimed this, and this therefore was on loan, it still is on loan from the Claims Conference to a local museum. In effect, all of the matters in regard to this type of property in the GDR have been resolved over the years, and that's no longer such an issue as such. There was also, as we've heard now before, the Committee on Jewish Claims Against Austria, and this also is a major matter, but let me say that it doesn't really actually go into full action and get something done in Austria until we get to the 1980s and the fact that the holding of many artworks and such in the Mauerbach Monastery was a scandal. That's the reason why there's this article in 1984 by the Art News on the legacy of shame as to the fact that these have not been distributed and are still in the possession of the Austrian government. And there are various other things, but in 1996, we come to the Mauerbach auction. The Mauerbach auction in 1996 did give the possibility to people to make individual claims, and it also worked so that there was then the sale of a great many things that remained, and the sale provided some $14 million, if I remember correctly, that were made available then to survivors from Austria. The problem is that after the Mauerbach auction ended, Sophie Lilly and others, experts in this field, showed that in fact, the Austrian government had simply not been showing a great many of its archives, and that in fact, the owners of these pieces were known. There was an exhibition on this finally in December 2008 and 2009 at the Museum of Applied Arts in Vienna, showing that many of the Mauerbach objects had traceable original owners. So we now come to, other things. You heard already about the establishment of the World Jewish Restitution. I have to stop. Okay, then let me tell you, if we go to the conclusion, you've got to give me a little time, because otherwise I can't tell you what the nature of the conclusion is. But if you want, but it's fine. I'll be like a vaudeville person. You can say. I tell you what, ladies and gentlemen, in terms of this, I want to essentially go forward with the return of the attention to looted cultural property in the 1990s. But what I want to talk about in particular is how, at the present time, there are actually initiatives to try to resolve the tension between communal and individual cultural property, and I'll do that when you want me to do it. It's fine. Okay, thanks very much.
Thank you for this presentation. I just wanted to mention that in a PhD thesis that I supervised by Boaz Cohen, that was later published also, he showed that indeed, the Claims Conference gave Yad Vashem during this first decade its half, but the State of Israel did not give its share of the budget. And the Ron here. Yeah, okay, but so that is regarding funding and So our next speaker will be Ovidio Kreanga. Dr. Kreanga, who got his PhD from King's College in London, is a historian at the Conference on Jewish Material Claims Against Germany in New York. In this capacity, he supports ongoing efforts in the area of compensation for Shoah survivors, commemoration and restitution. He also coordinates the writing of the history of the Claims Conference and its compensation programs for a multi-volume series titled The Years in Compensation. Before joining the Claims Conference, he was a researcher at the United States Holocaust Memorial Museum, where he documented the fate of Jewish and Roma victims of persecution during the Shoah in Romania for the museum's Encyclopedia of Camps and Ghettos. We also, on a personal level, cooperated a lot in a project that I will mention in my closing remarks later on. He will talk also a long title, From Protocol 2 to Germany's Last Gesture, Legal Precedent, Uncompensated Shoah Survivors, and the Creation of the Hardship Fund in 1980. Ovi, here you are.
If I had known the state of my voice when I wrote this paper or before I came, I would have shortened the title and I would have shortened lots of everything else. Ladies and gentlemen, please forgive my voice. I feel absolutely fine. But a soccer game before leaving my home where my son was playing, and jet lag and a million other wonderful conversations since I got here has produced this incredible rusty voice. So just bear with me as I'm trying to make my way through this paper. I want to extend my thanks again, Professor Stamper, for this fantastic conference. I told him earlier that if he needs any evidence that this conference was so successful, you don't have to believe anything I say, just listen to my voice. And he said that he will provide me with some, Google Moogle solution. So if anybody has some Google Moogle, I will be willing to take it. Anything just to repair this. So with that as an introduction, let us go forward. The topic of my presentation today is about the Hardship Fund that was established in 1980 between Germany and the Claims Conference. And I have to say I benefited already from so many other discussions, including Dr. Wesley Fisher's presentation, which I think gives us some context to what I'm about to say. Established in the 1980, the Hardship Fund was the first and perhaps the longest fought-over compensation agreement concluded between Germany and the Claims Conference since the Luxembourg Agreement of 1952. The German government committed in Luxembourg to giving the Claims Conference a lump sum of 450 million Deutschmarks for assisting Jewish Shoah survivors outside Israel. This global payment, enshrined in Protocol 2 of the Luxembourg Agreement, was, in the words of the Claims Conference President Dr. Naum Goldman, truly revolutionary. Its chief importance, beyond the financial aspect, being that, and I quote, it establishes a precedent of major significance for the future, end of quote. Yet Protocol 2's impact on subsequent agreements between Germany and the Claims Conference has remained largely unexplored. Has the Protocol 2 agreement ever served as a precedent to conclude later agreements? In this short paper, I seek to demonstrate that the conference not only used Protocol 2 as a legal precedent to frame the Hardship Fund agreement, but that it proposed terms for the Hardship Fund that closely resembled those of Protocol 2. Germany's repudiation of this framework in favor of an entirely different agreement, an agreement that forever changed the nature of the Claims Conference, is discussed in the conclusion of this paper. Negotiating after negotiations. As Carol Fink has aptly observed, the creation of the Hardship Fund entailed negotiating after negotiations. The expansion of the German federal indemnification legislation of 1965, coupled with hundreds of millions more Deutschmarks spent in global agreements with Western countries and payments to Central European countries for victims of pseudo-medical experiments had dampened German sentiment toward Jewish Holocaust survivors streaming into the West from behind the Iron Curtain after 1965. German expenditure and fulfillment of the Luxembourg Agreement commitments grew by 1977 to over 61 billion Deutschmarks, further complicating the prospect of a new agreement. Numbering into tens of thousands, these Eastern European Jewish survivors would have applied for German compensation had they not inadvertently missed a series of deadlines set by Germany. As a result, they were excluded from federal compensation through no fault of their own. Like the earlier wave of Jewish Holocaust survivors hailing from Eastern Europe, namely the so-called post-1953 group, those emigrating after 1965 represented an ongoing problem for both Germany and the Claims Conference. As early as 1953, Germany started arguing that in Protocol 2, it had provided money for the needy survivors uncovered by the indemnification program and should not be asked to do more. The conference rejected from the beginning the notion that it accepted the Protocol 2 money, the 450 million Deutschmarks, as a fund to meet individual compensation claims inadequately covered under existing German legislation. It also stressed its organizational limitations in handling large volumes of individual claims. Thank you so much. Is this the Shmuga Google? No, a version of it? Okay. Shmuga Google. Great. Google. Okay, cool. Germany is saying that basically we provided money for needy survivors in the Protocol 2 fund. The conference rejected from the beginning the notion that it accepted the Protocol 2 money as a fund to meet individual compensation claims inadequately covered under existing German legislation, and also stressed its organizational limitations in handling large volumes of individual claims. In the Claims Conference's view, the moral, if not legal, obligation to compensate the post-1965 survivors rested with Germany alone. The Claims Conference's attitude had for years enraged German officials at the federal and Länder levels. It equally infuriated Jewish organizations in Germany, whose demands for money from the Protocol 2 fund for assisting their needy Shoah survivor members went unheeded. Understandably, frustrated survivors wrote the German Ministry of Finance complaining that they received no financial assistance from the Claims Conference. In response to pressure, Germany amended the 1965 Federal Indemnification Law, the BEG, to offer limited benefits to the survivors who had emigrated to the West before 1965. But it categorically refused to extend those benefits to those escaping after 1965 from places like Romania, Poland, Czechoslovakia, and the Soviet Union. That law was final. The Claims Conference allocated considerable sums for emergency aid and immigration assistance to the post-1953 group from its Protocol 2 fund. But by the mid-60s, most of the Protocol 2 money had been allocated or was earmarked for contractual obligations, and therefore the conference was in no financial position to assume responsibility for the post-1965 group. Thus, given the conference's lack of discretionary funds and Germany's refusal to reopen the BEG, the conference had no choice but to urge Germany to alleviate the needs of these uncompensated Jewish survivors. And indeed, in 1972, the conference formally submitted to the German government a list of demands, calling, among other things, for the creation, and I quote, of a special fund for post-1965 migrants, Nazi victims, who took their departure from Eastern Europe before December 31st, 1965. Carol Fink and Marilyn Henry, and including Rachel Blumenthal, who is here in this room with us, have provided valuable accounts of the lengthy negotiations between the conference and Germany over the hardship fund. Their accounts, however, do not examine the role of Protocol 2 agreement in shaping the Claims Conference's approach to the hardship fund. As such, the use of this legal precedent in the extensive negotiations for the new fund has remained unknown. Protocol 2, Article 2 of the Luxembourg Agreement permitted the conference alone to set priorities of spending. It stipulated that the amounts Germany paid to the Claims Conference, I quote, will be used for the relief, rehabilitation, and resettlement of Jewish victims of National Socialist persecution according to the urgency of their needs as determined by the conference. By drawing inspiration from this article of Protocol 2, the conference sought to secure a new agreement for the hardship fund that would allow it once again to decide how to spend the funds on uncompensated survivors without interference from the German government. But what did the conference determine the survivors' urgency of need to be in 1978, when negotiations drew near the end? And how did it go about ensuring that it has the freedom to allocate solely according to its judgment? Naum Goldman, the Hardship Fund's chief negotiator, envisioned in December 1977 spending less than a third of the anticipated 540 million Deutschmarks, as was offered in 1977, on survivor relief. Being a legacy-driven character, this is very important to stress, being a legacy-driven character, Naum Goldman thought that more than two-thirds of the fund should go to the Memorial Foundation for Jewish Culture for distribution to the Museum for the Diaspora in Tel Aviv, the building where we are today. The establishment of an endowed chair in Jewish studies at Heidelberg University in Germany, and for programs to combat anti-Semitism. He presented this spending proposal to the German State Minister Hans-Jürgen Wisniewski during their meeting on December 20, 1977. The proposal quickly attracted the gentle critique of Sol Kagan, the conference's executive director, who warned Goldman against allocating too little for the survivors' relief needs, saying, and I quote, "Don't you think it may appear strange and possibly be used as an argument against the urgency of the entire proposal that we are playing down the importance of the individual beneficiaries of the fund by reserving less than 25% of the total for that purpose?" Goldman eventually acquiesced to Kagan's call for higher relief spending, thus underscoring the conference's assumption that it would be allowed to determine the fund's distribution, as was true in Protocol 2. Wisniewski, representing the ruling Social Democratic Party in the governing coalition, allowed that much to be understood by not commenting on Goldman's allocation plan. He focused instead on the need for Goldman to secure the support of the two other parliamentary parties, particularly the backing of the opposition Christian Democratic Union, CDU, for a bill needed to pay for the new fund. From Protocol 2 to Protocol 3, finding the right legal tool to ensure the Claims Conference controlled the spending of the fund turned out to be an engineering matter that played well to the strengths of Sol Kagan. Kagan gained the reputation of someone who could turn Goldman's grand designs into reality. Unsurprisingly then, it was Kagan who recommended in the summer of 1978 that Goldman seek from the German government the closing of a new protocol resembling Protocol 2. Kagan called this pact Protocol Number 3. In a confidential letter to Goldman dated August 15, 1978, Kagan admitted, and I quote, "Giving a great deal of thought to the formulation of the agreement which you expect to reach with Schmidt, Kohl, Genscher, and Strauss." Since the terms, these are all highly influential characters, future chancellors, existing chancellors, future chancellors, and presidents of the state minister president of Bavaria. Since the terms of the agreement had yet to be formulated, Kagan wrote Goldman, "It is important for you to be ready with a document of your own before they come forward with their drafts. I therefore suggest that you propose the signing of a Protocol 3, which would follow the format of Protocol 2, signed in Luxembourg by you and Dr. Adenauer on September the 10th, 1952, covering the payment of 450 million Deutschmarks to the Claims Conference." Now, modeling Protocol 3 after Protocol 2 would produce, in Kagan's words, a very brief document that provides for the modus of payment, reporting requirements, and a mechanism to deal with disputes. Beyond its simplicity and clear procedures, however, casting the Hardship Fund agreement, as was conceived at that point, after the Protocol 2 terms, guaranteed the Claims Conference's independence and allocation. and I quote, "The crucial language from our point of view," wrote Keegan, "was the right of the Claims Conference to decide on the distribution of the funds." Building on precedent was another feature Keegan highlighted in his proposal for the new pact, telling Goldman, "The suggestion that your new agreement should take the form of a Protocol 3 should appeal to the German political leadership, for it follows a precedent which the same political parties approved in the past, and it enables them to draw a Schlussstrich under the entire subject without involving them in the future." Keegan appended a copy of Protocol 2 and the first draft of Protocol 3 to his 1978 letter to Goldman. And here you have the first draft of the so-called Protocol number 3. The two protocols, the original Protocol 2 and the drafted Protocol number 3, shared a great deal of language and phraseology. They differ substantially in the explicit addition of cultural investments to the use of the hardship fund, which of course was a significant change from Protocol 2. The conference's wish to decide alone the allocation of the anticipated funds was penned down in this first version of Protocol 3, Article 2 as follows. The amounts paid to the conference on Jewish material claims against Germany will be used for A. Jewish victims of National Socialist persecution who are largely and totally excluded from the benefits of existing German indemnification legislation, in accordance with their urgency of needs as determined by the conference, and B, for projects designed to restore and replenish Jewish cultural values and resources destroyed by National Socialism. Keegan stated the two areas of distribution, relief and culture, in broad enough terms to allow the conference not only to determine priorities in welfare spending, but also to make block payments to the Memorial Foundation, as well as for specific projects for which Dr. Goldman had prior commitments. In terms of percentages, this Protocol 3 version envisions spending 60% of the 600 or 540 million that was discussed at that point on welfare and 40% on cultural projects. The agreement with Germany was thought to be reached by the end of 1978 and payments to begin in April 1979. Yet another year had passed before negotiations advanced towards the finish line. Eyeing a potential conclusion by the end of 1979, Keegan wrote Goldman again in September of that year with information on the likely number of beneficiaries for the new fund. He again emphasized that Goldman should seek from the Chancellor's cabinet an agreement that the funds be paid to the Claims Conference, and I quote, analogous to the Hague Protocol 2, end of quote. Attorney Ernst Katzenstein, the Claims Conference representative in Germany, revised Keegan's Protocol 3 draft and produced a more lawyered version, which indicates that the notion of a hardship fund agreement resembling Protocol 2 was still operational in 1979. And here you have Katzenstein's revision or revised version of Keegan's version. Katzenstein's version of Protocol 3, which Keegan also showed Goldman, made no indication of how the conference was to divide the money between the approximately 75,000 post-1965 Holocaust survivors presumed eligible for the fund and the conference's cultural and educational projects. I leave this to you, said Keegan, as you are the father of this fund. We're moving now to the next section called a hardship fund agreement without Protocol 2. The proposal for a final redress gesture toward Jewish Nazi victims was introduced in the Bundestag session of December 14, 1979. The 440 million spending fund was designed the 440 million spending fund was designed to compensate individual needy Jewish victims who were ineligible for the BEG indemnification because they arrived in the West after 1965. Thanks to Goldman's assiduous work leading up to that date, the bill for the new fund enjoyed broad political support. Yet, few German parliamentarians accepted Goldman's spending proposal. So the resolution that emerged from the Bundestag drastically reduced the conference's freedom to allocate funds beyond welfare. Shortly after this became clear, on December 27, 1979, a relentless Kagan telegraphed Goldman saying, "After review of December 14 Bundestag resolution signed by Kohl, Zimmermann, Wegner, and Michnik, I believe your major problem will be to persuade CDU, CSU to modify limitation on the use of funds which are restricted in the resolution to compensate," this is the citation in the resolution, "to compensate for hardship in individual cases. In this connection, I suggest you stress Hague Protocol 2 precedent, wherein federal government agreed and Bundestag ratified provision that the 450 million Deutschmarks be distributed by the Claims Conference for relief, rehabilitation, and resettlement of Jewish victims of national persecution, in accordance with urgency of their need as determined by the Claims Conference. From the start," and this is still part of the same citation, From the start in 1954, Claims Conference allocated portions of funds for cultural programs. Approximately 15% of the conference allocations went for cultural activities as part of the rehabilitation of Jewish communities and cultural life destroyed by Nazis. Would rather urge German government should adhere to the Hague precedent and place responsibility upon Claims Conference for distribution of funds and establishment of priorities and criteria for individual hardship payments. These are very complex internal Jewish problems which Bundestag would be advised to avoid. And I think we would still agree with that. It is clear from Kagan's response, end of quote. It is clear from Kagan's response that the diversion of money for cultural allocations had become a sticky point for German officials. In his formal reply to the December 14 Bundestag resolution, Goldman carefully avoided confronting the Germans over cultural allocation. He mentioned in this regard only that it would be to the advantage of the federal government to let the Claims Conference decide how to distribute the funds, thereby avoiding criticism and additional demands. As a precedent, he concluded in his letter, I quote the text of the agreement between the federal government and the Claims Conference after the conclusion of the negotiations at The Hague. There it was determined that the sum made available to the Claims Conference should be used for relief, rehabilitation, and resettlement of Jewish victims of Nazi persecution in accordance with urgency of their need as determined by the Claims Conference. The following months, end of quote, the following months saw a few more meetings between Goldman and German officials, but the Protocol 3 language, namely compensation for the uncompensated and cultural investments, gradually gave way to Germany's framing the fund after its BG language of damage to health, leading to hardship in individual cases. The German cabinet decided at its meeting on July 25, 1980, the division of the 400 million Deutschmarks fund between the Claims Conference, which was to receive 400 million of the fund, and the Zentralrat in Germany, who was to receive 40 million, and earmarked another 5% from the conference's share for spending on institutions offering services to the survivors. The agreement provided no money for cultural spending, which clearly departed from Goldman's vision for the fund. It also made it a precondition that the Claims Conference administers the payments, which was a clear departure from the conference's vision of having the freedom to determine the allocation, not to administer payments. Nevertheless, the Claims Conference accepted the terms half-heartedly, and Chancellor Helmut Schmidt signed the agreement in Bonn on October 3, 1980. A day before the publication of the fund's guidelines in the Federal Gazette, which was scheduled for October 14, 1980, Katzenstein met with the Finance Ministry Director, Dr. Bruno Schmidt-Bleibtreu, to clarify the terms of the new fund, which the Claims Conference was to administer under German guidelines. It emerged during their discussion that the German officials had decided to strike down the use of Protocol 2 as a framework for the hardship fund. There will be no reinstatement of the Hague Protocol 2, wrote Katzenstein in his minutes of the October 13 meeting at the Ministry of Finance. According to Schlipp-Bleibtreu, this was because groups of persecuted Jews from around the world had written letters of protest to the German government, to the federal government, This was because groups of persecuted Jews from around the world had written letters of protest to the federal government that these provisions had not, as intended, gone primarily to individual persecuted Jews, but rather to Jewish organizations. End of quote. Consequently, in another quote, all parties involved, the federal government, parliament, and parties, had jointly expressed the view that there could be no repetition of the determination on the issue stated in the Hague Protocol No. 2, by which the Claims Conference could allocate funds according to its judgment. End of quote. With that decision, the German government put to rest its frustration with the conference over its use of Protocol 2 money. So in conclusion, the Protocol 2 agreement remains singular in the history of negotiations between Germany and the Claims Conference. The conference tried and failed in its attempt to frame the Hardship Fund agreement after Protocol 2. Germany's refusal to allow the Claims Conference to decide the allocation of the Hardship Fund constituted the key departure from Protocol 2. Even so, the Hardship Fund agreement was historic and set a precedent of its own. Beyond the fact that it transformed the Claims Conference into a global payment processing and payment distribution organization, it also established a format that shaped subsequent compensation funds. All the major compensation programs that the conference administers today are informed by German guidelines. This principle still holds, even when negotiations between the conference and Germany result in expansions to a fund's initial terms. Thanks to these negotiations, the Hardship Fund to date has benefited over 500,000 survivors, nearly 7 times the number estimated in 1980, and has paid out more than $1.4 billion, far beyond the initial sum of 400 million Deutschmarks. If the signing of Protocol 2 birthed the Claims Conference into existence, the conclusion of the Hardship Fund agreement extended its life well into the future. Thank you very much.
Thank you very much, Ovidio. And we'll proceed to the third paper of this session by Dr. Meir Benaya, who is the head or chief historian at the Holocaust Survivors' Rights Authority of the Ministry of Social Equality in Israel. He received his PhD from Tel Aviv University, so here on this premise, in Jewish modern history. He's the author of the book Moshe Almoznino of Salonika, which was published by Tel Aviv University in 1996. He published recently A Philosopher in the Stock Market, Ethics and Capitalism in 17th Century Amsterdam in Joseph Penzo de la Vega, Confusión de Confusiones. Was published in Studia Rosentaliana, where I'm also on the editorial board. So he will talk on a shorter topic, Holocaust compensation for North African and Middle Eastern Jews. The title is shorter. We'll see if the presentation will be short. Okay.
Dear Professor Wünschmann and colleagues, dear guests here with us and online. The increasingly widespread idea that the limits of the Shoah transcend the borders of Europe has raised the awareness of non-European communities in Israel to the possibility of claiming benefits from the State of Israel pursuant to the Person Disabled by Nazi Persecution Law from 1957. The purpose of this lecture is to present key historical considerations that emerged in the complex process that eventually led to the recognition of citizens from Tunisia and Libya under the terms defined by the 1957 law, while rejecting the claims of citizens from Morocco and Iraq by both the government and the Supreme Court. I have a few preliminary comments. I am aware that my talk is related to one of the most sensitive issues in our society. That's why it's important to define the context of my lecture. The context was well phrased by the Honorable Judge Daphna Barak Erez at the beginning of the Supreme Court. It's okay. The context was well phrased by the Honorable Judge Daphna Barak Erez at the beginning of the Supreme Court's decision concerning the Farud. I quote, "The question presented to us does not pertain to recognition of the victims' unbearable pain or the fact that they were victims of terrible hatred and incitement. It also does not relate to the place of the Farud in the national story of Jewish persecution in the diaspora in modern times, or to the memory of the Holocaust. These issues, with their undeniable significance, shall be left to the historians, sociologists, educators, and policymakers. We, however, are required to answer a different question, a narrow legal question. Are the Jews of Iraq who were victims of the Farud eligible for compensation under the terms of the 1957 law?" Unquote. I shall speak today not as an objective observer armed with a theoretical and critical apparatus, but rather as a historian on behalf of the Holocaust Survivors' Rights Authority, which took part with expert scholars and legal advisors in formulating the position of the state in these issues. So let's start with Iraq. In September 2009, Jews from Iraq began to file claims. The basic argument of Iraqi Jews was that the Farud on June 1 to 2, 41 was carried out under a Deutsche Veranlassung, namely instigated by Germany. The historical legal dispute centered on two main questions. What was the affiliation of Nazi Germany with Iraq at the time of the Farud? And what wage did German propaganda originating from Berlin bear on the executors of the pogrom? Iraqi Jews sought to prove that in April, May 41, during the reign of Rashid al-Kalani, Iraq was a type of satellite state of Germany. They emphasize the significance of Nazi propaganda originating from Berlin for Iraq and the affiliation with Germany and its anti-British elements. The representative of the state, in contrast, claimed that no link was formed via orders or instructions between Germany and Iraq during the rule of al-Kalani, not to mention previously or subsequently. They also claimed that the German propaganda was no more than a secondary cause among myriad old and new causes of the pogrom. They also claim that the German propaganda was no more than a secondary cause among myriad old and new causes of the pogrom, that German propaganda is not sufficient proof of a Deutsche Veranlassung over the Iraq regime. Moroccan Jews in Israel began to file claims in September 2012. The basic argument of Moroccan Jews was that from June 1940 to November 1942, the Vichy government had imposed on Moroccan Jews restriction as part of a policy resulting from the French process of surrender to Germany and from Germany instructions. In the legal debates conducted in the appeal committees, the historical disputes primarily address two questions. First, was Vichy France a satellite of Germany, or was Morocco under any German initiative, instruction, or compulsion? Second, the extent and meaning of the persecution of Moroccan Jews and whether it constitutes a deprivation of liberty or only restriction of liberty. The parties were also disputed regarding specific historical questions as the extent of Jewish dismissals from public service in Morocco and which cities were subject to the Dair, the Sultan order from August 22, 41, that forbade Jews lacking French citizenship who arrived in European quarters after September 1st, 39, from living or holding property there. Honorable Judge Aaron Sadeh, chairman of the appeal committee, summarized the debate in his decision. I quote, "Even if we accept the appellant's claim whereby it should be accepted that the Vichy regime indeed operated under German initiative, even then, Moroccan Jews cannot be recognized according to Section 43 of the German law, as Moroccan Jews themselves were not subjected to deprivation of liberty as defined for the matter of eligibility for compensation." After reviewing the claims of Iraqis and Moroccans, the Holocaust Survivors' Rights Authority rejected them, and the appellants turned to appeal committees in Haifa and Beersheba simultaneously under the Person Disabled by Nazi Persecution Law of 57. Ultimately, both appeal committees rejected the appeals of Iraqi and Moroccan Jews after they discussed in depth the evidence, expert opinions, and details inquiries presented to them. Finally, the Supreme Court as well rejected the appeal of by Iraq Jews on March 2019 and of Moroccan Jews on August 2091. 21. As a result, they were compelled to relinquish the monthly payment, a minimum amount of 2,500 Israeli shekel to a maximum of 11,000 Israeli shekel, and other benefits granted to those persecuted by the Nazis. On December 2015, in the midst of the discussions, the Minister of Finance reached an administrative decision constituting a type of recognition of the suffering undergone by victims of the Farud and of Moroccan and Algerian also Jews. The administrative decision recognized them as victims of anti-Semitic and racial harassment during the Second World War. Based on this decision, they are eligible for an annual grant of 6,500 Israeli shekel and free medication, requiring only a self-declaration. You can see the number of Iraqi, Moroccan, and Tunisian Jews among the presently recipients of an annual grant and free medication. There is no doubt that the struggle of the Jews of Iraq and Morocco was also about recognition. They wanted to obtain a symbolic achievement and not just a material one, as Josep Brunner explained yesterday in another context. My impression is that some people are very disappointed with the results. They wanted everyone to recognize the importance of the Kristallnacht of the Iraqi Jews. Others receive the annual grant and say to themselves, we are Holocaust survivors too, not only the Ashkenazim. Tunisia. The first claims by Tunisia were filed in 1996. Tunisian citizens of Israel who had immigrated to the country before October the 1st, 1953, and had been living in Tunisia during the German occupation from early November 42 to early May 43, are eligible for compensation from the State of Israel, similar to other Jews who had been within the territory of the Third Reich. But Israel did not see itself obligated to pay compensation to those Tunisian Jews who had foreign citizenship, French, Italian, or even Tunisian citizenship, as by virtue of this citizenship, they did not fit the BEG definition of persecuted persons. And therefore, it was not the reparation agreement, but rather their foreign citizenship that barred them from eligibility for German compensation. This obstacle was removed gradually following various court rulings, Zimbri, Khalifa, and Muscati. Hence, an administrative decision by the Minister of Finance again from 2014 determined that a Holocaust survivor shall not be barred from recognition by law only due to his foreign citizenship, so long as he is not receiving compensation from that country. For 50 years, no law was legislated in Israel regarding the Holocaust survivors until the law of benefits to Holocaust survivors from 2007 was enacted. Based on this law, a Tunisian who arrived in Israel after October the 1st, 1953, and therefore the law from 1957 does not apply to him, could be recognized by declaring that he had been in a German camp in Tunisia, or had accompanied one of his parents to a site where they performed hard labor for the Germans, or that his mother has been pregnant with him when she did hard labor. Those Tunisians who do not declare this are eligible only for annual grant and free medication. 6,000 Tunisians have received annual grant. Libya Libya was the only country in North Africa that had been under Italian rule. But the massive military presence of the Wehrmacht in Libya, due to the war that took place in its territory between the British and the Germans, generated circumstances where Germany motivated Italy's policy concerning the Jews. Notably, Jews from Libya who had been in the Jado camp, where some 500 Jews died of typhus, were recognized in the 60s by the German under the BEG. This precedent was very important for the recognition of Libyan Jews by the State of Israel. In 1984, increased considerably the number of Libyans who filed claims. In the late 90s, the authority began a gradual process of expanding recognition of Libyan Jews. At first, deportation within Libya and outside Libya, as well as concentration and labor camps in Libya, were recognized. At this stage, the authorities still reject claims filed by Libyans who had fled to the village, mainly from the city of Tripoli, for fear of the Germans due to the Allied bombings. On April the 1st, 2010, the Taya ruling was the first to recognize the possibility of applying the rule of fear to Holocaust survivors from Libya. Following this ruling, in September 2010, those who had fled to the village for fear of the Germans were also recognized through an administrative decision by the Minister of Finance. Notably, it was in this case, that the administrative decision device was utilized for the first time to expand the spheres of recognition to new groups of Holocaust survivors. These include not only Jews from North Africa, but also from Romania and Bulgaria, as well as German residents who had previously been prevented from claiming recognition by Israel. You can see here updated data, the number of Tunisian and Libyans among the survivors presently having rights by Nazi persecution law from 1957. And now you can see the small number of Tunisians and Libyans among the survivors presently having rights according to the 2007 law. In conclusion, please look at the graph that represents the budget of the Holocaust Survivors' Rights Authority. A budget that has grown almost 4 times in the last 16 years indicates a change in the attitude of the State of Israel toward compensation. The process that eventually led to recognition of most Libyans and Tunisians was lengthy and took place in stages. In this respect, they were no different from other communities. A patchwork, as colleague Avital well defined this yesterday. This process was affected by court ruling from the 90s that led to the recognition of new ground for eligibility, such as certain types of deportation and curfew in Bulgaria and Romania. In the absence of any initiative by the legislators or government, these rulings are a manifestation of legal activism inspired by the 1992 Law of Human Dignity and Liberty. Against the background of important social process, the attitude of the court is, in my opinion, an important factor that paved the way for subsequent changes in the attitude of state authorities toward the issue of compensation for Holocaust survivors. Finally, I would like to thank my colleagues, expert scholars who contributed of their knowledge and took part on both sides in this important public debate. Thank you for your attention.
Thank you very much, Meir. I was not requested to give advice for the legal procedures, but as Daphne Barak said, historians should say their word. I have said my word on this. The Farhud definitely does not belong to the Shoah. Here's a question of another question of definition. What exactly is the Shoah? And also what happened in Iraq. It's not in Iraq, it's in Baghdad only. So they try to expand it. And there are some recent studies on the history of Iraqi Jews by Orit Bashkin and Riva Simon. And if you read them, you'll see that this is actually exaggeration. But as you said, it has to do with the will to be included in the major event of modern Jewish history, and that's the Shoah. And so it will raise the status of these people, and the public fight is going on. It has not finished. We'll now hear the last paper by Blandine Landau, who was originally trained as an art historian and a museum curator, but she turned to research on the Aryanization of Jewish property after conducting doctoral studies on the history of the art market, and that was Duke University, USA, and Université de Lyon in France. In 2020, she started a new PhD focusing on the disposition of people considered as Jews in Luxembourg during World War II under the joint direction of Professor Andreas Vickers for the Center for Contemporary and Digital History at the University of Luxembourg and Professor Bakouche of the School for Higher Social Studies in Paris. She's also part of the digital memory of the Shoah in Luxembourg, and interestingly, in recent years, research on the Shoah in Luxembourg is suddenly growing after many years of silence. So her topic will be local context and long-term echoes of the Luxembourg Agreement of 1952 in the Grand Duchy of Luxembourg. Please.
First of all, please allow me to thank the Goldstein-Goren Diaspora Research Center, the Conference on the Jewish Material Claims Against Germany, and Yad Vashem for organizing these highly stimulating 3 days. I would also like to thank my brilliant colleagues for all the really stimulating talks we had, and especially those who, in their presentation, mentioned the issues of legal definition and compensation of victims, setting a frame in which I would like to set this presentation. Over the last 3 days, we discussed the Luxembourg Agreement, the discussions that led to it, its consequences. But what about the small country that gave its name to the agreement itself? if the signature of the agreement marked the return of Germany on the international scene and allowed for the economic growth of Israel and the development of institutions devoted to the memory of victims of the Shoah, what was its impact in Luxembourg? Or rather, did it have an impact in 1952 and over the last 70 years? And if so, in which way? This is what I will present to you today, covering the following topics. First of all, the absence of the Jewish minority in post-war discussions, then the slow recognition of the specificity of their suffering, and finally, the recent acknowledgement of its responsibility by the Great Duchy and its consequences. But before to get to the context of the agreement itself, I need to give you a quick overview of the situation of the Jewish minority before, during, and immediately after World War II. The latest estimates allow us to think that at its top, before 1940, the Jewish minority in Luxembourg counted about 5,000 people for a global population of about 300,000 inhabitants. It mostly consisted in people who did not have Luxembourgish citizenship, for the main part from Germany, as you can see here. Between May 1940 and May 1945, almost all, and I do mean almost all, of these 5,000 people left the country in a context of growing persecution. Hundreds were deported from Luxembourg to concentration camps and assassination centers. Others were caught in France or in Belgium. Some managed to flee to Switzerland, Spain, Portugal, or further away, especially to the Americas. Then, after the liberations in February 1945, only a few hundred members of the previously flourishing community came back. More than one-third had disappeared during the war. Some had chosen to stay in the countries where they had lived in exile and sometimes settled, while some had asked to move back to Luxembourg and had been denied the right to re-entry. This is the context in which my presentation starts, with few survivors, no synagogue, no archives, and very little information regarding those who had disappeared. So how would the situation of the Jewish minority be acknowledged by the Luxembourgish society during the post-war period is what we're going to see first. Originally, the idea seems to have been to set back things as they were before the war, with Prime Minister Pierre Dupont stating in June 1944, I will translate the quote that you see here, "There can be no controversy on this topic. The foreign Jews who had their home in Luxembourg before the moment they had to flee from the Nazi threat can, once the war is over, come back and settle again in Luxembourg." The reality was quite different. In November 1944 already, the reinstated government of Luxembourg reminded its contacts that when conducting exchanges of prisoners, the, quote, few hundreds of deportees of Israelite religion end quote, kept in Litzmannstadt and Theresienstadt should not have the priority over the, quote, 30,000 compatriots interned or deported. And I have to specify here that in Luxembourg at the time, deported was a word used for umgesiedelten, which means the people who had been transferred to live in the borderlands of the Reich to become good Aryans, so not the Jews. The leading principle seemed to have been not to give a preferential treatment to one group of victims over another, a decision that did not take the specificities of the situation of the Jewish persecution into account. This attitude echoed in the legislation, where xenophobic measures were taken to limit the influx of returning residents of foreign nationalities. Members of the police maintained some of the habits they had taken during the occupation to either refuse entry or lead out people who had lived in Luxembourg and wanted to come back to their homes, as you can see here with the example of the Grossvogel family, who then moved to Israel. In the post-war context, marked by the epuration and post-war processes, the persecution of the Jews was barely mentioned. What mattered was whether you had had a patriotic or anti-patriotic behavior. Participating to the persecution or to the economic collaboration did not seem to be an issue in itself, as you see on the slide here with the example of this architect who conducted expertises on buildings that belonged to the Jews for them to be sold. And if at first all the victims seemed to be acknowledged in the same way, some groups soon received a better audience, I would say. Luxembourg needed to present itself as a resisting nation, so resistance groups and political prisoners were put forward in the post-war build-up national narrative. The about 12,000 forced recruits and workers, all Luxembourgers, also had a massive social and political impact. So in comparison, what weight could the 870 Jews, 383 of them foreigners, have? These are the numbers from the 1947 census. This discrepancy is obvious when you look at the law of February 25, 1950 regarding war damages. Racial persecution is not a criteria of eligibility, which de facto excluded people considered as Jews from any retribution. In this context, it is in this context that on September 29, 1952, on neutral ground, the agreement between the Federal Republic of Germany and Israel and the agreements between the Federal Republic of Germany and the International Claims Conference were signed. Both the principle of the negotiations leading to the agreement and their outcome were, as we saw, extremely important, but as reflected as the only article written in a Luxembourgish newspaper that you see here, they mostly met with indifference. The impact of the agreement with the Claims Conference, for instance, and its possible impact of the Jews in Luxembourg, on the Jews in Luxembourg could have been underlined, but reaching this level of awareness in the Great Duchy would take time and a little help. Things hadn't evolved in 1956 when the country joined France, Belgium, the Netherlands, Norway, Denmark, and Greece for the so-called Démarche commune, a common request for war damages from Western Germany. To be eligible, victims of National Socialism, that's the term that was defined, victims of National Socialism, had to be legally defined as such, and the definitions varied from one country to another. In Luxembourg, it meant that to be eligible, you would need to have been a member of the resistance or of the forced recruits, who are indeed the only two groups who are mentioned in the application law of February 25, 1967. This choice did not take into account the remarks of the representatives of the Jewish victims, such as the president of the consistory of Luxembourg, who in 1960 stressed to the ministers in charge that based on the restrictive criteria of the treaty, almost all the, quote, Luxembourgish citizens of Israelite confession, and then again, Luxembourgish citizens, so of course not the foreigners. So all these people would be excluded from compensation, and I'm going to translate part of the quote that you have here. So these restrictive criteria would take the indemnity away from the goal it was specifically aiming at. As you would guess, the law was poorly received among the community, and not only in Luxembourg, as you see in this excerpt from the speech given by Albert Nussbaum, who was the former president of the Israelite consistory in Luxembourg, who gave this talk to the Luxembourgish Jewish Society in New York in 1968. This lack of acknowledgement, while the Eichmann process brought more awareness to the specificity of the Judeocide, led to the creation in 1965 to the Comité des Rescapés d'Auschwitz, the Committee of the Survivors of Auschwitz, which was the first group in Luxembourg specifically dedicated to the memory of the persecution of the Jews in the Great Duchy. But except for their work, globally, until the 1970s, the situation was similar to the one Frank Bosch described in Germany, mostly marked by the indifference of the general population. Among survivors, the situation was comparable to the one Muriel Pichon described in France. Quote, in the years following the war, there was an offset between national memory and memory of the Jews. A lived and felt offset, sometimes expressed, but never a claim for specificity. End quote. Then, slowly, things started to change. Shortly after the publication in 1973 of Robert O. Paxton's La France de Vichy, and I chose the French translation on purpose, so this book that shook the French national narrative to its core by revealing the role of the French state in the persecution of the Jews, the Luxembourgish journalist Paul Cerf, coming from a Jewish family, published Longtemps j'aurai mémoire, For Long I Will Remember. The book was the first in Luxembourg to describe the persecution of the Jews in the Great Duchy, with references to detailed sources and testimonies, stating, among other ideas, that, quote, after the liberation, no Luxembourger had to answer in court for the crimes and misdemeanors committed against the Jews, end quote. This book was followed in 1986 by L'Étoile Juive au Luxembourg, the Jewish Star in Luxembourg, prefaced by Serge Klasfeld, in which Cerf gave a more detailed account of resistance actions from Jewish individuals and the effects of the persecution. The goal was to fight the commonly spread idea that no Jew had stood up against Nazism and that their deportation was not worse than the one of forced recruits and displaced people. As an answer to the recurring request for lists of victims from the Luxembourgish authorities, it also included the first published lists of Jewish victims from Luxembourg and deportees from Luxembourg, France, and Belgium. The year before, historian Paul Dostert had published his doctoral dissertation, which was the first academic work questioning the role of the Luxembourgish authorities and the general population during World War II, based on archival research including German sources, which was really new in Luxembourg. It was followed by an article by historian and archivist Serge Hofmann about the rise of xenophobia and anti-Semitism in Luxembourg in the 1930s. An interest for the topic also started to grow outside the Jewish minority, thanks to movies and TV shows such as the TV series Holocaust, which aired in Luxembourg, in Germany, in 1979. But this did not lead to political or legal recognition. For, at the same time, forced recruits and workers were legally acknowledged as, quote, victims of National Socialism. Remember the category that I was referring to before. So they were recognized as such in Luxembourg by the law of June 12, 1981. This was officially presented as, quote, the end of a moral and material discrimination between the different categories of victims of World War II, end quote. Whilst the government insisted that the Jewish victims still did not fall under the legal frame of the 1950s law defining victims that I mentioned earlier. Then, thanks to the relentless fight of brave individuals, local and international organizations, especially the ones born from the Luxembourg Agreement, things evolved. After the fall of the Berlin Wall, access to hidden archival sources helped renew the perspective on the Holocaust. Revelations and affairs, like the Mahlo affair, led to international conferences in London for Nazi gold in 1997, in Washington for confiscated art in 1998. The Claims Conference and the World Jewish Restitution Organization were major actors in these conferences, helping the international community face these complex issues with major international and national impacts. Following a groundbreaking speech from President Jacques Chirac acknowledging France's responsibility in the persecution of the Jews in 1995, in 1997, in France, a commission was missioned from experts to evaluate the impact of the spoliation and the remaining related questions. Similar commissions were created in Belgium the same year and also in the Netherlands. It took a little longer in Luxembourg. At first, the government of the Great Duchy did not see the point of setting a commission focusing on the dispossession of the Jews in Luxembourg. But thanks to the actions of Representative Ben Fayot in 2001, I will translate the very long name of the commission, the Special Commission for the Study of the Spoliations of Jewish Goods in Luxembourg during the years of war 1940-1945. So this commission was created in 2001. This was a turning point for the recognition of the persecution of the Jews in Luxembourg. Many aspects were missing from their final reports, though, from an in-depth analysis of the Jewish assets held by banking companies and insurances, to the study of the possible involvement of the Luxembourgers in the persecution. In its report, the Commission actually stressed that the Luxembourgish authorities held no responsibility there, but also indicated that some criteria used for the attribution of war damages, such as citizenship, were, quote, difficult to accept. And that was not the only aspect that, from academics to associations of victims, was indeed difficult to accept. This led historian Serge Hoffman, that I mentioned before, to publish an open letter to the Prime Minister on September 19, 2012, asking for light to be shed on the extent of the collaboration of Luxembourgish authorities with Germany. His initiative was supported by Representative Ben Fayot, that I also mentioned before, through a parliamentary question, and by historian Denis Couteau, who published an article with lists of Jewish pupils excluded from schools in September 1940 by the Luxembourgish administration. Then Prime Minister Jean-Claude Juncker asked for research to be led on the collaboration of Luxembourgish authorities. Historian Vincent Artuzeau was missioned to conduct this research, and his report, that you see here, was debated in the parliament in January 2016. It led both the parliament and the government to officially acknowledge the suffering of the Jewish population and apologize to the Jewish community in Luxembourg. In 2018, following the prescriptions of the Special Commission for the Study of the Spoliations, national memorials were finally set in the public space, including a monument to the memory of the victims of the Shoah, which was inaugurated in the center of Luxembourg City on June 17, 2018. A foundation for the memory of the Shoah was also created to support projects such as the creation of the digital memorial of the victims of the Shoah, led by C2DH University of Luxembourg. A major point of tension remained, though, the, quote, unresolved questions linked to the Aryanization of Jewish property. On January 27, 2021, an agreement was signed by the representatives of the Luxembourgish government and the Israelite Consistory of Luxembourg, co-signed by the representative of the World Jewish Restitution Organization in Europe and the president of the Luxembourgish Foundation for the Memory of the Shoah. Through this agreement, the state of Luxembourg committed itself, among other things, to supporting survivors of the Shoah and to support research conducted on the dispossession, with focus groups working on bank accounts, insurances, and provenance research. It is still too early to measure the consequences of this research, but 70 years after the agreement between Western Germany and Israel, it shows that the case is definitely not closed and that the grounding missions of structures such as the claims and the WGRO are still very relevant today. In conclusion, the relationship of Luxembourg with its Jewish minority has been a long and tortuous one. The signature of the Luxembourg Agreement in 1952 started a new dynamic, which, thanks to the work of the claims, the WGRO, and committed local actors, also reached Luxembourg. Facing the past is difficult. Conducting research on this topic is difficult. But this is definitely not a reason to stop. For, as Emily Dickinson famously wrote, if your nerve deny you, go above your nerve. I thank you very much for your attention.
Thank you very much for this paper. Just a week ago, I got a request from somebody who is embarking on, from Luxembourg, was embarking also on a study on a PhD on Luxembourg. Luxembourg, I think, though being a minuscule example, is very interesting. One of the things that is striking in Luxembourg is the 15th and the 16th of October 1941, because on the 15th of October 1941, the last train to Portugal left with people from Brunne, and the next day the train left to Lodz. And so you have in one day a split between being able to leave and then experience the later lot. So we'll proceed now, as usual, to questions from the audience. José.
Yeah, I have questions to all the speakers. First, a question to Wesley Fisher and Ovidio Krianga. You spoke about the division between the funds allocated to individual compensation and cultural reconstruction, and you kind of mentioned that the dispute between Nahum Goldman and Shaul Kagan. That seems kind of informal. What kind of structures are in place today to decide on this internal division of allocation of funds within the claims conference? I mean, how is this division actually done? So, especially to Ovidio Krianga, you mentioned the hardship fund, and the name, I wonder whether you consider it appropriate. I mean, 2,500 euro is better than nothing, but is it really hardship that is being relieved by it, or does it not fit more closely into the category of symbolic compensation? I wonder what your views are on this. I have about 57 questions to Meir Bnaya, but I'm not going to ask all of them here. This is a fascinating topic that I'm also working on. So I just wonder, you mentioned a kind of timeline of Tunisian Jews, submitting the claims already in '96, and other groups coming later. Can you explain this timeline? I mean, why did one group start to submit claims already in '96, others in 2012, and so on? I mean, can you explain how it comes that they don't submit at the same time? Who comes first? Who comes second? I mean, how do you explain this kind of a timeline that you were speaking about? Then I just would like to know, what is an administrative decision? I understand there is such a thing. I mean, that your department does take administrative decisions, but how are they taken? I mean, how can you decide that you suddenly compensate a certain group without a legal process, just by administrative decision? It's a very curious and fascinating issue. And I wonder about the Libyans. The Libyans, you said, were recognized already in '65 because of Jado. The Libyans already tried to get into the compensation process in the 1950s. I rely here on secondary sources, but as far as I understand, and this may also go to the claims conference's question, the claims conference didn't really want to take up their claims. And so they went directly to Adenauer. Can you say more on this, on the recognition of Jado in 1965 and how it came about, and kind of which side? I mean, this is not something that just happens in 1965. So, what was the struggle? And
means citizens of Israel. When you are talking about Jews from Libya, citizens of Israel.
Israeli citizens.
Yes. Absolutely. I rely on secondary sources. This is not research I have done. So it may be wrong, but this is what I read. But this is a question, so it's not a statement I'm making. This is the question. Then you mentioned 1984 as a date. Yes, 1984 is a date in which many claims were submitted by Libyans. This is the last question. I'm surprised about 1984 because in 1984 there was no law under which you could submit claims. The Israeli law closed in the end of 1960 and reopened in 1995. So where did they submit the claims in 1984? Was it to the hardship fund? I'm just wondering, I don't know what you were referring to a massive increase in claims submitted by Libyan. I don't know under what law they would submit that at that date. Okay. And I forgot about Luxembourg. I don't want to discriminate against you. You said racial discrimination or racial persecution was not a ground for compensation. I wonder then what was.
Thank you. I have a request and a comment to Wesley and a question to Brandine. Wesley, first of all, thank you for the talk. My request is from everyone, if we could spend maybe 3 minutes listening to the end of the presentation about communal property, which was something I would have loved to hear. And my comment about the auctions specifically that you mentioned in the beginning of your presentation, So first of all, I wanted to mention the IRO auctions of 1947 and 48 of Jewish property from the gold train, and also which were held prior to the auctions you mentioned. And secondly, auctions of heirless cultural property that arrived to the Jewish Museum in New York, which was a major part of my personal research. Actually, the research showed that these auctions never took place and they were replaced by what they called private sales. And I personally went through all of the sale records of these so-called personal sales to different dealers in New York. So happy to share that later if you want to compare that with the information. And to Blandine, thank you for adding to the conversation. I think it's a crucial part to add. So first of all, thank you. And secondly, it's more of a methodological question. Which archives are you using and where can you find the information? And also maybe another question, sorry about that, about the different, if you're looking at different types of property, like how is this going to develop and what are your findings showing? Thank you.
And yeah, Aaron.
The outcome of our discussions here over the 3 days leads me to a certain thought, which I would like to present to the panel. It seems to me that the logic for the Israeli government paying pensions to Holocaust survivors, that is an outcome of the Luxembourg Agreement, where the German delegation did an excellent job negotiating for Germany, leads me to the thought that perhaps the Israeli government should also pay Israeli citizens restitution of property. Because let's go back to the basics. First, the German delegation refused to pay for East Germany. Second, at the last moment, the German delegation said, we will not pay for pensions to Holocaust survivors who are in Israel by 1953. And it was not just a saying, it was take it or leave it. If you don't agree, no reparations agreement. And Israel had no choice but agreed. So this logic leads me to the next step, saying, if the Israeli government is giving up on this and giving up on this and paying for this, why shouldn't the Israeli government pay also for everyone? To everyone and for especially now it's a big issue is the restitution of property. What do you think?
Ronnie?
I want to say something. I want to say something not as a researcher. Excuse me. Not as a researcher, but as a citizen of the State of Israel. That I don't feel comfortable that old people need to say that they're Holocaust survivors in order to get support. That the state cannot recognize the suffering of people who were not part in the Shoah, people who suffered during the Farud. I have a family, my wife is from Iraq. I know that what her parents suffered. And the fact that the Jews need to say that we are part, from time to time I'm here, people say I'm a Holocaust survivor. And I'm not sure that they are really a Holocaust survivor, but they say that they are Holocaust survivor because they know that, or they think that Holocaust survivor treated much better than others. So I'm just saying, as a citizen of Israel, I feel really uncomfortable about this situation today.
Gideon.
Thank you. I also have a question to Wesley and maybe also to Ovi, because it's kind of very much relates to the work of the Claims Conference. So first of all, I'm interested about this division 40-40 Israel United States, because there were also non-Zionist organization members of the Claims Conference and how they felt about that. And the other thing is that you talked about cultural reconstruction, but I assume also that it also includes religious revival. So maybe you can say something about the support of the Claims Conference of the yeshiva world, because I know that, for instance, the Satmars and all kinds of these types of groups also claimed and asked for support from the Claims Conference.
Okay, I think we can now. There is.
Thank you. I have a question to Meir, because what you said is strongly connected to Ovi's hardship fund story. I take the Tunisians as an example. Tunisian hardship fund applications arrived at the Claims Conference immediately in the early 80s. And the Claims Conference has to decide what to do with them. And in 85, they decided the forced laborers for the German Wehrmacht can get a hardship fund payment. So we have 1985, the beginning of the payments of Claims Conference money, hardship fund money to the Tunisians. So my question is, are the dates, it's connected to what we heard before, is there a connection between the Claims Conference payments and the hardship fund to North Africans to the Israeli payments to North Africans? It's unclear to me, I have to say. So maybe you can say something about that.
There's another question? Or no? No. Okay, so we'll proceed to from the Q to the A. Let's start with Ovi. We'll do it.
Thank you. Sorry. Thank you very much for this excellent questions and comments and observations. I would just simply respond to Professor Brunner here first and leave the question on the process of allocation to my boss and more senior scholar who is part of the allocation committee, who sit down and discuss how money is divided and where. I would simply say that from the 1975 onward, you can see in the trail of archival documents regarding exchanges between various leaders, particularly Saul Keegan, Ernst Katzenstein, and others, that the hardship fund payment will, regardless of the sum that they will land on ultimately, will be symbolic. That was always understood that that's going to be the case. However, something that is worth, I think, pointing out and connects with a number of discussions that happened and observations that happened over the last few days on this issue of symbolic payment. The Claims Conference practice and the Claims Conferences, starting with Saul Keegan's kind of attitude, was that each compensation program is a journey. And so even if we start on a symbolic level today, we will have a chance to make progress on that in the years to come. And so it was the conviction that really drove all of the negotiators to negotiate. Because even if it's really small today, we'll have a chance to enlarge this payment, enlarge the criteria. If it was up to them, every payment would be a lot more. But because they're negotiating, you have to start somewhere and then you build from there. So yes, symbolic, but with very practical kind of terms in mind, what this could do for the claimants.
In terms of the allocations internally at the Claims Conference, you can read about the structure on the website. This is quite a complex structure, but it basically is the 23 organizations that formed the Claims Conference originally still are all there, but they've been augmented by several organizations that represent more directly the Jews of the post-communist countries. Beyond that, there are in persona, they're ad persona, people who are added to the general board of directors. It's a large board of directors. The board of directors has under it an allocations committee, which then proceeds to ratify or to disagree with the suggestions that are made by staff and also by professional committees, the professional scholarly committees for education, for research, for documentation, for film, but then also a large number of things in regard to social welfare matters. And the major monies, of course, are all in the social welfare aspects. For years, the monies that were used were monies that were coming from the successor organization of East Germany in regard to these German matters. And those monies in recent years have been diminishing. And that has now led to a contract recently signed between the German Finance Ministry, the EWZ Foundation, and the Claims Conference in regard to monies that are not only for the survivors and the like, but also monies that are then there for education, for documentation, research, and the like. For years, the percentage was 20% of the money from the successor organization would go from monies from the successor organization, not all the monies that were coming from the German government, would go to issues of education, research documentation, and so on. This was fought bitterly by some of the representatives of the survivor organizations. There was in particular one gentleman who every time there was a meeting would raise the fact that this money was needed by the survivors and would not go along with it. Eventually, this was changed by the fact that there was an enormous input of monies from Germany as a result of the negotiations with the German government that led to home care payments, very large amounts for home care payments, as a result of which the amount of money in percentage terms that was going to to education and documentation research diminished greatly, so that now it's really quite a small percentage. It's still a lot of money, but it's a very small percentage. So that's how this is dealt with, but it also is determined, of course, by how much money can be negotiated each year, and that goes on. Those negotiations for the last decade have been led by Stuart Eisenstadt, but there are many others involved. In regard to the other questions, so just a couple of things. First of all, the JCR question, it's the 40-40, 40% to Israel, 40% to the United States, and 20% elsewhere. That has to do with the JCR. That was not a policy of the Claims Conference. It was very specifically the JCR, and that's why I started the whole thing by saying there's confusion over this because people think that that's what the Claims Conference has done, but it's not the case, and it wasn't the case in the first years of the Claims Conference. That's the matter. So far as payments by Israel for property are concerned, that's up to the Israelis and the government. But I have to say that minimum income is discussed by many countries, and maybe that in fact is a reasonable thing to do. Israel is a wealthy country and it could indeed perhaps afford to do that. So far as the auction at the Jewish Museum is concerned, I have to say I'm not a specialist on the auction. You may be, so but I have to say that it doesn't change the basic point, which is that in fact the monies these things were sold, and there is a question about the selling of items. Ever since that Mauerbach auction, there has been a change of policy, and the policy is not stated publicly. You won't find it on the website. It's not stated publicly, but in fact, internally, it's the notion that although the Claims Conference does sell unclaimed heirless real estate, it does not sell unclaimed heirless artworks and the like, and said there's an attempt to find the original people and such, but not that many things actually belong, quote unquote, belong or possessed by the by the claims conference. It was just the artworks from the GDR. But there is an issue that is larger than that, of course, that we're involved in. I'm happy to do the extra matter, but that perhaps we should do a little later, and it's actually it's important.
Okay, so thank you. The question regarding the fact that the racial persecution was not a ground for compensation. So in the 1950s law, the material destruction, like for any other citizen, were like a possibility to get some compensation, but only political persecution, so people who had been in the resistance, for instance, were entitled to specific extra treatment, if I may say. And there was a whole system of honorary mentions for if you had had a patriotic behavior, and of course, discarded like allowance for pensions, for instance, if you had had an unpatriotic behavior. That's what was special about this. But the other categories of victims were not acknowledged. For the archives that I'm using and the method, so my method is a mixture of microhistory and something that comes from a group that was developed by a group led by Sarah Gainsberger and Isabelle Bacouche, who are my directresses at the EHSS. The group is known as the Connu à cette adresse, and the idea is to use ordinary archives. That is not just archives from the persecution, which of course can shed a light on what Jews had before the war, but it's very limited because it's only from the German perspective. So for instance, in Luxembourg, if I were to base my research only on that, I would have the Declaration of the Wealth from December 1940, but they were only filled in by the people who were there in Luxembourg in December 1940, so there's a whole population missing. And so the idea for me is first to see what the people who lived in Luxembourg between 1935 and 1940 actually had. So for that, the best option would have been to go to taxation reports, but in Luxembourg, they're protected during 100 years by the law. So I have to be creative and look for other ways, which I will not say now because I might not have access to the archives afterwards. So I'm finding other ways, but there are many sources that you can use for that. So for instance, school registries that are a great indication to know whether when a family moves in, because sometimes the first thing that they do is register the child at school. So then you have the dates when they arrive and the date where they live. Also, basic registration at the city hall. You know, when you move somewhere, you register yourself at the city hall. So all these kind of archives, it's all about cross-referencing and using different things, not the way that they were sometimes originally meant, but to see what the people in the area I'm studying had before 1940 and how it was taken from them, either because when they were still there or not, between 1940 and 1945. So that's the first part of my research. The other part is focusing on the art pieces. So the idea with these two sides is, first of all, to have a more global view of the Jewish population in Luxembourg, or it could be in other places, but when you only focus on spoliation as legally defined, you tend to only see, for instance, people who owned houses and not the ones who rented, which is also something I want to see, because it gives you a skewed view of only the richest part of this population. And so that's why I want to focus first on having a complete picture of the situation and then move to the art pieces, which of course I'm interested in because that was my original training. And it's also because in Luxembourg, there was this widely spread idea that is also still in the report from 2009, that there were no Rothschilds in Luxembourg. So no collectors, no art dealers, no etc. Which, I mean, I should tease you and say you will see in my dissertation whether it's true or not, but spoiler alert, is not true. So, that's how I'm researching.
Hey, your turn.
Thank you for your questions. For this lecture, I made a little research looking for the demands of the different communities in order to give you a notion when the demands were filed. I leave to you to explain why it was an increasing amount of demands of people from Libya in the 80s. It seemed to me that this is related to the increasing awareness of these groups to demand the state of Israel in basis of the law. This don't mean that there were not the demands before. This is just an increasing tendency during the 80s. I thought that it could be interesting for you to give you a notion about the interaction between demands, rulings, and decisions or administrative decisions, and to give you a notion of the time that passed from the demands to the decision of the executive government, of the government. Especially or specifically about the Libyans, I saw with my own eyes as a festellum bescheid of one people from Jado, from Libya, from the 60s. I don't remember specifically the time now, the date, but I am sure that this is an important precedent that prepare the decision to give recognition to the Libyans, because as I try to explain, Libyan was under the government of Italians, not under the government of Germany. And this precedent was very important for to take a decision. Just to compare, there is now a dispute in the courts from people from Italy that came to Israel in the after the legislation of Mussolini from 38, and they demand Israel to have benefits from the law, saying that Israel should pay for their abandonment, leaving Italy. The position of Israel is that Italy, this is based on expert opinions of historians here in also in Italy. It was that Mussolini was totally independent in his decision and to legislate laws against the Jews in Italy. It's the only one case that we have now in the courts, because today's tendency to be more liberal and to reaching out and even in the field of the demands. But this was not the case in the 90s or in the 80s. People not always know that there is a possibility to demand, and that's the reason I thought that it's important to see when you can see in the database of the authority a number more numerous of demands to see when people decided to do it. Thank you for your question. The answer is very short. There is no connection between the hardship fund and the decision in Israel to about the Tunisians or even the Libyans.
Okay, thank you very much. We are now precisely at 7 o'clock, the set end of this session. So what I suggest to Wesley, perhaps copy-paste your conclusions and it will be disseminated by the office of this conference, by Ronnie, to the participants, and they will have, if they cannot fall asleep at night, they can read it before or something. Or another point, what I propose, I was thinking about this last question which you mentioned, but I think there is another dimension that maybe should be taken into account, and that is the fact that since the mid-1970s in Israel, the history of the Jews in Islamic countries is promoted. So in 1975, you have the establishment in the Ministry of Education of the Moreshet Yadut HaMizrach, the legacy of Oriental Jewry, and since 1980 is the compulsory unit on the Holocaust in the educational system, in history studies. And in the first books, if I remember well, there is a mentioning of Libya, not of other countries, Libya and Tunisia. So that may have had an impact of what you said, the rising awareness of this aspect. And the other thing, the later ones, I think, has to do with the enormous higher profile of the Holocaust since the 1990s. Right? This has to do with other developments, but also in Israel, but not only. So I think that is important. Maybe regarding Libya, there is another thing that can be taken, should be researched, but that is the fact that some Libyan Jews were deported by the Italians first to Italy, and then when Germany entered in September 1943, they were, as British citizens, sent to Bergen-Belsen. And there they met other kinds. Yossi Sukari wrote a book about it, thinks that he is the first one to mention it. No, it was mentioned already in Dutch literature in the 1940s and so on. But here is something that the awareness of the fact that there were also Jews from Libya in the Shoah, right? In the public awareness may have played a role. So that is just to mention. One remark to Blandine, you mentioned that you called the Fünfbrunnen, Saint-Fontaine, a ghetto. I'm not sure. It was a concentration place, which is not identical with a ghetto. So that is another thing, but that is a short remark. We can discuss this issue. So we close this session, and we thank all the presenters for another fascinating presentation. And now it's my turn to conclude. Thank you. So I was asked by my co-organizers to say some concluding remarks, and I actually have to apologize for attending only last day. The explanation is that I attended another conference in Ottawa, and it just landed yesterday. And so it is quite audacious to wrap up a conference that I did not really attend. And only the last part of today. I was on the organizing committee and read the applications, and I received several inputs regarding former presentations here in the conference. So I'll do my best, and if I repeat things or say nonsense, you'll decide. What I have to emphasize that also that I'm not a scholar of compensation and restitution at all, but I was a recipient of compensation, even though I was born after the Shoah. That is because my parents died. And the Dutch compensation program, which the acronym is Mahlo, very significantly also and started to be promoted and developed since the end of the 1990s, made compensation also to children of survivors, the first generation. So I had some experience with filling in forms and that kind of things. So first of all, I want to acknowledge the very pleasant cooperation in the preparation of the conference. First of all, with Ronnie Stauber and his staff, and the Claims Conference and their staff in New York and Israel, and of course our staff at Yad Vashem. Some are here. And regarding, we had here about the distortion of names, right, of several people. My story is that when my first son was born and my wife was in the Soroka hospital, the nurse entered their room and said, "Who is here? Eichmann." And so that was before the computer age, so it was on a card, and that's what the nurse said. So there were almost 50 applications for this conference, which shows the interest in the topic. And the organizing committee had a difficult job to select and create a multifaceted conference that sheds light on the many aspects of the Luxembourg Agreement. But what I think is that the number of applications also emphasizes the fact that scholarship has recognized the importance of this agreement. And indeed, I would say that the Luxembourg Agreement and what was around it fits into a broader phenomenon of major developments resulting from the Shoah, international developments resulting from the Shoah, that had an effect on the entire Jewry and beyond that. The act of a perpetrator state compensating after atrocities individual victims of a perpetrator group not living in one country but scattered all over has become a kind of precedent and a paradigm for other cases of major lethal atrocities. And it is different from compensation agreements between states, a procedure that was developed around World War I. And also it's different from compensation of slave laborers, and also the Protocol 2 aspect of going beyond the living, the survivor, and dealing with memory and cultural loss. And this is an additional part of this larger phenomenon, which has the coining of the term and concept of genocide and ensuing United Nations Convention on the Prevention of Genocide in December 1948, and the issue of human rights and its international acceptance. So, two issues promoted by Jews as a consequence of the Shoah. So here we can see that Jewish affirmative action by individuals or organizations were path-breaking in infusing international politics with moral issues that are translated into internationally accepted legal terms and then having an effect on individuals. As some of you may know, one of my fields of interest is the monitoring of historiography on the Holocaust and how it developed. For my most recent publication on this issue several months ago, of the developments of Holocaust research, historiography. Since 1990, I asked the Yad Vashem Library to provide me with data about incoming publications about skipped one page here, about how many books arrived in the Yad Vashem library. The interesting thing that I got, that it turned out that since 2009, or between 2009 and 2020, scholarly books on the Holocaust that only came to the Yad Vashem library were close to 10,000. And there are beyond that an enormous number of articles in periodicals. This means that within the overall field that is by now called Holocaust studies, which for some is by itself a subfield of Holocaust and genocide studies, which can be discussed, but there are subdomains in which extensive research is carried out. I myself focus on research on the core period of 1933 through 1945 under the regime of Nazi Germany and its allies. But there is the subdomain of rescue policies and activities from the free world, the subdomain of the lot of survivors in the immediate post-war period, the subdomain of Holocaust commemoration, the subdomain of Holocaust public memory in various settings and via a host of venues, the subdomain of oral and written testimonies, their accuracy, their value, and their evolving status, the subdomain of Holocaust representation in literature, movies, and arts, and more. So it is an enormous field by now. And I think that this conference and the number of applications that were submitted prove that the topic of compensation and restitution has evolved into a vibrant subdomain of Holocaust studies too. In his introductory paper, Konstantin Goschler, who is a leading expert in this domain and also cooperated a lot with José, surveyed the historiography on this topic from its beginnings to the present moment, which shows this path of evolution into a real subdomain. The aspects that were analyzed in this conference went from the specific core of the event itself, the signing and around it and the negotiations before, to the broader circles of context and impact. We learn about the personalities that drove the process since the late phases of World War II, such as Nehemiah Robinson, and he was, of course, related to Jacob Robinson, who was also an important personality, about the question why the Netherlands was chosen as the place for negotiations and why they weren't concluded in Luxembourg, and what it still means for Luxembourg, as we just heard, about the public discussions, especially in Israel, around the agreement, which were not only political issues, but also issues of morals and honor and belonging. Can such enormous crimes be forgiven? And here's the issue that I heard was hotly discussed, and that is Wiedergutmachung, reconciliation in German, Shilumim in Hebrew, which is related to revenge, Linakam v'Shilem. The naming itself presenting the different interpretations or goals of signing such an agreement from both sides. And this has to, and there is the issue of definitions, of course. Just here, the end, what exactly is the Holocaust, right? We use the term, or Shoah. I think I know, I've written about it, but it is discussed. Where are the limits, and therefore also practically who is included and who know what is a Holocaust survivor, what is Jewish cultural property. And so here are terminological things that issues that have a practical consequence. We heard about international views of the agreements, about the material benefits for Israel as a state and the impact on the relations between Israel and West Germany, about the psychological aspects of complicated personal encounters between the German official system and the claimants, and of the impact of receiving compensation on the claimants, their self-perception and their social status, and on their descendants. And moreover, about the encounter between claimants and former Aryanizers, about the broadening of the circles of compensation and restitution to cultural property, and recently also this issue of North African and Iraqi Jews, and the issue of so-called open ghettos in Romania and Bulgaria, and the question of compensation in Bosnia and Herzegovina, and about the resonance of the agreements for cases of genocide in general. I was personally involved in the issue of open ghettos in Romania, and some of the people who were involved, Kai Wambach and Karen Heilig and Avi Weber, who isn't here at the moment, and Ovidio Koanga, where I had my contacts with them. We were approached in order to provide a definition which could help the parties get out from a deadlock. On the one hand, there was the will to compensate, but legally this was a problem. So at the end of 2018 and the beginning of 2019, I had talks with the present ambassador of Romania to Israel, Dr. Radu Ioanid, who was before that a researcher and head of the archives at the United States Holocaust Memorial Museum, and we concocted I would say, or provided a definition with the problem of being faithful to history and really to historical facts, and yet giving it a mantle, if I can say so, which is legally acceptable. And that is one of the problems of the historians here. I can give also another personal example that I told just to some of you here, that regarding the applications of the earlier period, there were some Amsterdam applicants to Germany for compensation within the law of 2002. And they were turned down on the basis of my book on the ghettos, that there was no ghetto in Amsterdam. And they wrote me and asked me to help them. And what I responded was that the law was enacted in 2002 before my book was published. And at that time, the Hilbergian understanding of what a ghetto is was the basis for the legislation. So they have to continue with Hilberg's approach, even though I disagree with Hilberg, and it helped them in the end. But it was a bit depressing to get this expert view, which said that I was the reason for them not getting compensation. An interesting point of the compensation process is the fact that actually for this purpose, and this is not my original comment, but was raised, for this purpose, the abstract notion of the Jewish people as a nation, which did not exist as a state during the event itself, had to be transformed into a feasible legal entity which could be negotiated with. And the Claims Conference was created for this purpose, and the State of Israel, which had come into being after the event, served also as a legal representative of the abstract entity. There is, of course, you can ask a question why the World Jewish Congress was not the body that would be the representative. They claim to be the representatives of the Jewish people, and Nahum Goldman presented himself during the period of the Shoah as the representative. He even met Mussolini, saying that he represents world Jewry, and anti-Semites believed him. But for negotiation, for compensation, it was not enough. Though he was afterwards, of course, involved in the compensation issues. I would like to emphasize here the importance of the documentation that has been assembled for and during the legal procedures which were needed in order to implement compensation and restitution. First of all, there are the applications with the individual histories of the applicants. Then there are the inquiries carried out by the officials of the institution who had to evaluate the applications. First and foremost in Germany, but also the claims conference and also in other countries where local schemes of compensation and restitution were and still are carried out. These include also studies by historians and other experts, which were written upon the request of these compensating authorities. And I myself was a member of the historians committee of the well-known Empire of Liechtenstein, with 11,000 inhabitants during this period. The bulk of documentation, which, as my colleague and by now also my friend Kai Wambach from the German Bundesfinanzministerium pointed out, will undergo procedure of organization, digitization, and indexing, and is an enormous source for research on the Holocaust period itself and its many aspects. It resembles, to a certain extent, the Bad Arolson, the International Tracing Service archive, in that this new archive was created after the end of the event and deals first of all with individuals. Similar projects will be carried out regarding the other compensation projects in other countries. This will make these materials much more easily accessible to scholars, but this will also be important for commemoration practices in general and for family research and commemoration in particular. Chile was mentioned here in this conference, but a lot of other countries were not represented. As having been born in the Netherlands, I regret that the Netherlands did not get an application, but there's also Belgium and more. The Netherlands, by the way, is an interesting case because the Dutch government didn't find it needed to, in their agreement with West Germany, which ended up in 1960, to relate to the specific fate of the Jews, of the Dutch Jews. So this came up in the 1990s, and constantly there are studies that reveal other things. I just recall one, and it has to do with compensation. I recall a master thesis which was written in 2011 at the University of Amsterdam, where the student found that the Amsterdam municipality demanded from returning survivors to pay property taxes for the 2 years that they had been away, and they paid. Right? They paid. They were Dutch Jews, so they paid. But and during this period, Dutch Nazis lived in their apartments. So you have here another story which relates to this. So altogether, I think it was a fascinating and enriching conference. And in order not to have this intellectual and meaningful treasure remain in a raw state, there is the intention to publish the proceedings. This will be the following and follow-up step, which will be demanding for the various parties involved. But I think the contents of this conference deserve to be published. So I thank you all again, and hope I have done my job.